Hey guys, you ready to get started on day 3? I'm gonna see if I can speed it up a little bit so that maybe we can get caught up to the live eventually because I think this is like 7 hours long. But the good news is we can skip through sidebars and lunch and breaks and all that good stuff. So it won't actually be 7 hours. So yesterday we had an independent ME that was called in to look at the case who said she absolutely, oh no, that was, yeah, she said she could have absolutely fallen on the rake more than once. And then we had a biomechanical engineer that I believe said the same thing. I still don't see how you fall onto a corn rake more than once. Come on, StreamYard. Yay, there it is. The mics are still off. They're talking, but it's very, very faint.
You have two hypotheses, fair?
Okay. It doesn't stay that quiet through the whole thing.
Yes, I did.
when you did that?
I don't believe so, unless Jill had documentation. I don't know.
Regarding the retention of evidence or the handling of evidence.
Yes.
If we can show you Exhibit 400, I believe this is the Delaware County Sheriff's Office policies and procedures that were tendered. Are you a lifelong resident of Delaware County?
No.
Where did you live before Delaware County?
Objection, no.
In the course of your experience in your law enforcement career, have you responded to farming accidents?
Yes.
When did you get involved in the investigation or learn about the death of Amy Mullins?
It would have been on the evening of November 10th, 2018.
Do you recall what time?
I came on shift at 5, and I believe around
The Mullis family gave you consent to examine the shed and the outbuildings.
yes. Gave consent to Deputy Thompson.
Did you talk to Sheriff Leclerc before you went to the farm?
I honestly don't recall if I did or not.
You're at the farm?
Yeah, if the phone records show it. Yes, I don't recall speaking with him.
So you don't recall what you talked about then?
I do not know. I didn't have access to all my reports for today, but I believe there would have been.
We'll try to look and see if we can find a report for you, but we'll move on, okay?
Okay.
Do you recall walking around the farmyard that night?
I wasn't walking around the farmyard, but I was walking around the red shed. Yes.
Okay. And did you see anything unusual?
You have to be more specific than that. What do you mean by unusual?
Well, you previously testified that you saw nothing unusual outside of the shed.
Correct.
Okay. And that included that you didn't notice any footprints or tracks. Is that still your recollection?
Correct, yes.
Did you see surveillance cameras while you were there November 10th?
No.
How wide was the door to get into the shed?
That I'm not sure. It wasn't very wide.
Did you take any photographs while you were there?
No.
Have you reviewed the photographs that Deputies Thompson and Holub took earlier in the day?
Yes.
If you could review those today.
I don't think so. If my memory serves me right, it's 2 to 3 feet wide, maybe.
Did you try to move the door?
I did not.
How wide was the aisle or the shed?
Again, I'm Marine, I believe.
You would defer to your reports that you had written.
Well, we took photographs of the scene.
Can we show Exhibit 311? Mr. Himstaff, I believe these are photographs taken by the Delaware County Sheriff's Office that you might be referring to. And they were tendered to me as a PDF that has a total of 20 pictures, so we'll have to scroll through. Is this the shed that you were referring to?
Yes.
And I'm sorry, no. The opening there is the door into.
Yes.
And then if we can go down to 19, I'm sorry. Do you know what this picture is showing us?
Yes.
What is it?
This is that alleyway. You come into the front door, and then when you immediately look left.
So this would depict, documented it?
Yes. Well, I did not. Does
Your sheriff's office, your investigation did?
Deputy Thompson did right after the one call.
Okay. How tall chemical totes? Because the picture doesn't go all the way up, right?
I believe they're too high because I don't think a third one stacked on top of that would clear the door clearance. I'm not
Was it
sure though.
above your head?
Yes.
And how tall are you?
Pretty short.
I think I'm gonna have to ask you to be a little more specific there.
Like 5'7".
Okay, so more than 6 feet?
Yes.
Were they taller than 7 feet?
Yes.
And then if we could go back up to 18. Page 18 of 311 for the record, I'm sorry. All right, Mr. Himstaff, what are we looking at here in the middle picture?
Yeah. So you go down that alley where you see the corn rake laying on the ground, and then you look immediately to your right, and that is displayed just down that walkway. That's the animal carrier crate.
And are these the only two places you can walk in that shed?
Yes.
And this is the documentation we have of how wide that area was as well.
Yes.
Did you walk down towards the pet carrier while you were in the shed?
Yes.
And did you make any observations about the carrier?
It's half pulled out on the shelf.
And what are we seeing there photo under the pet carrier?
Some grain augers.
What is a grain auger?
It augers grain.
For those of us that aren't farmers, what does that mean?
It means it moves the flow of grain through a tube.
And so the green and the black long cylinder objects we see in the pictures, those are the augers,
Yes.
and they move,
Well, they don't right there.
but they can move.
Yeah, they need to be inserted into a steel tube, and then a motor runs that and augers grain.
So there's a piece of them, like the circular, the rounded piece that moves around. Is that right?
No, this would just be like a smaller version would be like an ice auger.
I'm sorry, I still don't know what that is, but did you step on these augers?
No,
Did you touch them?
no,
Did you attempt to manipulate them or move them in any way?
no.
I want to show you Exhibit 269 now. When you're in that walkway, what's to the right of you?
The, like a throwaway wagon for hay?
Did you make any observations about what was in that wagon?
I don't recall.
Have you seen this photo before?
So there's tanks in the wagon.
I'm sorry, can you just repeat that?
There's tanks in the wagon.
Tanks?
Water, chemical tanks. The way, that's what this picture displays.
Do you also see a stuffed animal, a kid's toy?
Yes.
Counsel, just for the record, which exhibit is this? There's a number of stickers on it. This has been marked 269 for the purposes of the post-conviction. At trial, it was, I think, I can't read, 103. Thank you. Okay. You can take that down. Thank you. Mr. Himmelsath, did you talk with Todd or Tristan Mullis on November 10th?
No.
Did your other deputies in your office talk with them?
Yes.
Did you review their reports?
Yes.
And have you reviewed any body cam, video, or audio of those interviews?
No.
Did you also review a report written by the sheriff at the time, Mr. Leclerc?
Yes.
And I believe these have already been amended, but I'm referring to Exhibit 201 and 221 regarding Sheriff Leclerc's report and his deposition. Have you had an opportunity to review any of the depositions given in this matter?
Not of other people, no.
Okay. And then Exhibit 318 is Thompson's report and 264 is Holub's report. Do you recall whether your theory when you left the farm November 10th, what your theory was regarding how Ms. Mullis died?
I honestly didn't have a theory. I asked Deputy Thompson to walk me out there or take me out there and to describe what was explained to him. My next step after that was just the autopsy.
When did you learn there was going to be an autopsy?
I believe the next day.
When you were on the farm and in the shed, did you find anything that disproved the idea or the theory that Ms. Mullis had tripped and fallen?
No.
So you said a moment ago, I think, that the next day you learned there was going to be an autopsy. Do you remember who you learned that from?
I don't. I'm assuming
Do
that
you recall having conversations with Mr. Leclerc?
well, we had a lot of conversations. John and I did. He may have told me, or Mike Kroppel. I know Mike Kroppel with DCI was contacted. John had contacted him, so I may have heard it from Mike too.
So John or Mr. Leclerc was having conversations with the agent Krappel,
Yes.
and were you a part of those, or you just were told about them?
No, I wasn't a part of those. I was just told about it.
What else happened on November 11th?
November 11th.
Yes, the second day of your investigation.
I believe I came in and then I was briefed on the rest of it. We had conversations with DCI. I talked with John, and the next step was, I believe I had conversations with DCI, Special Agent Mike Kroppel, about attending the autopsy. That was the next thing I did, I believe, in the case.
Were you aware that Mike Kroppel told Leclerc to lock Todd into his story on the 10th?
Objection, hearsay.
Overruled.
I learned that from reviewing his report.
Do you recall any other investigative activities on the 11th?
Not offhand, no.
Do you know what happened next in the investigation?
I went to the autopsy.
Do you recall what date that was?
I don't.
If the autopsy report is dated November 12th, 2018, would you accept that?
Yes.
There's been testimony about another deputy we haven't talked about yet, Keith Rowley.
Yes.
Who's Keith?
Keith was a deputy at the sheriff's office during this time.
And is he no longer a deputy?
Correct, he retired.
What did you learn about Deputy Rowley as it related to your investigation?
We had learned that he had a previous affair before this incident with Amy Mullis.
What were the dates of that affair?
That I don't know. I was just told it was way before this incident, and that him and his wife were in a good place at the time that this incident occurred.
For clarity of the record, when this incident occurred, you're talking about Amy's death on November 10th?
Yes.
So there's been testimony about clearing Deputy Rowley as a suspect. Do you recall that?
Yes.
Were you involved in that?
Not directly, no.
Why was that?
That was between the sheriff and DCI.
So were you indirectly involved in that part of the investigation?
Yes,
What did you do?
I was in the office. I don't remember the date of it. I was in the office and Keith had came in to the office. I believe DCI was present within our office and Keith had asked to have a conversation with us quick and in the sheriff's office. And that's when he had disclosed to us that he had a previous affair with Amy. He was currently working that day. And then that was it. It was short. It was brief. I left it up to John and I think Mike Kroffel or John Turbot to address that.
Okay. Can you tell me a little bit about what a patrol log is?
Patrol log is a daily activity report. You write down calls for service, town time, in and out town time.
Do you complete one every day?
I do not.
Why not?
If I get busy, I just don't have time to fill one out.
Are you supposed to complete one every day?
I guess I've never been told that I had to, but we had an understanding that I don't fill out.
Is there another way or another avenue to see where a deputy was during patrol?
Yes.
What's that?
Well, there's actually, yes, we have two GPSs in our car, one called MACH and one called AVL. MACH. And then the other called AVL.
Were you using both of those in 2018?
Yes. No. Yes, we were, sorry, yes.
And we have some prior testimony that that could be reviewed by the sheriff, those
Correct.
GPS document. I don't know if I should call it a document. How would you describe it?
I've never accessed it. So I just know it's called AVL. It's a GPS in our car. When we start our car up, it activates. And then if we shut our car off, I don't know how long it stays on. We've never been told at that time what it consists of. We just know it's a GPS system and the sheriff had access to the platform to view it.
Did you retain any of that information in your file?
I did not.
Have you reviewed it since 2018?
Reviewed what?
The GPS information, data?
No, it's a platform and I was told that the software, there's a certain time period it's retained for and then it's gone. I don't know what the retention period is. Like I said, I didn't have access to that.
Okay. And we previously admitted exhibits 208 and 209, which are patrol logs. And if we'll pull those up for you here in a moment.
Council, for whatever it's worth, I show 208 is being admitted, but not 209. I don't know if you.
Yes, Your Honor, we were just
double check
conferring about that.
Okay.
And I believe we have an agreement to admit 209 as well, just so the record is clear.
Should I admit 209?
Yes, Your Honor.
All right, thank you, Mr. Wacky.
Mr. Himmelsath, on your screen, are you seeing exhibit 208? 209? I'm sorry, I can't see that. All right, 208. Have you seen this before?
Yes.
What is it?
Patrol log.
For who?
Keith Raleigh.
And this would have been in addition to the GPS information and data that the sheriff reviewed.
I don't know if we reviewed it, but we have it.
As far as information regarding where Raleigh was at the time that Amy Mullis was injured.
Yes.
And then if we can flip to 209. And scroll. So that Mr. Himmelsath can see the multiple pages. And when you are ready, you can let us know what these are.
Patrol log.
And do these in addition to Mr. Raleigh.
Yes.
Do you know if responded to the on November 10th, 2018 regarding Mrs. Mullis?
No.
And previously that Deputy Raleigh was nowhere near the Mullis residence?
Yes.
Is the basis for that statement the patrol log and the desk that we don't have to look at today?
It was told from the sheriff.
So you don't have any personal knowledge about how close Raleigh was to the Mullis farm?
No.
Do you know if you learned about Raleigh and reviewed the GPS data before autopsy or after?
I didn't review any of that. That wasn't my responsibility in this case.
Okay, but maybe I'm misunderstanding. You said you were in the office with the sheriff while he was reviewing it?
I was present after we briefly spoke to Keith and he had brought it up on his computer and started reviewing it. I don't believe I stayed in there the whole time. I had other avenues that I was working on and I just had asked him, I said, please preserve that when you're done. He finished obviously, and he had communicated with DCI that Keith was not near that location.
At that point, did you consider him cleared as a suspect?
I believe that's what John Turbot and Mike Kroffel and I had. I didn't specifically come out and say he's cleared. That was a determination from Mike and John.
Okay. And if you're clearing a suspect, does that mean that you've already decided there was a crime?
Yeah. Or a suspected crime.
Okay. Let's move on to the autopsy.
Okay.
You would have attended that at the medical examiner's office in Ankeny, is that right?
Yes.
Okay. What did you take with you when you went to the autopsy?
I took the corn rake and the clothing from Amy.
And have you seen those since the autopsy?
Yes,
When have you seen them?
during trial, several times, I guess. I don't know how many specific times.
Okay.
I brought some of the stuff up the other day in bags.
Right. It was here in the courtroom earlier this week.
Yes,
Have you looked at it in the evidence room as well
just once. Yes, that was post-trial.
during the post-conviction?
Yes.
What did you do with the corn rake during the autopsy?
I just brought it into the medical examiner's office and gave it to the technicians, Kelly Cruz.
And were you in the room with Mrs. Mullis's body?
Yes.
Did you make any observations about the medical examiner and her assistants in the corn rake?
No.
You didn't see them look at the corn rake?
Yeah, they reviewed the corn rake. Yeah.
Did you come to any conclusions during the autopsy about the corn rake?
I did not. I was there just solely for observation.
Did you complete a report about your observations?
No.
Do you think you should have completed a report?
Well, no, because the reason why we would take somebody to autopsy, that's for their determination.
What did you and Dr. Cruz talk about?
We didn't talk about much. She did her examination. I just stood by, and then we talked about her conclusion at the end about that it was, she was going to rule it a homicide, or it was a possible homicide.
Did you tell her how Ms. Mullis's body was found?
Yes. I gave her the description that was explained to me, yes.
And that was a description that Deputy Thompson and Holub had gotten from Todd and Tristan Mullis?
Correct.
So did you have any firsthand knowledge about how Ms. Mullis's body was found?
No, I did not talk to Todd or Tristan.
Before the autopsy, had you seen any reenactment of how Ms. Mullis's body was found?
No.
Is it possible you gave Dr. Cruz incorrect information about how the body was found?
I don't believe so. I stated exactly what was described to me by Deputy Thompson.
Can we pull up Thompson's? I want to just give you Exhibit 300 to review, which I believe is Deputy Thompson's report. Can you let me know if that is correct?
Yes,
Would you take a moment to review it and see if this is the information you had when you went to the autopsy?
it is.
And now I'm going to switch to Exhibit 217. Have you seen this before?
Yes.
And for the record, this is also, it's in the exhibits twice, 254, I think, as part of the medical examiner's photographs. Can you tell us what we're looking at here?
That'd be the inside of the Carhartt coat.
How many arrows are there?
4.
What the arrows are pointing to?
I believe they were pointing the coat.
Are you aware of any photographs with arrows from the other items of clothing, the sweatshirt or the t-shirt?
No, whatever photos we have would be maintained in our case file. Yes. Or at the medical examiner's file.
Okay. And so this was was this the information you got from Dr. Cruz at the end of the autopsy, that she found 4 holes in the coat?
What do you mean by got from her?
That she told you that you learned?
Objection calls for hearsay.
Overruled.
That was a while ago. I'm not sure. I know there's holes in the coat. I don't remember seeing them take this photograph, but yeah, there was holes in the coat.
Do you recall testifying previously in 2023 that Dr. Cruz told you there were 6 holes in the coat?
If that was my testimony, yes.
You would agree with that?
Yes.
And you would agree with me that this photo only demonstrates 4 holes?
There's 4 arrows. The lab techs must have taken that. Yes.
Okay, we can take it down. What did you do after the autopsy in your investigation? Not your personal life, I'm sorry.
Oh, yes. I made contact with John Turbin and Mike Roffel and just explained to them that this is a potential homicide investigation. And then we proceeded with.
Recall what action specifically you did, like which search warrant you drafted the 12th and November 16th?
I drafted quite a reference to the farm. And then we did an assortment of interviews. John and I split up people and performed interviews.
Who were you talking to?
Quite a list. I don't know them all off the top of my head, honestly. I don't know if there's 25 or 30 interviews.
I'm not trying to ask you for specific names, but could you characterize what type of people you were interviewing? Were they other law enforcement or lay witnesses, fact witnesses?
Just essentially, just lay witnesses. We would get information that somebody might know something. We'd go to them. We'd speak to them. and then we would just move on to the next.
Would these include friends or family of Mrs. Mullis?
Yes,
Colleagues or coworkers of Mrs. Mullis?
the swordsmiths, yes.
What did you learn during that time period?
To the 16th?
Yes.
I don't know. I don't recall.
Okay, that's okay. I'm sorry. I don't want you to.
I would have to review my interview summaries. The majority of that time frame, I believe I was preparing search warrants.
Were you reviewing interviews done by other officers or getting updates from them?
I'm sure during that course, yes.
Did you come to any conclusions before November 16th?
I don't remember.
Did you have a suspect November 16th?
What time?
The 12th
We had suspects.
on the
I don't know the dates.
when
I don't know. I don't remember what we did between the 12th and the 16th. But we would have had two suspects at that point.
who were they?
Would have been Jerry Frazier and Todd Mullis, to my recollection.
Okay, and so at that point, Raleigh was not a suspect. Is that my understanding? Is that right?
I don't know the date that the sheriff had told me about completing watching the AVL. I'm unaware of the sheriff's conversation with DCI.
If you testified in your 2023 deposition that you let Deputy Raleigh know he was clear November 14th, would you accept that?
Yes.
Why was Jerry Frazier a suspect?
I think we established there was communication between Amy and him.
Why was Todd a suspect?
During that time period,
Yes.
I'd have to review my reports on that.
You don't have any recollection or memory?
It came out through witness interviews, like with Terry Stainer. Through the course, we started hearing about relationship problems with Todd. John and I did.
Okay.
And at that point, I don't know the time frame on those, but
Do you recall Todd being interviewed on November 16th?
that probably would have been when John Turbid interviewed him. Yes.
Would you have been in the building?
Yes.
Did you listen or watch?
Not the whole time, briefly.
Did you talk with Agent Turbot before the interview?
Yes.
Were you aware that Turbot was going to accuse Todd of murdering Amy?
No.
Have you reviewed any of the recordings from that interview?
It was a long time ago, briefly.
If I tell you that Turbot did accuse Todd of murdering Amy in that interview, would you disagree with me?
I don't know what the context of the interview was.
Do you want me to try to find it and play it for you, or take time to review it?
Are you wanting me to agree to that?
I'm wanting to know if you disagree that Turbot told Todd or. Okay,
I don't know exactly what John had spoke to him about.
okay. And you haven't reviewed Turbot's depositions or trial testimony?
No.
His reports?
No.
If his reports and his audio and the video indicate he accused Mr. Mullis of murdering his wife November 16th,
Then that
would you accept that?
That would be accurate then, yes.
On November 16th, in your investigation, had you obtained any cell phone records of the victim or the suspects?
That I don't know. I forget the date that we actually executed the warrant at the house.
If I told you you executed the warrant after the interview with Mr. Mullis later on November 16th, would you agree?
Yes.
Were you there for that?
For the warrant?
Yes.
Yes.
Was Agent Turbot there?
Yes.
Was Mr. Mullis there?
Yes.
Was his sister Lynn White there?
There's a couple other deputies from our office. She may have been there at some point. I don't know.
Okay. Bob Saber, is he an attorney?
Yes.
Did you know he was an attorney when you went to the farm?
Yes, shortly afterwards.
Was he there for Mr. Mullis?
I don't know why I was there. I would assume he was there for Mr. Mullis, yeah.
What did you see as November 16th on that search warrant?
Electronics, and then yes.
And do you recall there being an iPad?
Yes,
And do you recall asking for a password?
I do, yes.
Do you recall testifying about Todd? And Todd consulted with Mr. Sabers and then gave you the password. Is that your recollection?
Yes,
Do you recall testifying at trial that Todd hesitated before giving you the password?
yes.
Do you think telling a jury that he hesitated had a bad connotation?
Objection, this is, it's an improper question. His opinion on what the impact on the jury was is not relevant.
Sustained.
I'll rephrase, Your Honor. What inference were you making when you said Todd hesitated?
I'm going to object again, Your Honor. This is still commenting on what the impact on the jury was. The record speaks for itself. The transcript's already in evidence.
Sustained.
Why did you say he hesitated? Thought process there.
Yeah, so I asked him for the password and he hesitated and then he consulted with his attorney. And then he gave me the password.
And you were wearing your body camera at that time?
Yes, it's documented by video.
Do you testify in the criminal trial in 2019 on the electronic? You're not certified in electronic device analysis.
The physical extracts, the digital imaging of the device, no.
And do you have any specific training on interpreting extractions?
We are provided a Cellbrite reader and we don't need to have a certification. The platform is very easily navigable and you can't all. So no law enforcement has that certification on the reader program. We are provided and he's certified on Cellbrite. We do the examiner and he provides the reader program to law enforcement.
Okay. But my question was, do you have any specific training on interpreting the extraction results?
On the reader, it's possible. But it's not reasonable in some other categories. So that's Todd, possible in certain categories. It's possible.
In addition to word crawling, during this post-conviction,
It did.
after you learned about Mr. Castle's examination and analysis,
I don't know what his analysis is.
you haven't reviewed that?
No.
You have reviewed parts of the post-conviction filing, though.
What do you mean by the filing?
Well, in your 2023 deposition in this post-conviction,
Just a few paragraphs. There was, to my knowledge, there was several filings, but I've only read a few paragraphs.
thank you for that clarification. Your deposition made it sound like you read everything.
No.
Were you aware that the iPad did not have cellular data in 2018?
Upon the time that we seized the iPad, I didn't know. I know the iPad is either cellular or Wi-Fi capable. I just seized the device and then gave it to Word Crawley. this is a hypothetical. But
Did
yes,
you do any investigation into where Todd Mullis was at the time you thought these searches were being done?
there's no way to know where he was. No,
Analyzed?
yes,
Are you aware of cell tower records from cell phones?
yes.
Are you saying you couldn't have used those to determine where Todd was?
I had asked Ward Crawley about that for the Cellbrite, about the location data, and he didn't provide me with anything.
Could you have talked to witnesses about the dates in question and tower records from cell phones?
Yes,
Are you saying you couldn't have used those to determine where Todd was?
I had asked Ward Crawley about that for the Cellbrite, about the location data, and he didn't provide me with anything.
Could you have talked to witnesses about the dates in question and
Yeah, good.
coming from a farming community, are you familiar with the time period the farmers
Weather dependent, spring and fall.
and have you ever seen someone in a field late into the night,
Yes,
early in the morning,
24 hours personally.
but at any time of the day?
Yeah, anytime of the day is possible, correct.
And spring would be planting season, is that fair?
Yes,
Is fall harvest?
yes,
Some of the searches that you attributed to Todd would have been occurring in spring or fall, right?
yes. Some of them were in May and some were in January.
Did you do any investigation into Todd's activities in May or January? Or what was the other month you said? I'm sorry.
May, well, there's several sections. Like Roman Gamble, he created a spreadsheet for the layout, so it's easily read for visually.
Did you do any investigation as to those time periods where Todd was?
I don't believe so.
Did you talk to any witnesses about Todd's activities?
Objection, that's totally wrong.
I'm sorry. Your Honor, if I can finish my thought. During those time periods of the Google searches.
I don't believe so. I don't believe so.
Do you have any information from your investigation that Todd would have been able to do a search from the iPad while he was planting corn?
No.
Your testimony at the 2019 trial regarding the Google search warrant return and the iPad, all of that comes from Ward Crowley's work? Is that, am I understanding that? That is not the same as a forensic digital extraction. Is it the same?
Then what are you comparing it to?
What you did to the iPad?
What board and I sat down,
And then you personally looked at the iPad in your hands,
okay?
just like you would for your teenager, to
Okay.
see what they've been Googling, right?
Oh, sure, yes.
You did that.
I looked at when we were down there, we looked into the, oh, not the search history. It would have been like the Google bar where it saves your last 10 or 11 searches.
I think I'm good. Have you listened to the 911 call from November 10th, 2018?
Yes. It's been a while, but yes.
Do you recall when you first listened to it?
I don't.
Would it have been before you arrested Todd?
I don't believe I listened to that. If it was thrown into the case file, I don't believe I listened to the 911 call before we made the arrest.
Okay. And you arrested Todd several months after Amy's death?
Yes,
Do you recall the date?
I don't. Yes,
February 28th, I'm sorry. February doesn't usually have 29 days, right?
yes.
Did you arrest Todd at his home at his farm?
No.
Where did you arrest Todd at?
It'd be a hog building on 270th Avenue.
How did you know that's where Todd was?
It was a lucky guess. We've seen his truck there.
And did Todd resist?
No.
When you approached the hog building, do you recall what you said to Todd?
Yeah, I had opened the door and Todd was sitting there.
Devices to return to you?
Yes,
Were you carrying a box?
yes.
Was that in fact a lie?
Objection by characterization.
Ruled.
There was no electronics in the box. It was a safety precaution.
So the box was empty?
Yes,
When Todd came out of the building, what did you do?
I believe I placed him under arrest.
Did you place handcuffs on him?
Safety
Yes.
precaution?
And then what happened?
Then he was escorted to Eric Brooks' squad car and placed inside.
It's like car.
Wait, I'm pausing at the risk of it crashing again. But I thought they could lie in order to get like a confession. What do you mean that you lied for a safety concern? Pretending to be returning his electronics in order to arrest him was a safety concern? How does that make it a safety concern? That's weird. I think that's weird. He can still start throwing hands as soon as he finds out they're there to arrest him. I don't know either way if that's right or wrong. I just think it's weird.
Truck, yes.
Is it common for your sheriff's office to have trucks instead of a four-door sedan?
Yeah, it was crew cab Dodge.
And was Agent Turbot on the scene with you?
He was in the truck.
Turbot,
Yes.
what was your plan for having Mr. Mullis with Agent Turbot
John wanted to speak with him again.
after he was arrested?
Yes.
At the time you arrested Todd in February 2019, you knew he had counsel. Did you?
Well, Bob Sabers. Yes.
Did you coordinate with Bob Sabers, Mr. Mullis couldn't?
I didn't.
Do you remember discussing that with your investigative team?
I don't believe so. It came up. I don't know. But as far as I know.
Did you consider yourself to be the lead investigator for the sheriff's office?
Yeah. So I'm the lead of contact for the sheriff's office, and John is the lead point of contact for DCI. And so the two of us, we team together for the lead point of contact. Yes.
Could you have contacted Mr. Sabers and asked him to have his client turn himself in?
Yes, that is possible.
After Todd's arrest, did you read him any Miranda warnings?
I did not.
Did you hear anybody him Miranda warnings?
No.
You knew Agent Turbot was planning to talk to him in the
Yes.
car?
Yes.
And I've seen this video, so it appears that you leave the truck and go back to the hog bar. Your recollection?
I think we just stand outside.
Did you get into the truck at any point?
Yep.
At the time, you listen.
Skip through like the lunch break and sidebars and you know, like the morning and afternoon break, so it won't be a whole 7 hours, but it's going to be long.
I don't believe so.
Have you listened to them now?
Trial time,
And that would have been September of 2019.
yes.
Like
Oh, and I have it sped up a little bit too.
radio traffic.
Yes, that's what we would have had, yes.
I ask because for me, they're two separate recordings and files. Do they appear that way to you?
Yeah, I believe it's all one, just the 911 recording with audio, but
So have you ever listened to the dispatchers? Is it always filed?
I believe so.
I don't know. Do you recall her in the AG office at the trial in 2019?
Yes, Maureen,
What was her last name?
I believe Hughes.
Had you worked with her before?
No.
Have you worked with her since?
No.
Do you know if she's still in Iowa?
Last I heard, I think she's in Tennessee. I don't know even if that's accurate, to be honest.
Did you assist her in preparation for trial?
Well, I didn't assist her. I mean, we tried.
Did you help her with evidence and exhibit?
Yes,
Specifically the 911 call
yes,
at the criminal trial?
yes.
Was that after 10 p.m.?
Probably was. I don't know the time, but yes, I talked to her.
Was that about the 911 call?
Yes.
Were you excited?
I don't know if I was excited. I mean, what do you mean by excited? No, we talked on the call and we discussed if she was going to use a 911 call.
Did you learn something new from that phone
About what
about the 911 call?
yeah, about what the contents of it, whether it said one thing or the other. Yeah, that's what was this discussion about. Yes.
Where did you learn that?
I don't remember how we got that information, honestly.
Did you document any report? That information?
I did not know.
Do you know the name of the person?
No, I don't know if somebody sent me a message or called me. I don't remember that, but essentially it was a tip.
And this tip tells you there's something else being said on this 911 call?
I've never listened to the audio before.
So you're near the end.
Case file, but I don't believe I ever listened to it.
Do you know if anyone else listened to it before trial?
Objection, also speculation.
That I don't know.
Did you have any discussions about the 911 call being an exhibit at trial?
It was an exhibit
Do you recall talking to the county attorney about it?
about entering it as an exhibit.
Yes.
I think that's common practice.
Are you aware that any
Guys,
statement made by a criminal defendant has to
I'm
be
trying to
disclosed to him before trial?
Objection, this witness's knowledge of the rules of criminal procedure is not relevant to the things.
I would say he's trained on those and he knows what Miranda is, so he can answer the question.
Overruled. The witness can answer if he knows.
I don't know.
Do you think it would be important evidence if the defendant or suspect made a mission? Is that the AG argued Mr. Mullis made are prejudicial?
That wasn't my decision.
I'm asking for your opinion.
Prejudicial? I don't know.
Do you think they were indicative of guilt?
As far as the content,
The new statements that you guys discovered in the middle of trial. Were those important to you?
they're important to the case.
What?
Because
Why?
the audio, and she made the argument. I had no involvement in that. So whatever the content is the content is.
As an investigator,
Okay.
disparities about a victim, are those important to you?
From a defendant, yes.
Or from a suspect?
Yes.
Your Honor, I don't think I have any choice but to play it, and if we're okay, test it to make sure it works. Is exhibit 3?
And 293 has not been admitted.
The 911 call is in evidence, so I have no objection. It was admitted in the underlying trial, so it's already in evidence in this case.
So I guess 293 will be admitted separately then if it is identified. Obviously, it is part of the underlying record as well.
And I would just clarify for that, as long as this is the same version as well as
Said it lost audio again. Okay, they're on a break. So right this minute, well, can you hear me now? They're on a break. So I'm going to try to fix this stupid thing. And then we can skip the break. I got a message from the guy from the internet company. And I thought that was a phone call I had. And he didn't answer, so I left a message. And I hope he's calling to tell me that there's something wrong and he's coming out to fix it. I don't know what is happening. So I hope that's it. And he's going to call me back. And hopefully we can figure out this mess. It's the upload, like when I upload a video now, it's like 5 minutes, boom. And it used to take like an hour, hour and a half. So I know the speed is faster. So I'm starting to think this is just a StreamYard issue. What? You can't hear me now? Sound-wise for my mic, everything was fine. That's weird. That was doing that on Ada K's channel the other day, and she uses StreamYard too. Can you hear me now? I went into settings on StreamYard and put the mic all the way up.
Ms. Nichols-Cook, back on the record with your audio.
Yes, Your Honor.
All right, and that exhibit number again is?
Your Honor, it's Exhibit 293.
Okay,
It has been tendered to the court on an external hard drive. There are 2 actual audio files in a folder. There might be a third one that is a duplicate of 297, so we will clarify that for you later. But at this time, conferred with the state, we are going to play 293 File 1, which is, these are the 2 files that were played in the underlying criminal trial.
And Your Honor, I indicated to Mr. Mullis' counsel that we're going to object to this line of inquiry. We agree that these are the same as the 911 evidence at trial, so we have no objection on that front. However, how we anticipate this line of questioning is essentially, and here I'm just going to state that we would object to that because his recollection at the time of trial and what was actually heard in that courtroom is what matters.
Your Honor, I can represent to the court that that's not my point.
okay, well, we'll play the files and see what the questions end up being whenever you're ready.
Okay. And if we would start File 1. Pause it there for a moment. Mr. Henseth, do you know whose voice you're hearing on this recording?
Yes.
Who is it?
Todd.
Mr. Mullis?
Yes.
Do you know who the other voices would be?
No, dispatcher.
A dispatcher?
Yes.
Okay, finish this one. That is the end of the first file. And so we will get the second file of 293 pulled up for you. Do you have an understanding of what was happening at the time of this, during this time period of the call?
Sounds like he's in his vehicle.
Do you know what kind of phone Mr. Mullis had?
LG flip phone.
For the younger people in the audience, what is a flip phone?
It's a flip phone.
Does it fold together?
Yes.
Does it have speakerphone?
I believe so. I would assume. I don't know that for sure. I do not own a flip phone.
We will pick back up. Okay. Okay, so we are about 44 seconds into the second file. Did you hear Mr. Mullis say anything?
He's in a white Chevy.
Did you hear anything else? Did you hear him ask the dispatcher a question?
I don't remember, actually, if we're being honest. No, I did. It's possible.
At that time, what's your understanding of what the dispatchers are telling Mr. Mullis to do?
I think they're instructing him to pull over, and they're going to start administering CPR.
Have you had other instances in Delaware County where people have driven themselves to the hospital?
I'm sure it's possible. Yes, I don't know of anything in particular.
And we can back it up. We'll back this up just one more time for you. Maybe you can listen to see if you hear Todd ask anything else. Did you hear that? No? Okay. Okay, we'll keep playing. Did you hear Todd say anything there?
I can't understand what it says. Something about closer, maybe?
Okay. Do you know what's happening now in Todd's vehicle?
I believe it's performing CPR.
Do you,
Would be my guess.
do you,
Your Honor, can I briefly witness for the first amendment? Objection, very briefly.
Go ahead.
Sheriff Hennesseth, were you on this 911 call? Yeah, I'm going to object that this is calling for speculation, and it's asking for the witness to opine to what is said and what is occurring on matters that he was not personally present for. He has no personal knowledge of it. As to the trivia questions of what's said and when, I don't see how it's relevant. The court already has the 911 call in evidence. It already came out at trial what was or was not said, and that was a weight question for the jury. So, Sheriff Hennesseth's belief based on this sound system, what he is or is not hearing and what occurred is not relevant, and it's not helpful, in the state's opinion, to the court's ability to determine the facts at issue.
Well, I would agree that I'm having a hard time figuring out the relevance at this point.
I can move forward, Your Honor, if you'd like, and skip ahead.
Okay, thank you.
Mr. Hennesseth, in your review of the other deputies' actions in this investigation, did you become aware that other deputies responded to this 911 call?
Yes,
Do you know if that was Luke Thompson?
it was.
And if I can fast forward to timestamp 6:20, have you known Mr. Thompson for a period of time?
Yes,
Will you be able to recognize his voice?
yes.
Okay, are we at 6:20? Okay, so my understanding, this is file 2 of 293, time code 6:20. Do you hear Deputy Thompson?
Can you replay it?
Yes. Right there, did you hear?
I don't know what that is.
Okay.
That's very hard to hear.
Are you aware that Deputy Thompson arrived at the scene and started CPR?
He did.
And he took over for Mr. Mullis?
Yes, that's what his report said, yes.
Do you hear another male voice on the,
I don't know what that is. I can't make it out from here, honestly.
is it possible that that's Deputy
It
Thompson
is possible, yes.
and that he's there at minute 6:20?
Yes, that's possible.
Do you recall at what point of this 911 call the tip said the statements were?
I don't.
If I directed you to the trial transcript, which is marked as Exhibit 351, which should be Volume 5, page 89. I did not write down the line number. 89. If I represented to you that in the transcripts, Maureen Hughes stops the 911 call at minute 6:53 of the second tape, would you disagree?
I would agree with that, if that's what that reflects.
Okay. And then again, she stops it at minute 7:00.
Yes.
I'm going to object. The transcript speaks for itself. Sheriff Hennesseth wasn't the one testifying, and the transcript's already in evidence.
Just have one follow-up question.
Overruled. Go ahead.
Mr. Hennesseth, would these statements that you called Maureen Hughes about have occurred after Deputy Thompson arrived?
Objection. This is, it calls for speculation. I don't think it's been established that Deputy Thompson for sure did arrive at 6:20. I believe the sheriff's testimony was it was possible.
Well, yeah, I'm not sure that's really an evidentiary objection, but the witness can answer if he's able.
I don't know what you're asking.
If Deputy Thompson arrived at minute 6:20 and the alleged statements that Mr. Mullins makes on the 911 call are at 6:53, wouldn't Deputy Thompson have been present for them?
I don't know if that's when he arrived or not, so I don't know.
If he did, though. If you have a record, his patrol log, if I have another record that shows he's there at minute 6:20 of that 911 call for his testimony, he would be there. at the time the tip said Mr. Mullis made other statements?
I don't know.
Just have one more clip to play, Your Honor. What's the timestamp on this one? This will be at timestamp 640 of the second file. Do you know what or who was talking there?
I believe it sounds like Todd. I don't know.
Do you know what he said?
I don't know. It's hard to hear on this.
Do you want her on the ground?
Objection leading.
Overruled.
I didn't understand what it sounded like.
Okay. Did you do anything else? Did you do anything else after you got that tip to see if anyone else had heard those statements during the 911 call?
No, I just told Maureen about it, and then that was her decision.
Okay. And you were an investigator at the time, though, of trial in 2019?
Yes.
And you didn't ask Thompson or Holub if they heard those statements?
I believe so, no.
Did you ask the dispatchers?
No.
Did you review Thompson or Holub's reports about the 911 call?
I reviewed the reports.
Does those reports contain anything referencing a statement Todd made?
No.
Did you talk to any of the emergency first responders?
No.
Did you review any of their reports?
No.
Okay. I'd like to move on and talk a little bit about some 2023 activities. You testified earlier that you reviewed the coat of Mrs. Mullis in the evidence room.
Yes.
And do you recall reaching out to Dr. Cruz about the coat and how many holes were in it?
I do.
Okay. We're going to pull up Exhibit 230. I believe you saw these during your 2023 deposition. And do you remember if you reached out to her with a phone call or text message or an email?
Text message.
We can scroll through these because I think there's a few here. Do these appear to be text messages between you and Kelly Cruz?
Yes.
Why are you texting her?
I texted her because I read that report, the opinion report that stated there was 4 holes in the coat, and it's been a while since I reviewed the case file, so that's the original. It's been a while since I've seen it, but that was the main topic about asking her if she was aware of that, how many holes were in the coat, and that's why I went and reviewed the coat, because I thought that was not true.
It looks like in these text messages you took additional pictures of the coat,
Yes.
and then you texted them to Dr. Cruz?
Yes.
You and Dr. Cruz discuss other things?
As far as what, I haven't reviewed this one, but I believe so.
Did you also send her a video regarding this case?
It wasn't directly for this case. It was another individual that's very interested in this case, but it had nothing to do with this case. It was a simulation of a chemical tote, and an individual that I think you know who that is simulating falling into it. Yes.
So I want to scroll down to page 6 of this exhibit and have you review that message for me. Do you know if you are the blue bubbles or the ones that appear to be gray or white?
It's clear on this.
Can you make it any bigger?
I think I'm the white.
You think you're the white? And what do you recall you and Dr. Cruz are discussing? It's this other person, this other video?
Yeah. He was.
And so the blue bubble, you believe that's Dr. Cruz's message?
Your Honor, I'm going to object on relevance on this line of questioning. This text string that we're currently discussing, this portion of it is related to an individual who is not, as we've discussed in chambers and during sidebars, is not directly related to this post-conviction relief action, is an interested member of the public who has taken a very strong interest in the case, and the discussion pertaining to that individual is not relevant to the facts that the court needs to determine here.
Yeah. Can you help me understand why this would be relevant under a PCR analysis?
If I could ask you 2 more questions, I think it'll be clear.
Go ahead.
Mr. Himsath, the individual that created the video or that you sent to Kelly Cruz, did he have opinions about Todd Mullis' guilt or how Amy Mullis died?
Oh, yes.
Did he disagree with Dr. Cruz and you?
Yes.
Do you then go on to discuss and agree with Dr. Cruz that he must have a mental illness? And
Objection, relevance, again, this is not pertinent to the facts of the issues before the court.
Sustained.
If we continue on, on to the it's the first one. Is this the message or pictures of the red Carhartt coat?
Yes.
Page, I'm sorry. Page contained 2 images. And then what did you write?
I don't know. I don't see it.
I believe the text is in between the images.
Oh, sorry. Holes.
Were you referring to?
Yes.
Did you have documentations in your reports anywhere else about the holes in the coat?
I did not.
Did you have Dr. Cruz's photos that we looked at earlier with the arrows?
At that time, yes.
Okay, and then scroll to the next page, page 9. You also, so an article is sent. Do you know if you're sending that or Dr. Cruz is sending that?
I believe that'd be her.
And then the next page, page 10, are you guys discussing the article?
Your Honor, I'm going to object again. Sheriff Hemeseth's and Dr. Cruz's opinions about the media presentations and the filings by Mr. Mullis's counsel are not probative on any issue that is before the court for determination. They are free to have personal opinions in their lives about how they feel the process is going, but it's not relevant for this proceeding.
Any response, counsel?
Your Honor, I think it's relevant for a couple of reasons. One, I haven't been able to fully ask yet, but Mr. Hemeseth has done several media interviews regarding the case. The messages are illustrative of his attitude and towards the post-conviction and the actions he's taking after the filing.
I will allow a few very brief further questions on this topic, and then I think we need to move on.
Yes, happily.
Again, this is a PCR bench trial. There is no jury here. Let's remember that and keep to the relevant, important issues.
Yes, Your Honor. Mr. Hemeseth, did you and Dr. Cruz then discuss the PCR?
Not. What do you mean by discuss?
In these messages, are you discussing the post-conviction filing?
I believe she asked me a question about it.
You say this is out of control. Are you referring to the post-conviction filing?
I can't remember what that was in relation to.
Okay. Were you open to receiving new information about how Amy Mullis had died,
Yes, always.
but you didn't read the entire post-conviction filing?
I did not.
You also spoke to Dr. Cruz on the phone during or after the post-conviction was filed. Did you?
I believe that's possible. Yeah, I don't remember the dates and times I actually called her.
Did you say in these messages that the experts got it wrong?
Yes.
I think it's the very last page, page 11. Sorry, I'm used to you being able to flip through your own exhibit, so my fault. Did you say the experts got it wrong? Someone got it wrong?
Oh, I already answered that. Yes.
Oh, I'm sorry. Okay, we can take that one down. If the medical examiner's office missed something and were wrong that Amy Mullis' death is a homicide, would that change your investigation?
Well, it would depend on what they miss. That's a pretty broad question.
If she's wrong and it's not a homicide, does the rest of your investigation prove? Are you relying on the electronic evidence?
Everything else in a whole.
What else is there besides electronic evidence?
Other witness statements. I haven't reviewed any of the other depositions of witness statements, so I'm not up on all that.
Okay.
But I know there was a lot of witnesses called, and there's a lot of elements to this case.
Are you aware of any evidence that Todd Mullis killed his wife Amy besides what was presented at trial?
No.
I know we talked briefly earlier, I think before the break, that you talked to Roman Gamble at DCI.
Yes.
Can you tell me briefly who he is and why?
He's an intel analyst.
Do you know if Ward Crawley retired from DCI?
Yes.
What did you ask Roman Gamble to do in 2024?
I asked him to take the cell right extraction and the Google searches and to combine the search history so as an easier workflow document for visual aid.
And did you do that because your testimony at trial was being challenged in this post-conviction?
So I never had that formal document made. that document's what Ward and I and Scott Rieger talked about. We never had it officially drafted, so I had Gamble create that document, merge the two searches.
So you found that what you had from before wasn't sufficient, you needed something else, am I understanding that?
No, that's not accurate. It was sufficient, just a better workflow product.
Okay, nothing further.
Cross-examination?
Thank you, Your Honor. Good morning still. Sheriff Hemseth, how are you?
Good.
Just want to ask some follow-up questions so we're on the same page here. And I'd like to start with the Google search document that we were just talking about with Mr. Gamble. You did a deposition in this post-conviction relief action in 2023, is that right?
Yes.
And at that point, it had been approximately 5 years since the investigation had occurred, is that right?
Yes.
And it had been several years since even the trial had happened?
Yes.
At your deposition, you were asked various questions, and your deposition's in evidence, of course, but you were asked various questions about the Google searches and how you came to certain conclusions at trial. Do you recall that?
Yes.
Was part of the purpose for creating this document with Mr. Gamble, was that to help refresh your memory of how you came to certain conclusions?
Yes.
And that was given a pass of time, things like that?
Yes, create a better workflow document for visual aid.
You were asked some questions about completing reports in this case. Did you complete any reports in this case?
Yes.
And did you document portions or interviews and investigation that you thought were important?
Yes.
But you didn't document every single action you took, everywhere you drove, is that right?
No.
Is that typical in an investigation to not document every single thing you do on a day-to-day basis?
Yes.
There was some testimony where you referenced that you didn't have access to reports prior to your testimony today. Is that in part because your case file, your reports, your evidence were provided to the state, the prosecution team as part of this post-conviction relief action?
Yes.
So it's not as though that you have somehow had the reports were taken from you for any other reason, right?
Correct.
You were asked a question about your theory on November 10th, 2018. Do you remember those questions?
Yes.
And this call came in from Mr. Mullis and his son as a farm accident initially. Is that right?
Correct.
So the approach to the investigation was reliant initially on that representation?
That's what the deputies had told me, yes.
So was it only after the investigation and the autopsy, those results and information that led you to determine that the investigation pivoted from an accident to a homicide investigation?
Correct.
So any steps you took in those initial hours and days were a result of how it was reported to you. Would that be fair to say?
Yes.
You were asked questions about former Deputy Rowley. Can I clarify, was it your understanding that Sheriff LeClaire, your predecessor, had confirmed via I think you called it the AVL system, or the GPS, that Deputy Rowley was nowhere near the Mullis farm?
Correct.
And when you say that Rowley was cleared, you don't recall specifically the exact time frame of when that AVL data was reviewed, do you?
No, I don't.
And the AVL system, the Sheriff LeClaire is the one who reviewed that?
Yes, he's the one that has access.
That you were aware in the flow of the investigation that Deputy Rowley was confirmed to not be in that area?
Correct.
And for whatever reason, that wasn't preserved, but it doesn't mean it didn't happen, right?
Right.
There were some questions about the autopsy, and you were asked how many holes they found in the coat or clothing. Do you recall that?
Yes.
And you had prior testimony where you were trying to recall how many holes they observed at that time. Do you remember those questions?
Correct.
And you thought it might have, your recollection at the time of your deposition was you thought maybe they had counted 6. Do you remember that?
Correct.
Would it be fair to say that regardless of your memory, that you would defer to the notes and the subsequent viewing of the clothes for what the evidence actually shows?
Yes.
So if the evidence shows there's 5 holes in the clothing, you would defer to what that shows?
Yes.
Regarding the Google searches, you asked some questions about the harvest season and when planting is. And there's some, actually first, let me go to, there was questions about UTC time, which I believe is Universal Time Code. Does that sound right?
Universal Coordinated Time.
Thank you. The purpose of your investigation with the Google searches was not to determine what time the searches were, was it?
No, it was specifically the content.
So that was your focus, was the content of the searches?
Yes.
You were also asked a question about Miranda warnings. And to be clear, you were not in the truck with Agent Turbot and Mr. Mullis, right?
No.
So if Agent Turbot had read Mr. Mullis' his Miranda warnings at that time before asking any questions, you wouldn't have been personally aware of that?
I would not have been present.
And the only other person in that vehicle besides those two is a former deputy who is unable to testify for other reasons, right?
I don't know if he was in the vehicle, but yeah, you are correct.
And that's because he has passed away?
Correct.
Thank you. I have no further questions. Thank you, Sheriff.
Any redirect?
I think very, very briefly, Your Honor. One quick follow-up, Mr. Hemseth, regarding the Google searches. You just said that you were only concerned about the content of the Google searches.
That was the main focus, is content.
Did you do any investigation to determine who created the searches or did the searches?
What exactly are you asking?
I'm trying to understand that you were investigating the content.
Yes.
Did you do anything to investigate who made the search?
Warren Crawley and I worked on it.
And I just want
That
to
would
know
probably-
specifically you.
Oh, I don't think I did it. No,
Okay. You didn't talk to other members of the Mullis family about the content that you found?
I did not.
Okay. And we talked earlier about how you didn't do any, did you do any investigation about the times of the searches to determine where the iPad or another device could have been?
No.
Or people that had access to those devices?
Right.
Okay. Do you recall testifying at this criminal trial that you didn't have any other suspects outside of Mr. Mullis and Mr. Frazier?
I don't remember that.
Okay. Did you mention Deputy Rowley in your trial testimony?
Objection, Your Honor. I believe, my recollection is there was a subject of a motion limiting for the trial. Please correct me if I'm wrong, but I believe it was subject of motion limiting to limit the testimony of specifically involving the Deputy Rowley issue. So I don't want Sheriff Hemestead's testimony to be mischaracterized.
I'm happy to defer to the court on what the transcript says and rephrase my question if that would be helpful.
That's probably the quickest way to solve the issue. I'm looking at the motion in limine, but,
And sorry, Your Honor, to clarify, motion limiting from the underlying trial.
oh, okay. Then it would be definitely the quickest way to solve the problem. If you don't mind, Ms. Nichols-Cook, we'll handle it that way.
Mr. Hemestead, did you testify at the criminal trial about Deputy Rowley's affair with Amy Mullins?
No, I was never asked that.
Were you told not to mention his name because of a motion in limine?
I don't think so.
Phone number. Okay. Can I just one more, Your Honor?
Certainly.
If I may show you one more exhibit and we'll pull up 371, I just want to confirm that this is the Gamble chart that you were talking about. And I believe Mr. Gamble's going to testify later, but just so that you and I are on the same page. Do you recognize this?
Yes.
We can scroll, I think it's a couple of pages.
Should be like 6,400 searches at the bottom.
Okay, that's a lot of pages. But does this appear to be the
Yes.
document you got back from Mr. Gamble?
Yes.
Okay, and what you were referring to earlier, that better visual? Okay, we get that down. My last question is, are there any other notes or reports that regarding the investigation into Ms. Mullis' death or Todd's arrest that wouldn't be in your file?
Not that I know of.
And did you learn at any time about what happened in the car with Agent Turbot and Mr. Mullis after he was arrested?
I don't believe so.
So you don't have any information about whether Miranda was read at that time?
I do not.
Or what, if any, questions were asked?
No.
Okay, nothing further. Any redirect?
Yes, Your Honor, but I'll try to keep it limited to 2 questions, which I'll regret in a moment. Sheriff Hemestead, we'll try to get you out here in a second, but I just wanted to clarify. So you were discussing your investigation, the Google searches, the cell phones, all of that. Was all of that done with the assistance of other agencies and other investigators?
Yes, multiple.
So that included, I think you referenced Ward Crawley, who was an ICAC or DCI investigator, DC agent Scott Rieger, people.
Yes.
So your conclusions about digital evidence was all related to the totality of your investigation working with those other people?
Yes, it was a team effort, yes.
And then final question, your testimony here at the trial, your depositions, were you truthful to the best of your ability and your recollection of everything given the passage of time?
Yes.
All right, I appreciate it, Sheriff, and I have no further questions.
Anything further, Ms. Nichols-Cook?
One question, Your Honor. Have you filed any supplemental reports to correct your prior testimony at trial?
I don't believe so.
No further questions, Your Honor. I just want to make sure that we have agreement on the exhibits before the witness leaves.
Okay. Do you want to confer with Mr. Bakke quickly off the record, or?
Make sure the photos before 11, the Thompson report at 300, sheriff letter, Thompson's report, the policy completely. The dispatch audio. So, Your Honor, I think we're in agreement that we would move to admit Exhibit 311, the photographs from the Delaware County Sheriff's Office, to formally move to admit 300, Deputy Thompson's report. And then Exhibit 400, the policies of the Delaware County Sheriff's Office, we would ask for the caveat that they be filed at a level 1. And then Exhibit 297, which is the dispatch audio recording, we did not play that this morning, but we would move to admit it upon agreement for completeness for the record.
Mr. Bakke, any objection to those exhibits?
No, Your Honor, thank you.
Right. they will be admitted.
Thank you, Your Honor.
Great. Anything further then for this witness, or is the sheriff free to go?
He is free to go.
Thank you, Sheriff. Okay, are we returning then to Dr. Nye?
Your Honor, we do not have a good place for Dr. Nye to wait in the building. She is nearby. I'm wondering if the court might be amenable to starting our lunch break on the earlier side and reconvening at 1 o'clock or something in that time frame. If not, we can get her.
Is in recess until then.
Also show you
The diagrams do. This is essentially the diagrams do. This is essentially showing
um,
all right, we'll go back on the record. Ms. Thompson, are we picking back up with Dr. Nye? Dr. Nye? Good afternoon. Let's swear you back in since it's another day. You swear the testimony you're about to give will be true and correct. Right?
and Dr. Nye.
Good afternoon.
When we left off on your testimony yesterday, we were talking about some of the hypotheses that you considered in your evaluation in this case. Do you remember that testimony?
Yes.
And we had talked about your one hypothesis that you considered, which is that the hypothesis that these wounds that we've been talking about and Ms. Mullis's Can you rotate this 90 degrees? Let's start. Do you see the figures on image G in front of you, Dr. Nye?
Yes.
And do these figures help you explain your testimony as to why you disprove the hypothesis that someone could not have swung the corn rake and illustrates that?
We were talking about an overhead swing. So this demonstrative, even though it's two-dimensional, shows that with an overhead swing, the angle of entry of the tines does not match the diagnosed wound trajectories.
And is that true for those wounds A through D that have one trajectory and those wounds E through F that have another?
It's true for all of the wounds, yes.
All right. Another demonstrative K. Do these images also help explain your testimony that you disproved the hypothesis that someone could have swung the corn rake into Miss Mullis' body?
Yes.
And can you explain how?
Similarly as the other diagrams do, this essentially is showing an overhead swing and in various positions of erect to bending over to lying on the ground.
Hey, Rodney. I apologize, guys. Can you hear me? I'm so sorry. Just when it got interesting, StreamYard had a crash. What if she had already fallen down and was on the ground? Nobody said he swung it while she was standing. Well, I don't know what anybody said because I didn't watch the first trial. I'm just saying she could have fallen and then he did it. So wouldn't that make the wound trajectory different? I don't know. Let me try to get back to the trial. I'm sorry, guys. Hey, Rodney, did I say hi? I don't remember.
Would it have been possible to create the wound pattern and the wound trajectories that Ms. Mullis had if the person who caused these injuries was sitting or kneeling?
Sitting or kneeling behind them, you mean?
That'd be possible.
At the Miss Mullis metric location, that would match.
And would that be possible?
It wouldn't match the wound trajectories.
Thank you. I think we can take that image down. talked yesterday of the injury rate. Consider the hypothesis that someone picked this back to cause these injuries.
I don't recall us talking.
Just because that is another really good point. Because nobody saw it happen. Nobody knows what position she was in. So all of this is just speculation. And if it was murder, only the person who did it knows. And if it was an accident, the only person knows is her and she can't tell us. I hate these kind of cases. And this is why I think that there really are innocent people in jails, because of stuff like this. When nobody sees it and nobody knows. Yeah, that's a possibility too, because he may have thought, well, this is a good opportunity, and then I can say it was an accident. But if you think about the way your body moves when it's injured, you're going to do whatever you can to try to avoid further injury. And I know that from being injured and being in pain so many times. I'm imagining like she fell back and did like this hyperextension this way, but maybe I'm picturing it incorrectly. Because if you fall back on something and you realize you're going to fall back on something, you're not going to fall flat. You're going to do one of these. I don't know. StreamYard, it just got interesting. Will you please behave?
Shoulders back, rotated. If someone's on the ground, not in an active position to have to hold. So you'd have to then, feasible hypothesis.
So a second ago, I want to make sure that I spoke correctly. We had talked about the hypothesis that someone pushed Ms. Mullis onto the rake. That's what we discussed yesterday. Do you remember that testimony?
Yeah.
All right. I do want to discuss with you this other hypothesis, whether someone pushed this rake into Ms. Mullis's back, meaning they held the rake and pushed it into her. Did you consider that hypothesis?
Yes.
And were you able to prove or disprove that hypothesis? About your investigation led you to conclude that?
Biomechanical and scientific literature that talks about the penetration threshold for blunt objects into the body.
And what does that literature say about that topic?
What it says is I need about close to 75 pounds of force for one of these tines to enter the body without the clothing. When you add on the clothing, then we're over 90 pounds. And then the fact that there's 3 tines going, and then you have to distribute the forces, so you're multiplying that now by 3. There's biomechanical literature that talks about the push force, and there's different kinds of pushing. If you're holding it against a body and you're constantly pushing, or you're actually pushing with acceleration. So if you use the pushing with acceleration, that's a more severe scenario compared with the constant push, because now you're adding acceleration in. The maximum push force by males is about 138 pounds. So that is not enough force.
Through whether some
With the
were you able to determine any hypothesis where a person would be able to push the rake into Ms. Mullis's back to cause these injuries?
Sorry, can you say that one more
Sure.
time?
In considering this hypothesis, the hypothesis of whether these injuries were caused by someone pushing the rake into Ms. Mullis's back, were you able to envision any scenario where that was possible?
No, because that's already, even with 2 times, we're not reaching the necessary threshold. So again, I said a very, very conservative minimum. It's greater than that, is 90 pounds. Multiply that by 2 times, and that's going to be more than 180, and the very maximum push force is less than that.
In the literature that you looked at, that the literature discussed this concept with respect to,
Screwdrivers.
is that flathead screwdrivers like the screwdrivers we were discussing yesterday?
Yes.
And it was your testimony yesterday that this corn rake is blunter than a flathead screwdriver?
It's blunter than a 1/4 inch wide flathead screwdriver.
Thanks for that clarification. I appreciate that. Right.
Yes.
And could you disprove this hypothesis?
I could not disprove it. Actually, I proved it.
Sort of assist you in explaining this testimony.
Yes.
All right, I want to show you demonstrative J. Can you explain how that you could not disprove the hypothesis that the
Okay. Can you hear me? I shut down my channel. So I'm not seeing what you guys are seeing. I'm just seeing StreamYard. So let me know if anything looks weird or the sound is weird or anything like that. Because I cannot see what you guys see right now. Okay. That might fix the problem. I hope it fixes the problem. Okay, let's try this again. And I want Devin to call me back so I can ask him. It says I have 1 gig up and 1 gig down, and that should be plenty. And I have turned off Wi-Fi access to every other device in the house. So it's got to be StreamYard. I don't know what I'm going to do, guys. I really don't. Thanks for sticking with me, though. I really appreciate it.
That demonstrates that when she falls, that this generates the mechanism necessary to cause the injury. So now that I showed mechanism, then I analyzed force.
Force in a minute, but just sticking with mechanism for a second. You talked yesterday in your testimony about the concept that if someone had pushed Ms. Mullis, so stood and pushed her under the rake, there would have been rotational forces that would have sent her at least somewhat in a horizontal direction. Do you remember that testimony?
Yes, it's rotational as well as horizontal velocity.
And thank you. Why wouldn't that concept have prevented Ms. Mullis from falling down onto the rake in the way that you're just describing you could not disprove?
Well, when you have horizontal and rotational acceleration that pushes the body across, basically, if you think about parallel to the floor and rotating about that axis, when you contact the rake, because the rake is top heavy, it's going to flip. In the falling situation, when somebody falls from standing height and falls backwards, her body will contact the tines first, and then her lower body essentially pins the rake down with the rake handle down, which prevents it from flipping.
We're talking about a 4-timed rake and 6 wounds. So this hypothesis requires Ms. Mullis to have fallen on this rake more than once. Isn't that right?
Yes.
How could that have occurred from a type of force and direction of force perspective?
Well, as discussed, the A, B, and C wounds are created first because we've excluded that E and F and D being created first for the reasons we talked about. After A, B, and C are created, if you're, her trying to get up, she could roll to her right. The rake handle prevents her from sitting up straight, so sitting on her buttocks because it's too long, it's longer than her torso. So for her to get up, she'd have to roll over. And if you roll over to your right and not to your left, because otherwise you're rolling over the rake, if you roll over to your right, essentially you're causing tensile loading, and you can pull out that tine 3, which is in wound C, because it's not as deep as A and B. Right? Remember that wound C is 3 and I think 1/2 inches deep. So if you can pull wound tine 3 out of wound C just by attempting to get up and maneuvering, trying to get the rake out of her. The rake stays in the clothes at that point, and in her movement, the rake then moves within the clothes, causing the abrasion above wound D. Even if she gets up onto her hand, she doesn't have to get all the way up to standing, not even to her knees yet, getting up to leaning up on her hand and then falling backwards to get wound D.
I want to stop you right there where you caused wound D, and I'm going to show you another demonstrative, which is demonstrative F. Does this demonstrative help illustrate your testimony about how Ms. Mullis could have fallen on this rake more than once?
Yes.
And can you explain how it does that?
Yes, so basically her pulling on the rake handle to try and extract the rake from her body reorients the tines upward. With A and B still in her body, that is then consistent with the tines moving around, as Dr. Hammers discussed yesterday, with the external and internal wound pattern showing that the tines are moving, tines 1 and 2 are moving in wounds A and B. Once you reorient the rake and she falls on it, then you have the mechanism to generate E and F.
From the data that you had from Dr. Cruz and Dr. Hammers about the pattern of wounds A for F, did this hypothesis match?
It matches everything, yes.
And from the depth of the wounds as measured by Dr. Cruz, did this hypothesis match?
Yes, A and B are deepest, and they stayed within her, and E would be the next deepest.
In terms of the physical characteristics of the rake and the fitting of the rake, does this hypothesis match for all of Ms. Mullis's wounds on wounds A through F?
Yes.
you had talked earlier about Ms. Mullis's clothing. From your investigation and analysis of the clothing, did this hypothesis work?
Yes, with the less holes in the clothes relative to the holes in her body, and understanding that time 3 doesn't come out of the clothing to cause wound D, yes, it all fits.
And from the issue that you were discussing a minute ago of Ms. Mullis's back being hyperextended, at least on the right side, does that fact and that concept, does that fit with this hypothesis?
Yes, even when you move the rake in this position that we see here, you reorient the rake handle down by her left hip, trying to extract it. That'll cause, again, the back skin to basically compress together.
From your review of the layout of the shed and the physical characteristics of the shed, did this hypothesis fit?
Yes.
How?
The small spacing, there's not a lot of room in there. So we talked about that for the swinging scenarios, but there is enough room to fall and refall on this implement.
Were you aware of evidence in the record that there was blood on Ms. Mullis's hand and blood on the handle of the rake?
That's what I reviewed in the records, yeah.
And did that information fit with this hypothesis?
That fits with this hypothesis, yes.
How does it?
So she has to grab the handle to reorient the handle in the manner that we see in this figure in order to sustain ENF. So grabbing that handle with blood on her hand would transfer to the handle.
You told us a moment ago that, and I think discussed this yesterday, that first you have to determine the type and the direction of the force to determine if those mechanism issues fit with the hypothesis. And is it your testimony that those factors fit with this hypothesis?
Yes, the type and direction of forces in this fall scenario fits with all the injuries.
All right, and in your method of analysis, you would then go on to determine this question of magnitude, whether there could be enough force here to cause the injuries in this hypothesis. Is that right?
Yes.
So in the hypothesis you've described, we're talking about a couple of different kinds of falls. Is that right?
Yes.
What kinds of falls are we thinking about in this hypothesis?
I analyzed a fall from standing, a fall from a lower height attempt while she's trying to attempt to get up the first time, and a fall from, say, knee height if she's trying to get the rake out.
You were here for Dr. Cruz's testimony that she did not believe that a fall could be enough to cause these kinds of injuries. Did you hear that testimony?
Yes.
From a magnitude perspective, whether the fall from standing, a fall from kneeling could cause these injuries, what is your conclusion as a biomechanical engineer?
That there is sufficient amount of force.
And how do you make that determination?
Using engineering and laws of physics.
And can you tell, did you have to perform calculations to figure that out?
Yes.
So tell us what you did to make that determination.
So the fall height, calculating a fall height from standing height, you consider conservation of energy principles. So the gravitational potential energy has to equal the kinetic energy. So the law of conservation of energy states that energy cannot be created or destroyed. It can only be transferred from one form to another. So at the height of the fall, that is the potential energy. And as she's falling, you can calculate the kinetic energy using rotational energy combined with linear energy. Once you have that, you can isolate for the velocity, and then estimating a stopping distance, you can calculate an impact force.
And to make those determinations about what those different factors were that go into this consideration, were you relying on principles of engineering, of biomechanical engineering in your field?
Principles of fundamental engineering and science, yes.
All right, and so for the fall from the standing height first, would the force have been of a great enough magnitude to allow Ms. Mullis to be impaled on this rake?
Yes.
And what about from the lower height that you described, from being on her knees?
From you mean the first time she tries to roll over, or which one?
So in the hypothesis you've described, the first time that Ms. Mullis would have fallen on the rake in this hypothesis, she's falling from a standing height. Is that right?
Yes.
And for a later fall, I think as you described, she would be falling from a lower height. Is that right?
Yes.
And so what about from that lower height? When you did this calculation about the magnitude of the force, would there have been enough force generated in this hypothesis to have caused these injuries in the way that you described?
Yes.
During your investigation, did you come across any physical evidence that did not fit with this hypothesis of Ms. Mullis falling onto the rake in the way that you described?
No, every single piece of physical evidence supported this hypothesis.
Just one moment, Your Honor. In the hypothesis that you've described that you couldn't disprove, you described the rake times that caused wound A and B, which I think your testimony came first. In this hypothesis would have stayed in Miss Mullis's body as she tried to get up. Is that right?
Yeah, so A, B, and C happened first, and A and B stay within her body.
All right. And taking that factor into account, that's the hypothesis that's how, testing the hypothesis of how this has occurred, you were able to determine in that scenario that there was enough force to have caused first the fall from a greater height and then the falls that you described that would have been from a lower height.
Yes.
Now, you heard Dr. Cruz's testimony earlier this week that she did not perform any experiments in reaching her conclusion that a fall would not have made these injuries possible. Did you hear that testimony?
Yes.
Have you conducted an analysis that allows you to reach the opinion that that hypothesis can't be disproven?
I've done an investigation that not only can't disprove it, but actually proves it.
And have you worked with forensic pathologists in conducting biomechanical evaluations in other cases?
Oh, yes, for sure.
The hypothesis that you've testified that you can't disprove, is that hypothesis unlikely from a biomechanical or a biomedical perspective?
No, it's completely feasible. We've analyzed all the work that went into this investigation to consider all the physical evidence, including the diagnosed wounds externally and internally, the measurements and dimensions and geometry, and again, intrinsic properties of the rake. Everything fits. So not only does the magnitude match, the mechanism matches. It all matches.
Just one moment, Your Honor.
It's not far-fetched at all.
Sorry, one moment, Your Honor. Just two other questions, Dr. Nye. Is there anything in the opinions that you've given here yesterday and today in your testimony that is based on new science that's been developed since 2019?
No.
And are these opinions that you or someone else in the biomechanical field could have offered back in 2019 based on the state of the science then?
Yes.
All right. I have no other questions at this time, Your Honor.
Cross-examination.
Yes, Your Honor. Good afternoon, Dr. Nye.
Good afternoon, Mr. Duden.
How are you doing?
I'm well, and I hope you are well too.
I am, thank you. I want to start by talking a little bit about your background in biomechanics. Is it correct to say that in your PhD mechanical engineering? And was that again?
2000.
And since your primary focus, as you testified to yesterday and reflected in your CV, is focused on lower extremity injuries, right? And ocular, I believe.
Since that time, no. That's when I graduated. However, I've been a forensic biomechanical engineer for 15 years.
Oh, I'm sorry, about your publications specifically and the research that you've conducted. Has that predominantly focused on lower extremities, upper extremities, joints such as the knees? I believe you testified to yesterday.
Yes, my publications are focused on that, but I've worked in multiple areas.
Based upon a review of your most recent testimony offered in either a deposition or trial format, is this your first criminal case that you've consulted on specifically?
No.
Is it the only criminal case that's noted on the documentation of your trial testimony and depositions that was provided to Mr. Mullis' counsel?
I am not sure. The testimony list I have is for the last 4 years, but I don't really recall it.
Where have you testified for a criminal case?
I have not testified in a criminal case, but I've worked on criminal cases, multiple.
Through a consultation format, is that fair?
It starts out as consultation, but they don't, we talked yesterday, if I don't have an opinion that supports their case, I don't testify typically.
So when you first came into this case, it was to review Dr. Bowley's report, right?
I was a peer reviewer for Dr. Mullis.
And in that sense, you simply reviewed her report and then double checked it, in your opinion, is that fair?
I think I work alongside, I basically listened to her her investigation along the way to make sure that she was following the scientific method and applying the laws of engineering and physics appropriately.
So your own investigation came after, however, correct?
That is correct.
And so as it relates to your investigation and your biomedical evaluation, was that first in September 2023 or June and July of 2023, I believe.
I don't remember timing. I'm sorry.
Okay. When you undertook your investigation, you visited the farm, fair?
I visited the farm.
How wide is the space of the red shed where the incident occurred?
Based on the police documentation, the pathway when you enter the door to the totes was about 2 feet. And then when you walk along, you turn 90 degrees and you enter the pathway where the augers and the pet carrier were, and that was noted to be about 3 to 3.5 feet.
Did you take your own measurements when conducting your investigation?
No.
So no supplemental measurements were taken of the space in question?
No, from what I understand, they had taken, since the incident, it's an active farm, so they had taken things out and put it back in. So I had the documentation right after the incident from the police department.
So in that 2 feet of space, give or take for the walkway, where was the rake?
So the 2 feet was the walkway where she's found by the door. The space between the pet carrier and that space was about 3 to 3.5 feet, but there were 2 augers there.
So where was the rake when she was impaled? That's my question.
On the floor, in the area of the pet carrier is what I believe.
Okay, and where's that documented? Do you recall?
It's not documented there, but that's where the rake was found. I have no other documentation that indicates that the incident happened elsewhere.
Well, to be fair, the rake was found in her back, right?
Well, the rake was found in her back, but the photos have the rake on the ground in the shed.
So the location of where you believe she first became impaled in the rake with the corn rake was back by the pet carrier. Is that fair?
Based on the information, again, that doesn't really matter to me, but that would make sense.
Well, I'm trying to gauge it from a space perspective. Is it fair to say that your report does not outright include the calculations for force or magnitude as it relates to the injuries in question?
No, they do.
Your report details the force and magnitude measurements?
The actual dated report? No. I don't know, actually.
I believe it's in front of you.
Okay.
You can take a look
Thank
as
you.
well.
It's hard to remember because I have my notes file. You're correct. I don't actually have the numbers in there. I just have the conclusion that it generates more than sufficient impact force.
But you're not able to know from reading your report, for instance, as to what amount of force was generated based upon your hypothesis, right?
The exact number?
Correct. Looking to your report, do you still have your second report in front of you?
Yes.
Looking to, I believe, the first and second page specifically of your report. Let me know when you're there.
I'm here.
I believe that, directing your attention to page 1, your stated purpose of the letter is to provide your professional opinions based on your biomechanical investigation of an incident, and specifically as to the purpose of your investigation.
Well, yeah, be too. Because I just see a big flaw. Because she's doing her calculations from the position of the corn rake, but she was found with it in her back. So if she's doing it from the position it was found, that was after it was removed from her back, not where it was whenever she fell on it. So how does she know that her calculations are correct? If nobody told her where the corn rake was originally and she's just going from where it ended up after they took it out of her back, then her calculations aren't correct. I was so excited for her testimony, and now I see a huge flaw in it. Not that I'm siding with either side. I'm just saying I was curious as to why she believed that she fell on a corn rake more than once. And now I'm not sure I can trust her opinion.
Was to determine whether these diagnosed injuries were caused by an accidental fall on the corn rake or the rake being intentionally swung multiple times into her body. Did I read that right?
Yes.
Her evaluation was specifically to look at whether or not these injuries correlated or could have been caused by a fall. Fair?
My evaluation, that was part of my hypotheses, yes.
Nowhere else in your report do you detail any secondary hypothesis, though, correct?
Well, the secondary here is the swinging.
So, fair. And taking that into account, the evaluation looked at falling onto the corn rake, right?
Falling onto the corn rake, correct.
That's one. And the second one is whether or not it was swung into her multiple times. Fair?
Fair.
You do not detail any other working hypothesis as it relates to whether or not it was pressed into her body, right?
In my report, no.
Nor do you actually mention in your report as to whether it could have been kicked or otherwise thrust, struck, what have you, into her body either, correct?
You're correct.
In looking to the actual data information you provided, I believe your evaluation looked only again at a fall from standing or knee height, falling onto the rake, or swinging it, correct?
When you say my evaluation, do you mean my notes?
I believe it's in your notes section. And I'm looking specifically at your numbered paragraphs 1 through 3.
Yes.
And so those only evaluate from a swinging or a falling standard, correct?
Not technically, because I provide my references, which give the information that you can compare the numbers to.
Well, you've never filed a supplemental report as to the information as to whether or not it was kicked into or back, correct?
I did not write a report about kicking.
And so when was the first time you evaluated it from that perspective?
From the kicking part,
Yes.
I don't remember.
Well, I believe the first time it was mentioned here during testimony was yesterday, which you were in the room for, correct?
Well, Dr. Cruz had mentioned it in her deposition.
As to whether or not it was being pushed or kicked into her in her testimony on Monday. That's your statement?
Her testimony in the October 2023 deposition.
Was evaluated from a kick or push?
She had said she didn't know if the tines were entered into her body one by one, if they were pushed or kicked.
And to be fair, your report doesn't detail it from that perspective either, right?
My report does not discuss kicking.
And nor do your notes that were included with that report actually reference it from that perspective either, true?
For kicking, I mean, again, that's a trajectory standpoint. So if you talk about trajectory, then it doesn't specifically say kicking, no.
So there's nothing or no indication to believe that you had evaluated it from that perspective based upon your notes, correct?
I mean, I know that it's there.
But there's nothing based upon your notes provided or your reports that would detail that, correct?
Yeah, nothing in there says kicking. Correct.
Looking at it now, how much magnitude would, how much force would be necessary to penetrate the coats in question from a forced push?
It's in here within the references that I provide. So it's 600 newtons, which equals to 138 pounds.
Where's that in your notes?
It's in the references that I give.
Could you point me to a specific place, please, Dr. Nye?
Sure.
Your Honor, I don't want to interrupt the witness's testimony, but just because we want to make a record of what the witness is referencing, I think plaintiff's applicant intends to offer this as Exhibit 976, the document that the witness is looking at. We do just want to make a record of what the witness is actually seeing, since it's this other document.
976.
Yes, Your Honor, and we'll file a copy with the EDMS.
Mr. Duden, did you have any objection to that plan?
I have an objection to admitting the entirety of what would be admitted as 976, Your Honor, as it contains hearsay from other reports and would constitute an evaluated process. As for an improper evaluation, as for the actual calculations or page reference that we've spoken about so far, I have no issue, Your Honor.
All right, well, maybe on the next break, we can talk about what exactly 976 would constitute, see if you can come to an agreement on that. If not, we'll go from there, but I'll hold off on admitting that for now. We'll circle back. I think there was a question pending for Dr. Nye. Do you remember?
Yes.
Okay, you may go ahead and answer.
Sure. It's reference 5, Nolan. The last page have my references listed. And number 5, the reference number 5 gives you the max push force.
For stabbing attacks, correct?
Well, if you read the paper, it includes pushing.
Well, I'm just looking at it. It's forces generated in stabbing attacks is the one you're referencing, correct?
Oh, if you want the title, forces required for a knife to penetrate, forces generated in stabbing attacks, an evaluation of the utility of mild, moderate, and severe scale.
Where would your notes indicate specifically other than a citation to an article on stabbing?
Well, if you go to the article and you get the value that's listed there, they basically compare stabbing to blunt activities,
But
including
that's not included.
double hand pushing, and then you compare it to the calculations that I provide.
It's not included in your calculations, though, correct?
It's not a calculation, it's the number that's listed in the reference.
It's not noted as a number or otherwise in your actual notes or application in this case, correct?
No, the reference is noted.
And I believe you testified yesterday, you disagree with the category to say you would believe that this isn't a stabbing case, correct?
This is not, she was not stabbed. Does not generate sufficient force.
So there's no way to know, based upon that citation alone, in your reports, for instance, that would be the force required to penetrate the skin here, correct?
Objection, Your Honor.
There's no way to know the force required to.
Yeah, there was an objection. The objection's overruled. The witness can continue to answer.
I'm sorry, can I get that question again, please?
Sure, and I'll rephrase it. Nowhere in your report is that mentioned from a numerical perspective, right?
It's just listed in the reference.
And nowhere in your application of actual numerical values, notes, calculations, et cetera, is it noted either, right?
No, that number's in the reference, and it's not a calculation, it's a measured empirical number that you take and you compare it to the calculations that I did.
Well, let's talk about, you did not do an accident reconstruction or an incident reconstruction in this case, did you?
I absolutely did.
Where is that specifically noted other than viewing the scene?
So the entire process of the investigation is an incident reconstruction.
Well, what I see is we've talked about it. You have two hypotheses, fair?
The two hypotheses I discussed in my report.
And as is common in your publication history, which I've reviewed too, you note limitations of the work and research you provide, right?
Specifically with regard to what?
When you are conducting research or experiments according to the guidelines of technical papers or research in your discipline, you are to note the limitations of what you can identify as a causal factor. True?
I think you need to be a little more specific for me, please.
Sure. I'll give you an example, perhaps. I believe you did research as it related to wear and tear of knee joints, correct?
That's not exactly, I think you need to be a little bit more specific or accurate. I'm not quite sure what you mean.
Is it part of the scientific process to note the limitations of what you are testing?
Yes, that's why I do conservative calculations.
That is not noted in your report either, though, is it?
It is. If you actually look at the calculations, you'll note that it's conservative.
For those that are just reading your report, Dr. Nye, it would not be known, though, would it?
Objection, Your Honor.
On what grounds, Your Honor?
As to who would read it, it depends on who the person is that's asking her to speculate on the knowledge of the reader.
It's filed in a legal proceeding, Your Honor.
Overruled. The witness can answer if she's able.
I mean, anybody who knew basic physics would know
About your noted limitations as it applies to this case.
about my calculations being conservative, yes.
But that is, as I've said and asked, not noted in your report specifically, is it?
Oh, that's my standard practice to conduct conservative calculations. I didn't write in here the word conservative.
Well, I appreciate what your standard practice is, but what I'm noting is that in your report, we wouldn't know that, would we, Dr. Nye?
I believe that you would if you look at the numbers and the calculations.
Which are not present in your physical report, are they?
They're not in my data report.
The study of biomechanics is, for injury biomechanics, is the study of the failure of biological systems. Is that fair?
Yes, biological material.
And biological material in this case would be the body caused by the corn rake penetration, correct?
So tissues, yeah, we talked yesterday. Injury is defined as a failure of biological tissue.
And I believe as you described yesterday, your opinion here is that the tissues failed by compression due to puncturing or the penetration wounds caused by the corn rake.
Tensile overload.
And tensile overload would be the compression of the skin at odds with the corn rake, fair?
So due to the blunt object, when you compress the skin, it will deform with the object, and then it will, because of tensile loading, and then will start to tear. And that is why the appearance of blunt force injuries, as Dr. Hammers described, have that bruising and tearing rather than a sharp force injury.
Well, regardless of blunt force, sharp force injuries, there's no dispute that that corn rake caused the injuries on Ms. Mullis's back, correct?
Correct.
And that's in alignment with the medical diagnosis, as you noted too, correct?
Yes.
Because you are not able to diagnose the injury itself, fair?
I do not diagnose the injuries. That's correct.
Nor do you diagnose or note the treated injury patterns as it relates to a medical conclusion, correct?
I do not treat injuries. That is correct.
So the pathological diagnosis here was not being made by you, fair?
Right. I don't diagnose and treat. I'm not a medical doctor.
So your conclusion was tensile overload from penetration with a blunt object, correct?
Yes, blunt penetrating force.
Going through this, you conducted no experiments using the clothing or like clothing that was found on Ms. Mullis's body, correct?
What do you mean by experiments?
You at no point evaluated what additional force would be necessary to puncture the specific clothing on Ms. Mullis's body, right?
I did.
You evaluated the specific requirements added on from the 3 layers of clothing specifically related to her in that specific case.
So the types of clothing that she had on.
In a general sense, right?
The materials. I considered the materials those types of clothing would be made of.
So in a general sense, you applied the research as it relates to the layers of clothing.
Well, if you look at the tags of the clothing, they give the material properties, what they're made of. So denim, polyester, cotton. So the tags of the clothing indicated that.
How long is the rake?
37 inches long.
And that's noted in your report that was filed? Well, I'll rephrase, that's not noted in the report as filed, correct?
I don't know. I might be. I'm not sure.
Feel free to take a gander through it and let me know when you've viewed it.
Sure.
I'm just impressed that she knew that so quickly right off the top of her head. Does this guy seem a little mad? Or is it just me?
Yeah, I don't think I wrote the 37 inches long in the report.
And did you document the length of the tines in your report?
Would that be the same question if I wrote it in the report?
Did you note in the report the length of the tines specifically?
The length of the tines? No.
Or the gap spaces and angles of the tines at issue?
I did not put the specifics of the rake in the letter here, this letter report.
Because none of the calculations or information is documented in your written report, right?
None of the calculations?
Correct.
So just the conclusions of the calculations.
And your conclusion is that it would be impossible to cause the injuries at the hand of another in this case?
So to a reasonable degree of biomechanical certainty, more likely than not, it is unlikely.
Well, you say that with certainty there, that you, correct, as to conclusion number 1 on page 5, for instance, you decide certainly that no one swung the corn rake into Ms. Mullis's body, right?
Yes, to a reasonable degree of biomechanical certainty.
And I believe yesterday you testified that it was a swinging motion specifically, but then came back today and said you had these other hypotheses, fair?
Objection.
Based on what, Your Honor?
That misstates your testimony, Your Honor.
Kelly, can you read me the question?
And I believe yesterday you testified that it was a swinging motion specifically, but then came back today and said you had these other hypotheses there.
Mr. Duden, you just maybe want to rephrase your question. I'm not sure that I even completely understand it in the way in which it was asked.
Sure. I have down in yesterday that you had said it would be impossible to swing the corn rake into her body, correct?
I don't say impossible. My standard is unlikely.
So it is unlikely that it was swung into her body.
Right. So to a reasonable degree of biomechanical certainty, then it would be impossible.
And yesterday you said it's not an overhead swing, right?
Correct.
Or a lateral swing, fair?
Correct. And I said that today too.
And based on my analysis, or at least where my notes cut off, right? Your first mention of kicking, pushing, or otherwise was said today, fair?
I answer the questions that are asked to me. Those questions weren't asked to me yesterday.
Well, it's not noted in your report, is it?
We talked about kicking is not noted in my report.
And it wasn't mentioned specifically yesterday, as you implicitly agree?
I'm here to answer questions. I wasn't asked yesterday.
So that's correct, right? That you were not asked specifically about anything other than swinging the rake yesterday.
Objection, Your Honor.
I believe my, oh, sorry.
This question has been asked and answered, and the record is the record on this issue.
Overruled. The witness can answer if she's able.
I believe my testimony was continuing because it was the end of the day, so my testimony wasn't done yesterday.
You mentioned that there would be not enough force to push into the body because the literature supports this conclusion. That's what you said today, yes?
Yes, the literature indicates a maximum two-handed push force for males.
And by the literature specifically, you're only referencing that one citation that doesn't reference it outright?
It does reference it. If you,
Well, we wouldn't know, right? You would agree that it wouldn't be noted in your calculations. Again, we've talked about this part already.
well, I listed in my report. It's provided in my report, in my notes.
Permission to work with one of the demonstrative exhibits that were previously used, Your Honor?
Certainly, I don't have access to those though, so
We'll pull up whatever.
sure.
Well, I think I don't know if you needed to switch over that chords. That was mostly it.
You have access to them?
Yes, Your Honor.
Great. Whoever has the remote might need to turn the TV on for us though.
You have your own. You have your own, right?
Oh, we have a cord.
Yeah, you have your own.
Is that you guys? All right, perfect.
I'm looking to the screen in front of you, showing you what's labeled as demonstrative exhibit J, I believe. This is the demonstrative you worked with previously with Ms. Thompson, correct?
I developed this.
Most of my question is, this is just the same image that was used when you were working and speaking with Ms. Thompson, right?
Oh, sorry, I misunderstood. Thank you. It is.
So you're familiar with this because, as you said, you created it, fair?
Yes.
This is what you stated on, I believe, your direct examination was the likely scenario of the initial impact, or the initial time impact. Is that fair?
Well, it's a two-dimensional, as I said before, so it doesn't show the 3 dimensions.
But I believe, as you stated, this would speak to the trajectories at issue, correct?
Yes, for A, B, C, and D.
And this is, as you stated, would be the first injury. I believe you called them wound patterns. Is that fair? I don't want to misquote you on that one. First set of puncture wounds that occurred during this incident, correct?
So A, B, and C occur first.
So looking at this, this would be the initial impact for the through and through injury, the one that resulted in the puncture that came out this front side of her chest, right?
Again, this is a two-dimensional profile view of a static torso with no head, no arms, no legs. So it can hyperextend, but yes.
Permission to approach, Your Honor?
May.
We're going to show you what's previously been marked as State's Exhibit D in this case. Here you go, Dr. Knight.
Thank you.
What is this? A picture of?
This is a picture of a gel torso.
And are you familiar with this image of a gel torso?
Yes,
You took this picture, correct?
yes.
And it was during your research and experiments as it related to this case, true?
No, my research and experiments and testing and my opinions had already been formulated when I took this picture.
These were subsequent experiments undertaken for purposes of this case, true?
It was not an experiment. I already had my opinions.
So this is you working with the gel torso, correct?
Yes,
And you recognize it because, is that your hand in the image?
that is correct.
And you took the photograph,
Yes,
and it's a fair and accurate representation of your work with the gel torso as it relates to this case, fair?
yes.
Your Honor, I would move to admit State's Exhibit D.
Letter D,
D, yes.
isn't that in already?
I believe it was not stipulated to its admission previously.
Okay.
D and E remain pending.
Any objection to Exhibit D?
For, in terms of authentication and foundation, no, I think it depends on the purpose for which it's being offered, which I mean, we would reserve a right to argue its relevance, but in terms of, I believe that the state has authenticated it and laid the foundation in the way that, the way that the state just described it.
Okay, D is admitted.
This, permission to publish, Your Honor.
Yes.
Thank you. So this is looking at a copy of State's Exhibit D, which was just admitted. This is the gel torso work that you're doing,
Yes,
and that's for this case specifically.
it was for this case, yes.
And that relates to a female gel torso, is that fair?
A attempted model of a female torso, yes.
And the image shows that it's being impaled by a model corn rake, is that fair?
A purchased corn rake, yes.
And that corn rake was used to be of similar shape or spacing of the tines as it relates to the one at issue in this case?
Yes,
So when the impaled wound trajectory is done on the gel torso here, that's to mirror the initial strike or the initial fall, as you would say, for Ms. Mullis?
yes, it was to try and replicate or demonstrate here wound A,
And it was wound A, if you recall, the one that came out the other side of her chest?
yes.
Your report nor any of your data collection references her range of motion, though, correct?
Her range of motion?
Correct.
No,
It doesn't factor in as more of a dynamic variable, whether or not, I guess, the range of motion of her shoulders or arms, fair?
does not talk about what her range of motion is.
In fact, your report doesn't evaluate what would be necessary or how she would be able to remove the corn rake at issue here by reaching behind her. Is that correct?
So you're just grabbing the rake, you're not trying to grab the tines, but I don't,
So in the theory in question here, your posited way that this occurred, Ms. Mullis reached behind her and removed the rake. Is that correct?
she did not remove the entire rake, no.
But she was able to generate enough leverage or force to remove part of the rake. Is that fair?
That's what happens when you grab the rake handle, which is essentially right at her buttocks. So just reaching, touching, even scratching your hip.
After it had gone through her full chest cavity.
Yes, that's I showed you in that previous diagram.
But you didn't evaluate her range of motion specifically, correct?
Your Honor, I don't know that the witness had finished her answer.
There's a question pending. The witness can answer that. Please, counsel, just let's try to let the witness finish her answer before you ask your next question.
Is that okay?
Sure.
Okay, so as that diagram previously showed you, when the rakes are lined up with the horizontal trajectories. The rake handle essentially is against her body or against her buttocks. So essentially you're just kind of scratching. You can reach back and grab it, it's touching you. And pulling it in that manner of the second diagram where you grab the rake to or reoriented, that essentially, because the rake is stiff, it creates a leverage to pull out one of the tines. And the time that it pulls out is not deep, relatively speaking. That's why A and B stay in.
Is range of motion an important factor as it relates to biomechanics?
It depends. If I'm talking about a gymnast and someone doing, a splits or something, but this is not what we're talking about here.
Is it a relevant human factor as it relates to the evaluation as per the sources you've included in your report?
It wasn't something that was questioned because I don't have information that she worked on. She's a manual laborer. She was doing manual labor that day. She can reach down and
So you
tie her shoes. So
I apologize. And I understand that, but you didn't evaluate from whether or from what perspective the ability to reach behind her or her range of motion to be able to reach or contract, correct?
it did not seem like a far-fetched ability to be able to reach back and scratch her hip.
Despite it being an instance where she was already impaled.
Yes, it's essentially touching her against her buttocks.
Despite one of the wounds coming through her chest.
So she's grabbing, yes, she can reach back and grab the handle. It's just right by her body. It's not in some obscure, 10 feet above her head kind of location.
Well, you would agree that there would be some force necessary for her to generate, to be able to pull it out of her body after being impaled through and through, right?
Yes, that leveraging, again, grabbing the handle and pulling it down by her left hip and the handle forward, that creates leverage, which causes time 3 to come out.
But you would agree that there's a calculation or a way to evaluate leverage as it relates to the human body, right?
I don't need that. That's not necessary.
But my question was that there is a way in biomechanics to evaluate that, correct?
You can evaluate torque, sure,
And you did not include any mention of torque as it relates to her ability to rotate, correct?
because it's unnecessary.
And yesterday, though, when you testified, I believe, you mentioned torque and the ability to twist and the inability for, you disproved whether or not she was able to push the rake out, is that fair? Or I'm sorry, or pushed onto the rake, is that correct?
I'm not quite sure what you mean. You have to clarify for me, please.
You testified yesterday that you considered the hypothesis as to whether someone pushed her onto a rake somehow, and you said you disproved it. Do you recall that?
Yes, if they forcibly pushed her, yes.
And you said because of push on the shoulders, it wouldn't be a possible solution or scenario here because of torque and twisting, and it would flip the rake.
Because of rotational acceleration and horizontal velocity.
But you did not include that scenario as it mentioned in your reports either, correct?
I did not write that in my report.
And so when torque was relevant to disprove a hypothesis, it was a relevant consideration?
I didn't need to calculate it. What do you mean?
How would it flip the rake?
Because the rake is top heavy, and when you have horizontal motion and rotational, when you impact the rake in that position, it's going to cause the rake to flip upward, meaning the handle comes up to the ceiling.
Even when the handle is flush against the ground?
When you impact that rake with that kind of force, that kind of horizontal and rotational motion.
Well, I guess I'm confused here. So she can fall back onto it, right?
Yes,
But she can't be pushed with equal force at the shoulders onto that rake and caused to fall on it.
so again, this is talking about a push, an external load applied to your top of your body. When you fall from standing height, you don't have an additional external force applied to the top of your body.
So here, let's talk in the hypothetical then. Let's say equal force was applied to both shoulders at the top part of a person's body. Oh, I apologize. Let's say equal force was applied to both shoulders by an external force, or a person, let's say, to the top part of their body, causing them to fall backwards. Would that flip the rake?
So this is an aggressive push that would generate a horizontal and rotational acceleration.
But merely falling back on it in the presence of an object, causing it, say, an auger, wouldn't cause that imbalance?
No, again, this is not a external force applied to the body above the center of mass, forcing it to horizontally travel and rotate.
And those calculations, again, aren't in your report or in your notes, right?
They're unnecessary. I don't need to calculate that.
Well, there is nothing documented noting you considered that from a perspective of a hypothesis to rule it out if you were just reading your report and notes, correct?
That is correct.
So going to, again, demonstrative J. This is something you created, correct?
Yes,
And this would be the likely wound scenario of A, B, and C per your testimony in 2D format, right?
ND,
In D, in the two-dimensional format, right?
in the two-dimensional format, that is correct.
But, so this is your probable statement as to what occurred here.
This is what happened. She fell on the rake.
If I rotate this image 180 degrees,
Sure.
does this not supposedly generate the same injuries in question?
Yes.
It does.
Well, you have to look at force, but that is the mechanism.
Strength is a component of force evaluations in biomechanics, correct? One's strength when acting upon an object, for instance.
Yes.
Did you test or have any outside information about Mr. Mullis' strength patterns or
No.
his ability?
No, that's why I use the maximum forces available, so such as a push in literature.
And again, despite it not being documented there, taking you at your word for that, what is his maximum strength ability?
So and again, it's in literature, the very maximum reported force for a two-handed push for males is reported in literature.
What is that?
It's 138 pounds.
How many pounds of pressure or force are required to be exerted to puncture the skin?
For one time, is that your question? So one time for skin on the back is approximately close to 75 pounds.
So one time in this instance, Mr. Mullis would have the force capabilities to be able to puncture the skin one time.
With a push, but we know that the rate can't be entered one by one to cause this injury pattern.
What's required for 4?
Well, it's 3 that goes in,
What's required for 3 then?
and you consider the clothing. If you consider the clothing, then we're up near between 300 to 340-ish, depending on the conservativeness.
And again, what was his strength pattern or ability that you say you considered at a maximum scenario?
138 pounds for a two-handed push.
And does that evaluate any sort of measures like, I believe, something more dynamic like acceleration?
Yes, that's what we talked about. That is an accelerated push.
I'm sorry, an accelerated fall combined with it too.
So the fall actually, what do you mean an accelerated fall? So talking about a push, if you're pushing someone over, this is an acceleration, not just a static push. So we talked about having the rake against someone's body and you're statically pushing it at a constant pressure, or you're applying acceleration. So when you apply acceleration, it's a more severe scenario. So that scenario has a maximum two-handed force of 138 pounds,
And what would be required if constant pressure was applied?
less than that.
So less force would be required.
Less force would be required to puncture, that would be generated. Less force would be generated when you apply a constant push.
So it's your testimony that if Ms. Mullis was, say, face down on the ground, for instance, and someone pushed the corn rake into her back, that's not possible.
You would not penetrate the clothing and the skin, no.
And you hold that opinion to a reasonable degree of certainty?
Absolutely.
You also, though, didn't factor in her other wound patterns, correct? I believe yesterday you said you were only retained to consider the penetration wounds specifically, right?
I was asked to focus on them because there are explanations for the other wounds.
Well, you provided no explanation in your report for anything else, right?
Right, I was asked to focus on the penetration wound.
So you didn't consider it from the perspective of the wounds on Ms. Mullis's knees, hands, or chin?
Right, so actually if they fit my scenario. So going up on her knees, trying to extract the rake, being on a concrete gravel type ground as in the shed is available, that would generate the mechanism to cause those injuries.
Just pushing onto her hands and knees.
Well, crawling, she's crawling.
And the strike on her chin, how was that caused?
So again, that was from Dr. Hammers and to discuss.
And I believe, though, the standards for biomedical or biomechanical evaluations say that you're supposed to accept the treating physician's diagnosis?
That I do not, I don't diagnose and treat, therefore I don't dispute diagnosis.
I apologize. In your report, I believe it's noted specifically that you're supposed to look to the treating physician or treating provider's diagnosis. Is that fair?
That's usually where the wound pattern is, but autopsy, you're not treating anybody because they're gone. It's the medical professionals that I'm looking for that provide a diagnosis.
Just to quick summarize your evaluation and opinions here as it relates to this instance specifically. Your calculations are not noted in your reports.
The conclusions of my calculations are in my report.
I'm asking about the facts and data that would lead you to those conclusions are not specifically enumerated in your report. Fair?
So the calculations, the foundation for them are included, and the conclusions are included.
You took no measurements specifically of the location or space?
Because it had changed, and I had a diagram from the police department right after the incident.
And you did not document specifically, you're assuming that the rake where it was discovered by law enforcement or noted by law enforcement was in fact where the rake was to begin?
No, I did not assume that. I had no other information to indicate that the incident happened anywhere else other than the shed.
Despite knowing that the rake had been pulled out by Mr. Mullis, right?
Because that was what's available information, that the incident happened in the shed, but even if it didn't, it wouldn't change my opinions.
The location inside the red shed where the incident occurred and the physical limitations of the space wouldn't change your opinions?
If they happened elsewhere outside the sheds, that would not change my opinions. I'm not exactly, maybe I'm confused at what you're asking. It seems like you're questioning whether the incident happened in the shed, and I'm just a little confused by that question.
If the incident did not occur in the shed, would your opinion change?
No,
And if the location of where the incident occurred wasn't near the pet carrier, for instance, would your opinion change?
no, because it's again based on the physical evidence of the injuries and the rake. Everything else is supportive.
So no environmental condition would change the opinion of your statements here?
I'm saying that I considered the spacing, but even in that limited spacing where I know that a lateral swing can't happen, I still analyzed it. And I analyzed an overhead and I analyzed different positions. And all those positions can happen in a location other than the shed. So I considered alternative locations as well. But what comes down to it is the physical evidence and the, including the rake and the injuries themselves.
With the assumptions that you knew where it occurred in the shed, or no?
There's no assumptions here.
Yesterday, I just want to confirm, your testimony was that you can't analyze every scenario or every incident in a case. Is that correct?
That would not be reasonable to do. Again, there's, like I said yesterday, there was no information that there was a trapeze available. You know, if there's something that gives me more information, I'm happy to analyze that scenario. It's my job as a neutral party to consider, analyze, and evaluate new evidence.
And the last thing I want to talk about, I understand the statement was that you're salaried by Robson Forensic, true?
True.
But you've been compensated by Mr. Mullis' team or the fund for which is providing for him?
No.
You've received no compensation?
My salary stays the same whether I'm here or not.
Well, I will re-clarify. How much has Robson Forensic been compensated to provide for your testimony and your ability to be here?
I have no idea.
What's your hourly billable rate?
I think it started at, I believe Robson billed me out initially at $640.
And that's $640 an hour?
That is correct.
And based upon an estimate even, how much has Robson Forensic been paid for your testimony here today? How many hours of work have you conducted?
I have no idea.
You have no rough approximation of how much work you've done in this case?
I do not have an idea of the number of hours or the amounts. I have a lot of cases and those are not things I keep track of. That's something accounting keeps track of.
Well, my understanding is that you bill your time and enter that time to be billed, correct?
Yes, if you would like Robson, you can ask Robson for that information. That's completely fine. I just don't have it on memory right now.
And you don't have any approximation of the hours?
I mean, it definitely more than 10. I mean, but I don't have I didn't count.
Is it $640 an hour to have you be present in travel for trial, for instance?
They bill me hourly, flat rate, yes.
So you being here present for trial over the course here, I believe we had previously discussed that you've been here since Sunday, is that right?
I arrived Sunday night.
Since arriving on Sunday night, have you been, do they bill for every hour you've been present, or how does that work?
No, I bill for time that I'm in trial.
So for the rough 7 hours or 8 hours a day, you've been billed at $640 an hour by Robson?
So they bill me hourly and I bill for the time that I spend here, yes.
Taking you back to the investigation here, I believe you're present for Dr. Cruz's testimony, correct?
For the trial testimony, this trial testimony, yes.
And do you recall the noted absence of additional bruising or any sort of identified wound or mark as it related to the handle of the rake against Ms. Mullis' back?
You mean on her buttocks?
Her back, lower spinal column, lumbar spinal area, abdomen, etc.
Abdomen, I'm sorry.
I'm sorry, the backside of her oblique.
So
Her buttocks as well, yes.
her buttocks land on the handle.
What was that? I'm sorry. I
Her
didn't...
buttocks land on the handle, which prevents it from flipping.
Was there any mark noted during the autopsy, to your recollection or knowledge, to her buttock or back of her leg?
I would not expect that there be a buttock mark, bruise on her buttocks from landing on the handle.
Do you recall of any noted abrasion or other marking on her lower back?
No,
Would you expect, like you had testified earlier as it related to abrasions around the wound patterns, for instance, there to be any marking or indication of laying or falling on the handle of the rake?
so her buttocks that contact the rake, and I would not expect an injury there.
In this scenario, though, her buttocks would have hit.
I thought they said the rake handle was over her head, not down by her butt. Am I remembering that wrong? Or is this a hypothetical?
The concrete as well, correct?
Right, a distributed load, so the handle and the concrete.
And her arm, I believe, as you mentioned, which the location of where her arm would fall would potentially show some sort of injury to her elbow or the back of her arm. Is that fair?
I mean, I think the state has said this witness can't provide, medical diagnoses. I think that's what they're asking her to provide.
Sustained.
I don't have anything further.
Any redirect?
I do have some redirect, Your Honor. Dr. Knight, you were asked whether you testified in a criminal case before. Is there a different set of engineering principles that you apply to an insurance matter versus a criminal matter?
No.
Are engineering principles the same regardless of the type of client who's asked you to look at a particular situation?
Nope, they're all the same.
You talked a little bit about the investigation that you yourself conducted to perform a site visit at the shed in this case.
Yeah, I did a site visit of the farm.
Of the farm. When did you go to the farm?
I don't remember.
Would you rely on any information in your report about when it was that you conducted a site visit? And let me ask you about a question. Would looking at your report refresh your memory about when you conducted a site visit?
Let me take a look.
Let me direct you. We'll see who gets there first.
Oh, September 18th, 2023.
Does that sound right?
Oh, that's the clothing.
Yeah, okay.
June 30th and July 1st, 2023. That's in my report.
And when is it that you looked at the clothing in the rake in this case?
September 18th, 2023.
And is that when you took photographs of those objects as well?
Yes.
You were asked a number of questions about information that's in your, and I'm gonna have while I'm asking this question, I'm gonna have our colleague plug back in our computer here. You were asked some questions about information that's provided in your notes versus in your report, and without publishing this document. So I'm gonna ask my colleague to turn the television off for a second, just so we have a clear record of what the document we've been talking about. I'm gonna show you what we've marked as Exhibit 976. And I know there are witness that the document that applicant has marked as 976, just what that document is. So without publishing this document, I'm just going to ask you.
And right now, just the witness and myself can see it. It won't be displayed on the big TVs.
Correct, Your Honor. That's what I'm seeking to do.
I see it.
All right. I'm going to have my colleague just scroll through what's on the monitor in front of you. And the question I'm going to ask you is if the document that appears in front of you that's been marked as Exhibit 976 is a complete copy of your additional notes that you provided related to your work in this case.
It appears to be, yes.
All right. And if you need to count these pages, you can, but if I represented to you that that's a 14-page document, does that sound correct to you?
Yes.
Between your reports and Exhibit 976, do those, and I guess your two reports. So between your two reports, let me start this question again. You have photographs that you have provided in this case reflecting your inspection of the clothing and the rake. Is that correct?
Yes.
And did you take photographs that included a ruler in them to measure, that demonstrated your measurements of the tines and the length of the rake and the tines of the rake?
Yes.
So you have photographs that show those measurements. Is that right?
That is correct.
Okay, and you took photographs that documented your understanding of her clothing, is that right?
Yes,
You provided photographs, you provided those photographs as well as the notes that we've been describing that are Exhibit 976, is that correct?
yes,
And then you have your 2 reports.
yes,
And that is all information that you made available to council to provide to the state, reflecting your opinions and the bases of your understanding of the information in this case?
yes.
Just briefly, since 976 is still in front of you, I'm going to have my colleague direct you to the last page of that document, which is page 14.
I'm here.
All right. You have a references section on the last page of 976.
Yes,
And I think you were asking questions about reference 5. Is that a complete citation for the reference material that you're alluding to in reference 5?
well, I didn't allude to it. I stated it. But all my references are complete, even with page numbers.
I appreciate that clarification. If I was going to go to a journals database, a medical journals database, using the information you've given for reference 5, I could pull up that article.
Objection moving.
I'll withdraw the question, Your Honor.
Okay.
Using the information that you've provided for reference 5, could you pull that cited reference up in a medical journals database?
You could, but you can just go to Google. If you just type in Nolan and then forces generated, it would pop up. It's widely available to the public.
Is that true for the other references that you've identified on page 14?
That's why I provide complete citations so someone can go get them. Anybody can get them.
You were asked some questions about torque calculations, about the torque, about the consideration of torque in pulling out tine C while pulling a tine out of wound C while tines of this rake remained in A and B. Do you remember those questions?
Yes,
Why is it that you did not need to do a calculation for torque in making that determination?
because we know it came out. That has to be out to be able to make wound E and F. So that third tine 3, has to come out to be able to make wound E. I didn't need to question whether or not it was out.
You were also asked some questions about why you did not conduct experiments on Ms. Mullis's clothing. Why did you not conduct any experiments on her clothing?
So when you say experiments, that's a little confusing to me because I think for people not in my field, when you think testing or experiments, it has to be physical, like you're breaking something or, doing something. But looking at the holes, considering them, looking at the location, comparing them to the wound location, that's all part of the investigation process, which is essentially a whole big experiment.
Under your definition of an experiment that you just provided, did you give consideration to the properties of Ms. Mullis's clothing in reaching your opinions here?
Yes, absolutely.
You were asked some questions about the shed at issue in this case, and I want to show you a photograph that we looked at that has been admitted into evidence, Your Honor. You can. While my colleague's doing that, because I want to keep us moving, let me ask you about another issue, and we'll come back to that when it's ready. You were asked some questions about the medical diagnoses in this case, and just some general questions about Dr. Cruz. So I want to direct your attention back to those questions. Did you rely on the information that was provided by Dr. Cruz as to Ms. Mullis's injuries in this case?
Did I rely on Dr. Cruz for the injury pattern?
Yes.
Yes.
Were you in giving your opinions, were you disagreeing in some way with what Dr. Cruz said about that issue?
That is not my role. I don't disagree with medical diagnoses.
You were asked some questions on that issue specifically about the chin injury that there was some testimony about with both Dr. Cruz and Dr. Hammers. Were you present here for their testimony about that issue?
Yes.
Did you hear some testimony from Dr. Cruz that the injury to Ms. Mullis's chin could have been caused from falling and striking an object?
Yes, I heard Dr. Cruz say that. Yes.
Is that testimony in some way inconsistent with your opinions in this case?
I mean, it's not consistent or inconsistent.
Are you here to offer opinions one way or another about Ms. Mullis's chin injury?
No,
And has any of the testimony that you've heard about that chin injury as between Dr. Cruz or Dr. Hammers, does any of that contradict your opinions in this case in some way?
no, not at all. Yeah, when I talk about injuries, it's about mechanism. I don't diagnose.
I think we have this photograph up that I asked you about a second ago. And just for the record, what exhibit number is this? 311. All right, so I'm showing the witness what's been marked as 311. The photograph that you're looking at, this exhibit 311, is that a photograph that you took, Dr. Nye?
I don't think so.
All right, and do you recognize what's depicted in photograph 311?
What's depicted is the dog or pet carrier that it was claimed that Ms. Mullis was going to retrieve in the shed at the time of the incident.
Is there anything about the way that the shed appears in exhibit 311 that contradicts any of the opinions that you've provided in this case?
No, absolutely not.
Did you rely on, I think you can take this exhibit down now, did you rely on the photographs and descriptions of the shed as it appeared at the time of the investigation into Ms. Mullis's death in reaching?
I was muted. Oh my God. Thank you for telling me that I was being an idiot and was muted. Okay. So I start over. If the rake handle was sticking up, if you're going to go hit somebody in the back, if they're standing with their back to you, you're going to swing, the rake handle's going to be down. So they would have to be bent over and you would come toward them and swing like that. And then they would fall face down and then the handle would be sticking up over their head. That would be the only way the rake handle would be sticking in that direction from somebody hitting you with it. Because if you're going to come up behind somebody and hit them with a rake, the handle's going to be down. But the way she's talking about her experiments and stuff is that the rake handle was down by her butt. But I could have sworn I heard somebody say that the rake handle was above her head. Do you guys remember that? I do know. The only other thing I watched about this, I watched a 48 Hours episode. Because I didn't watch the original trial. So I might have heard that on the 48 Hours episode and not in this. So I could be wrong about that. But I thought they said it was above her head. So how do you get that way unless you're bending over and someone comes towards you and swings it down into your back while you're bent over? At some point, we're going to have to watch this original trial. Because I can't imagine how this happened. Either purposely or accidental. I'm so confused. Maybe we should have watched that other trial that's going on right now. Okay. But like I said, it's not hard to confuse me. I'm very easily confused.
Your opinions.
They were supportive of my opinions.
I mean, you were not assuming that the shed appeared the way it looked when you visited the site.
No, I don't. I don't make assumptions, and no, I did not do that.
You've been asked a number of questions about your calculations, and a couple additional questions I have on that topic here in reaching your opinions.
Objection, relevance, and speculation.
This goes to whether her methods are repeatable in her field, Your Honor. That's maybe an artfully posed question, but that's the issue I'm going into briefly.
With that clarification and narrowing of the question, the witness may answer.
Sorry, could you read that back? Thank you.
You've been asked a number of questions about your calculations, and a couple additional questions I have on that topic in particular. Could another expert perform the kind of calculations that you performed here in reaching your opinion?
Yes, absolutely, and they did.
Are these methods are the methods by which you performed your analysis and perform these calculations, are they accepted in the field?
Absolutely, yes.
And specifically as to your discussion about clothing, the concepts that you relied on here of the tear force of clothing and the tactical strength of clothing are the methods by which you consider those issues generally accepted in the field of biomechanical engineering?
Yes, absolutely.
Okay, you were asked some questions about this gel torso, and the photograph's not up, but do you recall the photograph that you were showed by the state as to that issue?
Yes.
First of all, does anything about that photograph contradict your opinions that you've testified about here today in any way?
No, not at all.
And I just want to note for the record, it looks to me that you are looking at a copy of that exhibit. So if you're relying on it to answer the questions, I just want to make sure the record's clear since you have it there. The particular gel torso that's depicted in the state's exhibit, why is there a reason that you did not use that gel torso to illustrate your testimony today?
Objection, Your Honor, based upon our prior motion practice and history. We're happy to approach the bench if that's easier. But certainly the question calls for something that has been the subject of much litigation and motion practice previously.
Well, obviously, I'm assuming of why the gel torso isn't here. I don't know that. I guess, Ms. Thompson, what kind of record do you want on this? Again, this is a bench trial, not a jury trial. I'm aware of what the procedural history is. Do you want some additional record at this point, or?
I do, and I'm happy to do this in front of the witness because I think this can be brief, but honestly, it was confusing to us to have it marked as an exhibit because it was our understanding that the issues here are what they are. And to the extent that I'm not trying to lead the witness, but you've asked me, so the court's asked me, so I'm going to answer. I mean, I think there's been a suggestion in the questions that somehow this object contradicts the opinions that the expert has provided here, that Dr. Nice provided. And so I think some explanation to clarify that issue is necessary for us to make our record. I think the history of this object is well documented, and it's not our intention to dispute, obviously, the pleadings that have been made, but I think there is additional information that goes to the issue that we didn't raise, that the state raised.
Your Honor, if I may.
Go ahead.
We can read back the specific question if we'd like to, but my understanding was the question was, why didn't you use this specific gel torso? Or what was the specific question may be important here, but the reason the specific gel torso wasn't used in the litigation after this portion has been held out to be not a scientific issue at all. As the court knows from our prior litigation, that's certainly been disputed.
Well, Ms. Thompson, if it is helpful to you, for me to tell you at this point that I didn't find anything with regard to Exhibit D to contradict the earlier testimony of this witness. I think we can just move past that in terms of where we're at.
I appreciate the court making that a record. And I think for us, obviously, we want to represent our client zealously. We want to make sure we've made our record. Obviously, if that's I think the court has given us some direction in terms of how it is viewing this evidence, and with that understanding, I agree that we can move on.
Yeah, I'm looking at my notes, the questions that were asked with regard to Exhibit D. That's where the questions about evaluation of range of motion, things of that nature were asked. I mean, yes, certainly if you want to ask some follow-up questions about that topic, that's fine. But specifically with regard to the use of gel torso, I don't think there is any need or reason to follow up on that. That particular topic is not going to be useful to the court in making any finding of fact.
I understand, Your Honor. And obviously, again, we want to make sure that we're representing our client in the way that he deserves to be represented. I have two other questions about gel torsos more broadly, not this particular gel torso, that I'd like to ask. And I don't intend to disregard what the court just said. Again, I want to make sure that we're doing what we need to do for our client, Your Honor. But obviously, there may be an objection to this question, but I don't believe it's covered by what the court just told me.
Go ahead.
From an engineering perspective, in terms of the force calculations that you've been testifying about here today, Dr. Nye, does a gel torso accurately represent the human body?
As far as force is concerned, no.
Correct. As far as force is concerned?
No.
One moment, Your Honor. Just one moment, Your Honor.
Sure.
Sorry, magnitude of force. Let me clarify.
Well, and just to follow up, because I appreciate that question. When you're talking about magnitude of force, are you talking about the forces that would be required, the amount of force, the magnitude of force that would be required as to the issue we've been talking about, the ability of a corn rake to enter the human body?
Right, I would not use that for magnitude.
You were asked a number of questions by the state on cross-examination. Do any of the questions that you've been asked by the state here today change the opinions that you've offered about the hypothesis that Ms. Mullis's injuries were caused by her falling on this rake?
No, if I had no other hypothesis, and that was the only one I tested, everything fits that hypothesis. It is proven.
All right, no other questions, Your Honor.
Mary Cross.
Just briefly, Your Honor, if I may. Drawing your attention to what is reference number 5 for the article, you stated just on redirect that you could pull up the case of Nolan, Hainsworth, and Ruddy forces generated in stabbing attacks just by Googling it, right? Well, I will tell you that we did Google it in permission to place it on the screen, Your Honor, to work with. Is this the article you referenced specifically for the notes and proposition that you evaluated kick and force injuries that were not related to falling or swinging?
Sorry, I've lost my page. This is, so if you scroll down, let me just see here. Keep going. Keep going. Keep going. Keep going. So hang on one second. Yes.
This is the same article?
Yes.
Drawing your attention to what is Table 2.
Yes,
Do you see Table 2 in front of you?
I do.
In the actions evaluated included a button push, push, slap, and punch, correct?
Correct.
Did not include a kicking or kneeing or any sort of exertional force by what we've talked about here previously, right?
Right, and I didn't evaluate kicking for magnitude, as I discussed.
So this article does not support your proposition that it wasn't kicked or otherwise forced into her body in some other manner, for instance.
Objection, Your Honor. The question is vague as to kicking or other force. I'm not sure what we're talking about.
Would you like to clarify, Mr. Duden?
Along with kicking or forcing into Ms. Mullis's body, the other proffered aspects of your hypotheses testified to today, those are not evaluated according to this article, correct?
So this article was for the two-handed push. The kicking, as you recall, I talked about mechanism of injury. So it wasn't a magnitude discussion.
This article doesn't cover the stomping either, though, does it?
No, I wouldn't, but it's not related to the specific position that Ms. Mullis was in at the time of the incident, so it wouldn't list that.
And scrolling down to, well, I think if we did a control find on this, do you believe this article references clothing specifically?
Can you go up?
Sure.
This one, I can point to the clothing ones if you want.
But it's not this article?
Can you move up a little bit? Let me just review before I speak to it. Can you start at the beginning? I'm sorry, and then, thank you. And then scroll slowly. I'm sorry, I can't do it myself. Yes, keep going. Thank you so much. Yep, keep going. Keep going. Thank you. Trauma, stabbing, keep going. Keep going. Keep going. Keep going. And keep going. Perfect. Yes, I confirm that this was not one of the ones. I just wanted to make sure it's not the clothing ones, but I have clothing ones listed.
And then based upon your testimony here today, is it your testimony that you were able to differentiate the degrees of force at issue here by looking at the wounds and their depths or the aspects of the wound injuries sustained by Ms. Mullis?
So location of wound, knowing it's on her back, and understanding that it's a tensile overload.
So it was just merely looking at the wounds and the depths and information provided to you on that front?
So again, clarifying your question as I understand it, the magnitudes are considering the location, the diagnosis of the wounds, as well as the instrument being a blunt object.
And that's based upon the appearance and photographs and the information provided to you by Dr. Cruz and ultimately Dr. Hammers as well.
Yes.
Looking to the discussion section of the same article here, and beginning with the paragraph of, thus based on both of the results of both experiments. So beginning with this paragraph, thus based on the results of both experiments, in the case of a wound tract involving skin and organs only, applying a subjective scale of mild to moderate to severe force in an attempt to suggest to the court that one could differentiate the degrees of force by simply looking at the resulting wound is inappropriate. All that can be said is that minimal force required for a particular implement to breach the skin and cause injury to the skin and soft tissue only has been met. Did I read that correctly?
Yes.
So here, the conclusion by going off of the appearance of the wounds themselves, we can't really say more than the minimal amount of force that would be required to penetrate it, correct? Based on this article's guidance.
Which is what I use. That's why I use a conservative value. So I use the minimum force. And then I use the blunt instrument cross-sectional area. That's exactly what I did.
I don't have anything else, Your Honor.
One question.
Go ahead.
If at any point in any of your work in this case, Dr. Knight, have you have you relied on the idea that you, in your evaluation, can differentiate degrees of force simply by looking at a resulting wound?
I'm sorry.
Sure, I'm going to ask that question in a
That's a
better
lot of
way.
words.
Does your analysis differentiate degrees of force by looking at the wounds that Ms. Mullis had?
That wasn't what I was doing. That paper talks about measuring force if you, depending on how severe the attack is. That's not what we're looking at. We're looking at forces necessary to penetrate.
You didn't reach conclusions about the force that was at issue, that could be at issue in these hypotheses just by looking at the wounds that Ms. Mullis had. Is that right?
Again, I rely on the diagnoses. So looking at the minimum force and the maximum, say, push, then I'm meeting both ends. So if I take the maximum and I take the minimum and it still doesn't meet, then anything after that is met, essentially.
Were your conclusions on that issue based on your full investigation and analysis, and not just looking at Ms. Mullis's injuries?
Oh, it's a complete, like, yes, the engineering investigation takes a lot of time and consideration and the scientific method that we talked about.
All right, no other questions, Your Honor.
Anything further?
No, Your Honor.
Thank you, Dr. Nye. Counsel, do you need to address Exhibit 976 before the witness is gone, or is that something that she can be released for?
Your Honor, we sought to admit Dr. Nye's reports, and I think there was an objection to that. And I think this issue relates to, the issue about these notes relates to that concept. I think we're seeking to admit it based on this testimony in that respect, but I don't think we need further information from the witness, and we can take that issue up at the appropriate time.
Okay. 285, I think, was the other exhibit.
I believe that's right, Your Honor.
Yeah, okay. All right, so normally I would say this would be a good spot for our afternoon break. Do we have another witness today?
We do, Your Honor.
All right, let's go ahead and take about 15 minutes at this point. We'll plan on picking back up at 3:15.
James Krogman, 1810-200.
Ms. Nichols-Cook, are you ready with your next witness?
Yes, Your Honor. Applicant would call Tom Krogman.
Okay, Mr. Krogman, if you're ready, you may come forward. Have a seat in the chair to my left, please. And if you raise your hand, you swear the testimony you're about to give will be true and correct. All right. If you turn the microphone in front of you on, please, there's a button in the bottom center. There you go.
Did I get it? There we go.
Oh, I think I have it.
Hi, Mr. Krogman.
Hello.
Can you state your name for the record and spell your last name for the court reporter?
Thomas James Krogman, 1810 200th Avenue, Manchester.
Okay. And how do we spell Krogman?
Krogmann.
How long have you lived in Delaware County?
62 years.
Would
Forever.
that make you a lifelong resident?
Yeah,
What do you do for work or employment?
I'm a farmer.
What do you currently raise or grow as a farmer?
Corn and soybeans.
Have you raised livestock in the past?
Yes,
Did that include hogs or cattle?
both.
Are you familiar with when farmers in Delaware County typically plant crops?
Yep.
When is that?
Last year it was in April till someone's the middle of May.
Is it generally spring?
What's that?
Is it generally in the spring?
Yes, excuse me. Yeah. It was a really nice year last year.
Is it dependent on the weather?
Right.
When farmers are planting crops, how long are they in the field most days? In your experience?
Sometimes 24 hours a day.
When you plant crops, do you have Wi-Fi in the fields with you?
My cell phone? Yes.
Do you have anything else?
Guidance systems on equipment?
And that would be data plans and things that you pay for?
Yes.
Do you know approximately how many years you had livestock?
Probably all of 30.
And are you familiar with farm equipment?
Yes,
Do you also repair equipment?
absolutely.
I want to ask you about a couple of things, and I have a couple of pictures to show you. The first one is going to be Exhibit 265. It looks like the TV went off.
It's like mine at home. Never works.
Where
Have
did
you
they
seen
get
anything
this
here?
guy? Is he
Yes,
a
I got it.
friend of the
Yes, correct.
defendant or what?
What is it? What is on the screen?
We call that a corn fork,
Corn fork.
corn rake.
Do you use those terms interchangeably, corn rake and corn fork?
Yes.
What is it for?
It's for raking your corn out of a crib, or it's just handy to have. It's like I don't know, it's like an extension of your hand a lot of times. You can reach out and pull lumber, bedding, whatever.
Have you used it to clean out a chicken coop?
No, I've never had chickens, but I've used it in Verone houses and stuff like that.
And is it a familiar or common object to see around a farm?
It's kind of like an antique. I mean, it's not nothing you'd use every day type thing. Grandpa had it, it's hanging on the rafter, and it's just a cool thing. You don't get rid of something like that.
Would you consider it a dangerous item?
No,
Would you consider it a sharp object?
I don't know. I never really considered it, I guess.
Would you want your grandchildren to stay far away from it?
I'm pretty sure I got one laying around, and I'm pretty sure they probably messed with it.
Okay. So you don't take any special precautions
No,
regarding that?
no.
We've talked before you got here about augers. Can you tell us a little bit about what is an auger and specifically a sweep auger?
Well, it's a shaft with a spiral flighting on it that has usually a drive on the end that pulls your material to the motor and to the front. Let's say you're moving grain into a sump in an auger to load out. At the end of the bend, you would use that. Or silage, you would transport it from one place to another.
Where would you store an auger, a sweep auger?
You know, you should put them inside, but usually they're not.
When you say inside, you mean like in a barn? Or
Right, yeah.
Are they stored on the floor typically?
Yeah, they're heavy.
Heavy?
Yeah.
Have you ever stepped on one?
Oh, yeah.
What
I'm sure. Well, when it's running, oh,
No, when it's laying on the ground or in a shed.
I can't really say anything happened. Slip
Would-
probably.
Would parts of it move?
Oh, probably so. It's bearings on each end and belt drive to a motor.
Okay. Next, I'm going to ask that
Hi,
we
Carla.
311, which we looked at earlier today, to make sure that you and I are talking about the same thing.
Yes, I have it.
Okay. I have this. I apologize. I can't see what you're looking at. Okay. Mr. Copeland, can you see a photo on your screen?
Yes.
Do you know what that picture is depicting?
I see a pet carrier and augers. Looks like sweep augers on the floor. Looks like some totes in the background, and I'm not quite sure what the thing is painted camouflage is. I can't really say.
Okay. And when you were just talking to us about sweep augers, that's what's also in that photo?
Right. Mm-hmm.
Do you know Todd Mullis?
Yes.
When did you meet Mr. Mullis?
I don't think he was old enough to drive yet.
So you've known him for a long time?
Yeah, I think he maybe is 14 or 15.
Okay. Are you familiar with other members of the Mullis family?
Oh,
as well?
yes, absolutely.
Would you consider your family and their family to be neighbors or friendly?
Yes.
Over the years, what types of things would you and Todd do together?
We did a lot of hunting together. We went kayaking, cookouts in the timber. I don't know, just things farm guys do, I guess, you know. Had a few beers here and there, you know.
When Todd married Amy, were you at the wedding?
Yes, I was in the wedding.
Did Todd and Amy bring their kids around camping or to barbecues with you?
Yes.
Have you ever seen Todd get into a fight?
No.
I want to kind of orientate you to like 2018 and that fall. Were you still in regular communication with Todd?
Not very often.
Did you see him and did you talk to him about farm work?
Yeah, but I would say in the last, I don't know how many years, you know, life gets busy and we didn't get to hang out. We didn't, I don't know, he had his things going, I had mine. I didn't really answer your question probably, but.
Do you know if Todd was also planting crops in 2018?
I'm sure he was.
Do you know if he was harvesting?
Absolutely.
Do you know if he had a hog farm operation in 2018?
Absolutely. I was somewhat in touch with him, you might say. I knew he sold chemicals and just, you know.
When you talk about selling chemicals, are those also for farm work?
Yes.
And the picture you looked at, or the one that might still be up, the totes that you mentioned, are those for chemicals?
Yes. Mm-hmm.
Do you know if those totes are heavy?
Are the totes heavy? They weigh about 125 pounds empty.
Whoa.
I know because I use them for scrap iron and I got to weigh them back empty.
Gotcha. I want to talk now about November 10th, 2018. Do you remember what you were doing that day?
That was the day of the accident. I was, my son and me were about, I'm going to say, a half mile from my nephew's place. And we were loading scrap iron off a farm. And we seen ambulance, or not ambulance, we seen flashing lights to the east on 38. And we're looking, and I was like, well, wonder what's going on. And then a town officer, town cop, whatever, he flew by on the highway, which is way out of city limits, which was, we thought was pretty odd. So we grabbed the binoculars and looked, and we looked to the east where my nephew's place is. He's just building a house there, and we seen like, well, it looked like that's where the activity was. So we hopped in the truck and headed down. We figured, excuse me, there was a skid loader accident or something. They were building a house. You move a lot of dirt, debris, lumber, everything with loaders, whatnot. And you want the whole story?
Well, I'll ask you another question
Okay,
before there's an objection. What was the name of your son that you were with that day?
Michael,
Michael. And what is the name of your nephew who lived on 38?
Brian.
Brian. And so you and Michael both went down the road to where the squad cars or the deputy lights were?
Yes.
You said that you thought it was an accident. You knew Brian was building a house, and you talked about a skid loader. For clarity of the record, can you tell us a little bit about what is a skid loader?
It's probably the most awesome machine ever built. You can do anything with it. You move dirt, you can mow, mowers, backhoe attachments. There's nothing you can't do with a skid loader.
Can I call it a smaller tractor?
No, it's not.
What can I call it?
I've never heard them called anything else but a skid loader.
Is it a heavy machine?
Yes,
Um,
12,000 pounds probably.
okay. Is it something that you can take on the road?
Your Honor, I'm going to object. This is fascinating, but it's not relevant.
I guess Ms. Nichols-Cook, as far as the relevancy, is there some reason you think it's relevant?
I guess I'm trying to lay the foundation for why he expected there to be a skid loader accident and why he went there so quickly. So I could just ask him why he was worried about a skid loader accident.
Sure.
Okay. Mr. Krugman, when you thought there would have been a skid loader accident at your nephew's house, was that upsetting or alarming to you?
I don't really think it was either. It was just a matter we had to get there and fix the situation.
Were you afraid somebody was hurt?
Right. Or they would have called.
Could a skid loader accident seriously injure somebody?
Very much so.
Have you seen other skid loader accidents?
I've seen it with the same type attachment on tractors where same scenario, they're building a new house. The wife was down in the trench and the tractor didn't stop and it pretty much cut her in half.
Okay.
And I'm sure a skid loader did the same thing. You don't know. There's a lot of stuff goes through your head when it's at your nephew's place.
Yes, I'm
Really quick too.
Yeah. Have you yourself been involved in any accidents while farming or?
Yeah. Any one of those guys sitting back there been in an accident? Oops.
Are accidents common
Yes.
on a farm?
Yes. It's a dangerous job. I mean, we don't have to play by OSHA or any of that ruling, and we got so much time to get this done, and we just do it. And sometimes you lose a finger.
And do some people sometimes die in a farming accident?
Yes.
So when you got to Brian's property, what did you see?
I seen what looked like a car accident.
Did you recognize anybody?
I noticed Todd's truck.
Did you see Todd?
Yep, he was standing outside. Well, yeah, yes,
Did you see deputies?
yes.
Did you see Amy Mullis?
On the ground, yes.
Was anything happening to Amy at the time?
I think I don't know if they're doing the chest compressions or what. I can't say for sure.
Was EMS there yet?
I can't say for sure.
And did you speak with Todd?
No, yeah, absolutely.
And did you ask or inquire about what had happened?
Yes,
Have you been to Todd Mullis's farm before?
absolutely.
Are you familiar with a shed between the hog barns and the house?
The red shed, I've been in it. I don't know, 10 years ago, probably I bought a tote from him on a winter day. I needed a tote, but that's the only time I've ever been in the shed.
Do you have any recollection from that time you were in the shed, how much space was in it or what was stored in it?
It was full. I was just helping him out by taking a tote.
So the totes that you identified in the photo were in those type of totes?
Yes, yes.
At some point, did you learn that Amy had been found in that shed?
Yes,
And at some point, did you learn that there had been a corn rake involved.
Yes, I did.
Did that strike you as unusual or strange?
I'm going to object as relevance. This witness's opinion on whether that's unusual or strange is not relevant to the issues before the court.
Overruled.
You can answer.
Would you repeat it, please?
The information that you learned that Amy had been found in the shed and that a corn rake had been involved in her injury, was that a strange thing to you or a suspicious thing to you?
It was odd. I mean, anytime there's no common act, there's no normal accident. I mean, you've all seen accidents. You can't make sense of it. It's like, why did this happen? So, I mean, I don't know how I should answer that for you.
In your experience as a lifelong, member of this community and as a farmer, did you have any thought that this wasn't an accident?
No.
Object is improper opinion testimony.
I'm not asking for an expert opinion. I'm asking in his personal experience, just like if I asked a witness, how fast was that car going?
Objection's overruled. I heard an answer. Did you, Kelly? Yeah, it'll remain in the record.
Thank you, Your Honor. Did you learn at some point while you were in Brian's driveway that Todd had been on the way to the hospital with Amy?
Yes, I talked to Todd.
Have you ever had to drive a family member to the hospital that was injured?
Yes.
Why do you not wait for an ambulance to come to you?
That's not how we're wired. We fix stuff. There's no time to, well, I think, I don't know how many times I had to do it. Once I come to recollection with my brother, he was back in a timber. It was in the spring. So you couldn't even walk. It was so muddy. And he was unconscious and his leg was bent behind him, bleeding. There's no way you're going to get him out of there unless we did it.
So
And
in your experience, is it impractical to wait for an ambulance to get to you?
Yeah, there's probably scenarios where not, but in most scenarios, we fix stuff. We don't wait for nothing.
Was Todd with you the day that your brother broke his leg?
Yes, he was.
And did he help you take your brother to the
Absolutely.
hospital?
I think he rode in the back of the truck and held him down.
So on November 10th, when you're in Brian's driveway, do you see an ambulance come?
I don't recall seeing this. I guess I really wasn't paying too much attention to that part of it, because they were working on Amy, and I can't tell you if there was 5 squad cars there or 50 squad cars. I couldn't tell you.
Did you see Amy leave in an ambulance?
Yes.
Okay. Did you and Todd get in the ambulance?
No.
Why not?
Todd rode in with me because I think it was too full. They didn't have room for
Did
him.
you make any observations that you can remember about Todd's demeanor or his behavior?
I think he was in disbelief.
Do you know Tristan Mullis?
Yes.
Did you see him on November 10th,
Yes.
2018?
Yes.
Did you drive Todd to the hospital that day?
Yes.
Did you stay at the hospital?
Yes, I did.
Do you know where you went in the hospital?
No, some small room.
Would it be like a waiting room?
It could be, yeah.
Did you stay with Todd?
Yes, I did.
Were you there when a doctor came out and informed Todd that Amy had passed?
Yes.
Did you see deputies coming in and out of that waiting room?
Yes, I did.
Were you present for any conversations the deputies had with Todd or Tristan Mullis?
I don't think so. I don't recall anything.
Did you observe anything about the medical staff's behavior? Anything that you remember about how they acted towards you and Todd?
I'm going to say cold.
Did you feel that was that a concern to you?
Rolled off me pretty easy, but you just got that feeling.
Did you recognize? Oh, I'm sorry.
Yeah, go ahead.
Did you recognize any of the medical staff as someone you knew?
No, I didn't know any of them.
Did you know Amy used to work in that
Yes.
hospital?
Yes, I did.
Did you see other members of the Mullis family come to the hospital?
Yes, I did.
At some point, did you and your wife Carol then leave the hospital?
Yeah, we left together, yes.
Before Amy died, I know you said you had more limited interactions or time with Todd.
Mhm.
At any point, did you and Todd ever discuss Amy having an extramarital affair?
No,
Do you have other friends in the community?
a few.
Do you sometimes hear people talk or rumors about
Oh, absolutely.
affairs?
Oh, absolutely.
Did you also talk to Amy directly over the years, or text or call her or talk to her?
No,
When Amy and the family and Todd would come for barbecues or campouts or anything, did you ever hear Amy complain about being unhappy?
no,
Did you ever hear Todd complain about his marriage or about wanting a divorce?
no.
A couple more quick questions on November 10th. I know it was Iowa in November.
Mhm.
Do you remember weather-wise, if it was cold?
Yes,
Do you know if there was any snow on the ground?
yes, there was. Because we had commented loading the skid loader on that trailer, how sketchy it was. It's on tracks and I don't like a wet bed that's snow on it.
When you were doing your scrap metal job at the farm by Brian's,
Mhm.
were you walking around outside in the snow?
Yes,
Were you leaving prints? Shoe
I'm sure
prints?
we were.
Do you remember a DCI agent coming to your home to
Yes,
talk to you?
Yes, I do.
Do you remember approximately when that was after Amy's death?
It was cold out.
If I told you the report from the agent is December 28th, 2018, would you
Yeah,
accept that?
yeah.
Okay. Do you remember having this discussion?
Yes, I do.
Do you remember the name of the agent?
No,
Have you had a chance to listen to the audio of your interview with him?
yes, I did.
Do you know where on your property that interview is occurring?
Yes, I do.
Where at?
Right in the shop.
In the shop?
Yep.
Is the shop a large building?
Yes, very.
What do you do in there?
Everything.
Objection is overruled. The answer will remain on
What?
record.
We do everything in there from snowmobiles to four-wheel drive tractors.
Were any of your children or grandchildren on the farm that day with you?
Yes, they were.
Were any of them in the shop?
At one point, they weren't supposed to be, but he wasn't supposed to be there. He was supposed to come back at 5 o'clock, but he was too impatient, so I had to leave my grandkids in the house. So I had to talk to him then. And one of them slipped out, and
Do your grandkids play in the shop sometimes?
absolutely,
Do they ride their bikes or roller skate or?
all of it. Pickleball, segways, I got it all.
Do you remember the DCI agent talking to you about how Amy died?
Vaguely,
Do you remember him using a term that the medical examiner's decision that it was a homicide was gospel?
yes.
Oh, man, that's
What did you understand that to mean to you?
what
I
would you
didn't
put it?
really, I didn't really pay too much attention to it, I guess.
Did you have an impression that law enforcement had already decided who killed Amy?
Absolutely.
Do you know who they thought it was?
Yes, they had the finger pointed at Todd the whole time.
Do you remember talking with the agent about your thought that it was an accident?
I'm sure I did because I don't know if you guys want to listen to this or not, but as while I was at the scene, Todd told me what happened. And today he will still tell me that same exact story, that you cannot tell that twice. And it has not faltered one word from the day at the incident. You can't do it.
Mr. Krugman, does it make sense to you that Amy could have slipped and fallen on that corn rake?
That's
Object is relevant.
How is that not relevant?
Objection is sustained. That answer will be stricken from the record.
He's a farmer.
Do you recall telling DCI that it didn't make any sense that it was a homicide?
Yes, I did.
Do you remember what DCI wanted you to do?
It was pretty obvious what he was out there for.
What was that?
He wanted me to put some dirt on Todd that I didn't have none.
Have you ever seen Todd get in a fight with someone?
No.
Are you aware of any evidence that Amy's death was a murder?
No evidence at all.
In your experience growing up on a farm and farming, do your kids help with farm chores?
Yes, when they were from little on, they did everything.
So would you have a 13-year-old helping you prep a hog barn?
Absolutely.
Overruled.
Would you let a child use a corn rake?
Yeah, absolutely. Yeah, I'm sure they have.
You are aware that Todd was arrested for Amy's murder in 2019?
Yes.
Do you know who Bob Sabers is?
Yes, I do.
Did you ever talk to him about your presence at Brian's house on November 10th?
I don't think so.
Did you ever talk with a Jake Firehome?
I don't think I know that person.
Were you willing to talk to Todd's attorneys if they needed to talk to you?
Absolutely.
Did you attend any of Todd's criminal trial in September of 2019?
Yes,
And did you watch any of it online?
I think all of it.
What was your impression of the trial?
Objection, relevance. This witness's opinion of the trial is irrelevant.
Sustained.
Do you recall hearing defense counsel's opening argument in the trial?
Yes.
How did you feel after you heard that?
Objection, relevance.
Sustained.
As a farmer, do you see a lot of life and death?
Yes.
Do you also know the anatomy of the livestock you raise?
Absolutely.
Is there significant differences between the anatomy or the organs of a body of a hog and a person?
No.
Have you ever had to Google the anatomy of a person?
Objection, relevance.
That was an issue in the Google searches at trial, and this is being presented to show what counsel could have and should have put on at trial to combat that.
However, Mr. Krogman's need to Google something is not relevant to that determination.
He is a farmer just like Mr. Mullis, and it was alleged that Mr. Mullis conducted that search. So I think it's directly relevant.
The objection is overruled. Was there an answer, Kelly?
Have you ever had to Google or search the organs of a body?
No. We've actually done autopsies on hogs. When you have livestock, second nature, you turn into a veterinarian. So when something happens, you open the animal up and you see if that is the reason this critter died on you. And if you don't, then you have the veterinarian.
Just one moment.
I dissected a fetal pig in high school, and
Over
their
the years,
organs are pretty much
of your
laid
friendship
out like
with Todd,
ours.
did you ever observe any behavior that you would consider to be mistreatment of Amy or the kids?
No.
Do you know if you told the DCI agent your opinion on how Amy Mullis died?
Objection, hearsay.
I'm asking if he remembers if he told her. I'm not asking what he told her.
The question was as to the witness's opinion.
If he remembers telling Turbot if he had an opinion about how Amy died.
The objection's overruled. You can answer.
I'm quite sure I did.
Mr. Krugman, when you were with the DCI agent, do you recall any other statements that the DCI agent or like what he was asking you to do in regards to Todd?
I'm sure he was looking for some dirt on him, but I had none. I told him, I said, I'm worthless to you, man, because I have nothing for you.
Do you remember a part of the conversation or the interview where the agent wants you to like sleep on it?
Oh, yes, yes.
Do you remember what he wanted you to sleep on?
I'm kind of fuzzy on it. I really am.
Okay.
I mean, when you tell me, yeah, it comes back to me, but I can't recall all that long ago.
No further questions.
Cross-examination?
Yes, Your Honor, thank you. Good afternoon, Mr. Krogman.
Hello.
Nice to meet you. You were discussing your interview with Special Agent John Turbot on direct examination. I just have some follow-up questions about that specifically. So that occurred in December of 2018. Does that sound about right?
Yes.
During that interview, you indicated to Special Agent Turbot that you hadn't spent much time with Todd and Amy in 10 to 15 years. Does that sound right?
Probably so.
So you would see them occasionally, but not a regular thing?
Not like we did earlier before they had children.
You also described your relationship with Mr. Mullis as you were his best friend. Does that sound right?
Yeah, we were really good friends. Still are.
What was that?
We still are good friends.
Thank you. You were asked to describe Todd and Amy's marriage, and you referenced that there were a lot of oddities. What did you mean by that?
I'm going to object because I don't believe that was the testimony, the oddities in the marriage. Is that what the question was?
Let me rephrase my question then to make it clear. In your interview with Agent Turbot, you described Todd and Amy's marriage as having a lot of oddities. Do you recall saying that?
No, I'm sorry, I don't.
If you had indicated that, what would you have meant by oddities?
Your Honor, if I could object and
I
ask
don't know.
counsel to clarify for the record if he's referring to the audio of the interview or the written report by Turbot? The narrative, do you know where it comes from? It's the narrative? Okay. Thank you, Your Honor. I'm sorry.
Mr. Bakke, I think maybe if you can re-ask the question at this time.
If you had described any peculiarities, oddities, whatever word you happen to use, would there be a reason for that?
I don't think they spent a lot of time together because all he did was work and she worked at the hospital. So I don't think, I don't know, I guess it just seemed kind of odd to me. They didn't have that much time to spend together.
You indicated that I believe that they've been married for a while, so maybe it kind of, sorry, I don't want to mince your words here. But you were aware of some concerns about Amy being unfaithful to Todd, is that fair?
I wasn't concerned about nothing.
Were you aware of it?
I heard rumors, but as far as, I don't know how you want me to answer that. If I believed every rumor I heard, he wouldn't do it.
In the time leading up to this incident on November 10th, 2018, I believe you told DCI agent Turbot that in the 5 years before that, Mr. Mullis had not brought up Amy's name. Does that sound right?
I'm drawing a blank. I'm sorry. I don't.
Would that surprise you? Would you have any reason to dispute that?
I don't know how I should answer that. I don't really know what he's getting at.
You don't know who's getting it.
Turbot was getting what he.
So you don't remember much of your conversation with Agent Turbot? Is that what?
Well, you know how long ago it's been? Quite a while. And no, I do not remember everything that was said.
But sir, you remember whether your footprints were covered up or were showing in the snow on the day of this incident, but you don't remember your conversation about it?
With him? No, I don't remember it with him, but you're saying that you don't think I had footprints in the snow? I don't remember that, or what are you asking me?
We'll move on. You discussed what Mr. Mullis had told you about the incident involving Amy that led to Amy's death, right?
Right.
And Mr. Mullis told you that he had to remove the corn rake from Amy's body because the handle was 8 feet long. Does that sound right?
Objection, can I ask the foundation of where this comes from?
Yes, this is from the same interview that we've been
Can
referencing.
we have just a moment?
Sure.
I'll ask you a question.
Okay, go ahead. Certainly.
Mr. Krugman, just to be clear for the record, you were not personally present when Amy Mullis became injured. Is that right?
Right.
You don't know exactly what happened, even though you have your own speculation, right?
Yes.
So much of your testimony today was based on the fact that you have your own hypothesis of what may or may not have occurred.
Yeah, like everyone in here does, has an idea what happened. Yes, exactly.
Fair enough.
He's not
I
wrong.
don't have anything further. Thank you.
Any redirect?
No, Your Honor.
Thank you, sir. You may step down.
That was such a great answer. I love it.
Any further witnesses today?
No, Your Honor.
Anything else that we should take up, or are we ending for the day?
We should discuss the schedule tomorrow, Your Honor, but I don't know if the court wants to do that in chambers.
I think we probably can.
Sorry. There's one brief scheduling thing that might be best, since we're done a little early, that we could talk about in chambers. And then I believe the court indicated it wanted to make a record briefly about discussions that we had on Monday. I don't know if this would be a good time or if that was still needed.
Well, we can at some point. Yeah, we can talk back in chambers about whether we do that this afternoon or later, and then we'll see where we're at maybe with regard to the NIE exhibits. But just make sure I keep a running list of my notes of things that we need to clean up at some point. We'll plan on recessing for the day and picking back up at 9 in the morning. Have a good night. Thank you.
Okay, now we can start on today's and get closer to life. I just have to find it. Yeah, like I said, I don't know what happened. I didn't watch first trial. I think you're right, just because about that guy's like Todd's ride or die. But still, that last answer. Court is at lunch. So we can start at the beginning of today on. I can go back to 1.5. I had to slow it down to. We were on 1.5 and doing good. And then when Dr. Nye got back up on the stand, I had to slow it back down to 1.25 because she talks so fast I couldn't keep up. So let's try 1.5 again. But regardless of the fact that I don't know what should happen because I didn't watch the first trial, that answer was brilliant. Yeah, I had an idea, just like everybody else in this room has an idea what happened. That was a great answer. Because he's not wrong. I mean, no. Gets accused of committing murder. Of course, you have an idea what happened, and it's usually contrary to what the police think. I know how girls are. I know. I just mean the answer in and of itself. Everybody has an idea of what happened. Whether it's that he did it or that he didn't do it, everybody has an idea of what happened. I don't mean like that it's the truth. It's just that everybody has an idea of what happened. I do have a question though. I know how women talk. Like, if I had a relationship problem, I don't have relationship problems with Travis. We're great. I don't know how I got so lucky. But, you know, in my past, when I've had relationship problems, my friends knew about them. That's what women talk about. Do guys talk about their relationship problems? I know I have mostly girls in here, but do they? Like, do you tell your buddies, you know, oh, I think she's cheating on me. I don't know what I'm going to do about it. Should I get a divorce? What do you guys think? I mean, do you guys talk like that? Because he said that he'd not talked to Todd about it, but he'd heard rumors. Like, do you confide in your friends when you have problems like that? I'm just curious. And that is another possibility too. She could have fallen on it and he could have been, oh, great. Now is my opportunity. Depends on the guys. Yeah, I can see that. Yeah, because like I wouldn't tell every friend that I knew, just like the close, you know, the close ones. It kind of doesn't sound like they were super, super close. Maybe at one time they were, but at the time, maybe not so much. Okay. I imagine there's women like that too. I was just curious because, like, did he not know because they weren't close, or did he not know because that's not something the guys talk about? Bill Engvall has in one of his stand-up routines, he talks about the differences between men and women, and he's talking about he talks to his friend on the phone, and he gets off the phone, and he tells his wife that so and so's getting a divorce, and she's like, "Well, what happened?" "I don't know. They just said they're getting a divorce." "Well, was she cheating on him?" "I don't know. They just said they're getting a divorce." "Well, what happened? When are they separated?" "I don't know. They just said they're getting a divorce." "Well, who's going to get the kids?" "I don't know. They just said they're getting a divorce." And it's the funniest routine, and it just goes on and on and on and on. Like, she just keeps asking question after question after question, and his answer is just, "I don't know. He just said they're getting a divorce." So that's why I asked. Like, I know it's a comedy routine, but is that just something that men just don't talk about? You know, because when women talk, we know everything by the time the conversation's over with.
Yes. Witness.
The applicant calls John Castle.
All right, Mr. Castle, take your time, come forward and have.
Is it too fast?
All right, raise your right hand. You said testimony you're about to give will be true and correct. All right, microphone is on, so you should be all set. You can adjust the chair if you need to. Whenever you're ready.
Good morning, Mr. Castle.
Good morning.
Can you please say your name and spell your last for the record?
Sean Castle, K-A-S-A-L.
I'm gonna
And
slow
Mr.
down a
Castle,
little
what is it
bit.
that you do?
I am a digital forensics expert and a network security consultant.
What?
Network security consultant.
What does that?
As a consultant in network.
Dang it, it was going so well. Every time I mess with it. I don't know why. Because you're a wonderful person.
Training you have in the area of digital forensics?
Yes. So in the industry of digital forensics, there are several software titles that we utilize on a daily basis, descriptions for the licensing of those titles. And as a part of the renewal process, I purchased the training packages that accompany those titles from Cellbrite, Magnet Axiom, Oxygen Forensics, and Xero FTK. I also teach. I did my adjunct work at the University of Nebraska-Kearney under PhD Matt Miller, and I also am a returning guest lecturer and instructor at the Institute of World Politics in Washington, D.C., where I teach specifically in the area of network attribution and threat intelligence as it pertains to signal
Politics has entered the trial? Why?
So you instruct with the military?
I teach graduate students who are going to be employed by intelligence services such as CIA, NSA, and I also instruct law enforcement at the University of Nebraska-Kearney. I teach them means of correlation of data points and give them an understanding of how to build context within correlation of data.
Mr.
It's taking independent data points as it pertains to the evidence contained within devices, building timelines, and understanding how all of those data points come together to understand a full narrative of events or patterns.
Mr. Castle, have you provided any previous expert testimony?
I have. I have testified in state courts, federal courts, and military courts.
Have you ever been appointed as a special master?
I have a couple instances of which I was appointed to a district court judge. The situation surrounding that was the Attorney General's office of the state of Nebraska had received privileged information and pertains to communications between their client and the attorney. So my role was to be a custodian of the data and assist the judge in parsing out that privileged information so that the AG's office could have a comprehensive report of all of the other data contained within the device.
Have you ever been disqualified as a digital forensics expert in any court proceeding?
No.
Mr. Castle, can you tell us what digital forensic evidence, what that term means?
The science of digital forensics is the ability to collect, maintain the integrity of, and analyze artifacts in digital devices such as mobile phones, tablets, computers, servers, and cloud data sources.
Are there standard operating procedures for digital forensics?
Yes, there are industry standards as defined by organizations like the National Institute of Standards and Technologies, as well as the companies who build the digital forensics tools that we use have best practices and standards for procedural aspects of collecting, maintaining the integrity of, and doing the analysis of the data that they're contained.
Would this include the investigation interpretation of the data?
Yes,
Do you follow these standards?
yes,
Mr. Castle, were you retained by counsel for Todd Mullis?
I was.
And did you examine any electronic devices in this case?
I did.
How did you physically examine the data?
I was invited down to the Sheriff's Department in Delaware County to do my own independent collection of multiple devices on site there in September of 2022. And I also visited the Mullis family farm to collect some devices there as well. Specifically on the mobile devices, my assistant and I collected through multiple extraction processes those mobile devices to also include a network security recording device for cameras, which was located on the Mullis family farm, and also a satellite-based dish network TVR set-top box, and multiple laptops. I think there were 2.
What do you do first when you examine an electronic device?
Depends on the device. When it pertains to mobile devices, the first thing to do is to isolate that device from any connected network, placing it in airplane mode and making sure that Bluetooth and other similar network connectivity options are turned off, or by placing it in a Faraday cage or bag to make sure that it is unable to talk to any networks for fear of data corruption. At which point we connect those devices to the laptop or machine that we're using to extract that data and process it for further analysis. With laptops, it requires pulling the hard drives out of the laptops, connecting them to a forensic write blocker, which inhibits the ability to modify, tamper, or corrupt the data contained on that laptop, and do an image of the hard drive for further processing later. That same process is also followed with the hard drive contained within the camera security network video recorder, and as well as the set-top box from Dish Network.
Can you explain what exactly you mean by extraction?
So it is the process of collecting the data contained on the hard drive or the memory within a mobile device or laptop. There are multiple extraction methods available to a digital forensics investigator. With mobile devices specifically, there is logical, advanced logical, and physical methodologies available, both through Cellbrite and Oxygen Forensics. That process is similar in nature for both Android and Apple platform devices, and entails different methods of collecting that data within the device.
What software did you use for the phone and iPad extractions in this case?
Cellbrite UFED, which is a Cellbrite Universal Forensic Extraction Device. I actually licensed the title Cellbrite UFED for PC, which allows me to install that on one of my laptops, making it a little bit more mobile or portable as a solution.
Can you explain the 3 types of extractions through Cellbrite?
Yes. The logical extraction process is a simple process of extracting the data as it exists on the file system of the hard drive contained within the mobile device. That is the same for both Android and iOS platforms. The advanced logical extraction process entails both file system extraction and on the Android platform, an ADB or Android backup process. On the Apple Ecosphere platform, it would also entail an iTunes backup method. And the physical process of collecting the data is very similar to the process of a hard drive contained within a computer, and that it is a bit-by-bit copy of the data contained on the drive within the device. The physical methodology is the most comprehensive and the best method to use. However, depending upon the device, the software version running on the phone, and the software version of the software that I use to collect, it may not be available as a process.
After the extraction, did you do any analysis on the devices?
I did. I ingested the extracted information into Cellbrite Physical Analyzer, which is the software that Cellbrite produces for that process. And I also ran these devices through Magnet Axiom, which is another forensic title available to me, and a tool that is commonly utilized both by private sector and law enforcement. Using both tools gives a better and more comprehensive overview of the data, as both titles have specialties, meaning that those software companies have spent their resources and money on specific areas of analysis and have special or unique abilities within that software title. As an example, Cellbrite spends a lot of their research and development time finding ways to circumvent encryption processes utilized by cell phone companies, where Magnet Axiom has spent a lot of time developing ways and means to process the SQL-like databases and JSON files that make up the data constructed within a mobile device. So using both tools gives a very comprehensive overview of the data contained.
You mentioned some other electronic devices. Did you do extractions for those as well?
I did.
What software did you use?
For creating the disk image of the network video recorder for the camera security system and the Dish Network set-top box, I used FTK Imager to produce an EO1 format of the disk image. And for the analysis of the network video recorder for the camera security system, I used the same software title that the law enforcement used, which was DME, DVR Forensics. It was the same title that the law enforcement in this matter used for their analysis.
Did you generate a report on your analysis?
I generated a couple of different reports. I will be specific of those. A general report of my findings overall was authored, and then I also created individual extraction reports of the data contained within the different devices that I had an opportunity to do analysis on.
I would like to show the witness what has been marked as Exhibit 272. Is it on your screen?
I do.
Do you recognize this?
This is a current copy of my Sworn Vitae, noting my professional experience, training, presentations I've done, and some of my work history.
And you mentioned this is up to date, so there's no additions?
No, I believe this is the most current version.
And can you scroll down to page 4? And what is this, Mr. Castle?
This is the first page of the report that I authored of my findings overall for this matter.
Does the CV and report, or general report, fairly and accurate represent your work and experience in this matter?
It does.
Your Honor, the applicant offers Exhibit 272.
Any objection?
Yes, Your Honor. Beyond what has been referenced, this exhibit also contains an affidavit. The report and affidavit are hearsay, and in addition to that, the report contains what this witness, essentially credibility findings of this witness speaking about other witnesses that have testified in this case. His credibility determinations and his opinions about the truthfulness of other witnesses is inadmissible, and the report should be excluded for that reason and because it is hearsay.
Would you like to respond?
Your Honor, this goes to what happened in the underlying trial, as well as the evidence that was presented, and it is a full explanation of Mr. Castle's experience and his analysis of the data that he extracted and analyzed. It's about the weight and not the admissibility of the evidence.
272 will be admitted. However, the court will not consider the affidavit portion of that exhibit or give any weight to any credibility determinations made of other individuals if they're referenced throughout the report. Certainly to the extent that counsel is utilizing the report in any questioning of the witness, I would ask that you avoid any of those portions, please. You may proceed.
Thank you, Your Honor. Did you review any depositions or trial testimony in this case?
I did.
And who would that have been of?
The testimony and trial transcripts of former Deputy Travis Hemseth and the DCI agent, Mr. Trebet.
Your Honor, I see the witness is reading from the screen. Is he reading from the report?
He is, and I can put it up on the TV if that's helpful.
Did you also review the testimony and deposition of Ward Crowley?
I did.
Nicole, you can take down. Did you receive and review the extraction and digital discovery evidence from Mr. Mullis's criminal trial?
I did.
Mr. Castle, did you review the iPad that belonged to the Mullis family?
I did.
What browser was used on this iPad?
Primarily the Safari web browser.
On this particular device, did the Safari web browser default to Google searches?
The Safari web browser had the Google search engine as its default search engine.
Did you review Mr. Hemseth's testimony regarding the iPad?
I did.
And do you recall that his testimony about the search history on the iPad was falling off?
I do recall that portion of his testimony.
Was this correct?
No.
And why is that?
I'm going to object. This is going into credibility determinations. He can testify about his own findings and whether in the court can determine if they are consistent with the underlying trial testimony.
May I be heard, Your Honor?
Go ahead.
This is not a credibility issue. This is about the actual issues and what was actually on the iPad and the evidence that should have been presented at Mr. Mullis's trial.
Yeah, I agree. Objections overruled. Do you remember the question, sir?
Could you restate it, please?
Yes. Just you were about to explain the search history of the iPad falling off.
Yes. Upon visual inspection of the device, there would be a list of most recent searches that a user had done on the device. But upon the extraction and analysis of the data contained within the iPad, it reveals a longer history or a more comprehensive understanding of all the searches that were conducted on the device.
Can you explain what it would mean for searches to be falling off?
Visual inspection of the device, when tapping in the Google search area, it would show the most recent searches conducted by a user of the device. And that would be a short list, just simply because the screen is only so long and it would only represent those most recent searches that were conducted. But that does not inhibit or restrict the memory of the device or the number of searches that were actually conducted on the device itself. That would be revealed upon the extraction and analysis of the data itself.
So the evidence would still, or the search history would still be available?
In two different locations, one on the device and also as a part of the subpoena offered to Google for the comprehensive search history.
Were you able to determine when the iPad was first activated?
I believe I recall that in August 2017, the first user activity demonstrated on the device was a connectivity to a wireless network, representing the first viable activity recognized on the device in its activation time period.
Is there a way to determine how the iPad accesses the internet?
Yes, the Apple Ecosphere keeps a fairly comprehensive system log that demonstrates the network traffic that leaves or arrives on the device via its network interfaces. Those network interfaces being the WWAN interface, which would be the cellular radio on the device, or the Wi-Fi radio interface for standard Wi-Fi network connectivity.
Can you have a cellular data plan on an iPad?
There are a couple different models of iPad. One of those models does contain a radio that is capable of 3G, 4G, and now more modern 5G cellular data transmissions.
Are you aware if the Mullis family iPad had a cellular data plan?
It had a radio that was capable of cellular network traffic. The time frame in which it had a data plan attached to it was determined later.
Okay. I would like to show the witness what has been marked as Exhibit 256. Mr. Castle, based on your experience in this field, is this a document that you would normally see?
Yes.
And do you often see activation plans in your work?
As a part of network threat attribution, one has to correlate multiple data points, one of those being subscriber data, to gain an understanding of the traffic that may have arrived on a device, the IP addresses associated with that traffic, and the data plans connected to them. Yes.
Your Honor, the exhibit is being displayed. This was an issue yesterday as well, where exhibits are being displayed where they haven't been admitted. Thank you.
Did you use this document to reach your opinion on whether the cellular data was activated?
It was one of the data points that I used, yes.
Counsel, and I guess I would just say, I mean, with regard to the displaying of the exhibits, again, this isn't a jury trial, and so it doesn't really matter to that end. Normally, we wouldn't want them displayed because a jury would be seeing them, but to the extent the court is the fact finder, that isn't a concern in terms of what's being seen. Obviously, we have spectators and the media viewing, so there is that, but it isn't those spectators or the media that will be the fact finder in this case. So just want to note that for the record.
And thank you, Your Honor. That one reason I point that out specifically is some of the exhibits that have been filed have unredacted personal information, social security numbers, minors' names. So if it's up before I have a chance to open the exhibit, it's difficult for me to determine.
Well, yeah, and the issue of redacting information is certainly different. There shouldn't have been anything filed with unredacted information. I think there's only been one exhibit that we've talked about that needed to be filed at a higher security level. So that is something that should be brought to my attention. So thank you for that. All right, go ahead, Ms. Steenson. Sorry for the interruption.
That's okay. Thank you, Your Honor. Does this appear to be an activation plan from US Cellular?
Yes.
Is the phone number the one on the phone number listed, the one associated with the Mullis family iPad?
Yes, it correlates to the telephone number represented in the Cellbrite extraction report.
And what day was this plan activated?
I believe it was October 12th of 2018.
Your Honor, the applicant offers Exhibit 256.
Any objection?
Based on prior agreements with counsel that we will not require US Cellular to come in and lay foundation, I have no objection.
256 is admitted.
Mr. Kessel, do you know when when planting is generally is?
Objection, this is the foundation.
Sustained.
Were there email accounts connected to the iPad?
Yes,
Is there evidence on the iPad that links to Todd Mullis 76 Google account?
yes.
Is there evidence on the iPad that links to Mullis RN Gmail account?
I'm sorry.
I'll withdraw.
Okay.
That second part of the question?
Yes. Is there evidence on the iPad that links to the Mullis RN Google account?
Yes, there are artifact evidence of both accounts on the device.
And is there evidence on the iPad that links to Amy Lynn 5810 Google account?
I did not find any artifacts or evidence of that account being linked.
Mr. Castle, you mentioned earlier that you reviewed the cell phones in this case. Did you analyze Todd Mullis's phone?
I did.
And what type of phone was this?
It was an LG older style flip phone.
During the course of your review of the digital forensic evidence, did you review Todd's US cellular records?
I did.
I would like to show the witness what has been previously marked as Exhibit 373. Can you tell me what this document is?
It appears to be a phone record of a device in a billing period noted. This appears to be the phone records for Todd Mullis' phone.
Are the last four digits of Todd's phone number 1114?
Yes, as represented in the document.
Are these the records that you received from the state?
Yes,
The applicant offers Exhibit 373.
Any objection?
Your Honor, the only objection I have, as was stated in our preliminary objections, is there's highlighting added by Mr. Mullis' counsel on the first page of the exhibit. But beyond that, in agreement, consistent with our prior agreement about the US Cellular, I have no other objection beyond that.
373 is admitted with the understanding that the highlighting, I guess, was not original to the document.
Yes, Your Honor, and I believe there has been another version filed without the highlighting in it.
Okay, thank you.
And you can take this down. During the course of review of the digital forensic evidence, did you review law enforcement's extraction of Todd's phone?
I did.
I would like to show what has been marked as Exhibit 353. What is this, Mr. Castle?
And this is a page that was a part of the extraction report of the phone, Todd's phone specifically.
And how is it that you recognize this?
First, it notates the extraction report and the model number of the device up at the top. And it was also labeled Todd's phone. And as far as the data contained within the report, it represents some sent and received communications.
The applicant offers Exhibit 353.
Any objection to 353?
Minimally, Your Honor, there's some handwriting on it. If additional foundation can be like just the handwriting where it says Todd's phone, et cetera.
Ms. Stinson?
Yes, I believe that this. Yes. Did this? Did this come from defense counsel's file?
It did. That's not my handwriting specifically on the phone that as far as the notes on it. I recognize the report as a result of the model number of the device and the communications on it.
But this is what you received?
Yes. Minus the handwriting.
Does that address your objection, counsel?
I'm fine with it being admitted, Your Honor.
Right. Again, 353 will be admitted with the understanding that the handwriting, I guess, is not relevant necessarily to the exhibit.
Mr. Castle, did you analyze Mrs. Mullis's phone?
I did.
And what type of phone was that?
It was a smartphone with a larger screen, a more modern device.
Are the last four digits of the phone number 5675?
I believe so, yes.
Did this phone have access to the internet?
It did, which was in contrary to Mr. Mullis' phone, which the flip phone had internet capabilities, but there was no artifacts or evidence of any internet usage. where on Ms. Mullis's phone, it did have a web browser that represented artifacts and evidence of web history to include social media.
Would this also included Facebook?
Yes.
So you indicated that there had been internet searches on the phone?
On Ms. Mullis's phone, yes.
Was there any email accounts connected to Mrs. Mullis?
There were
Mullis's
multiple
phone?
accounts.
Is there evidence on the phone that links to Mullis RN Google account?
Yes.
Mullis RN Google account?
Yes, there was.
Is there evidence on the phone that links to Amy Lynn 5810 Google account?
Yes.
Is there evidence on the phone that links to Todd Mullis 76 Google account?
Yes.
Was there a recovery number on the Todd Mullis 76 Google account?
There was.
Can we get foundation for what is the recovery number?
The objection's overruled. The answer will remain in the record. Go ahead, Ms. Steenson.
Thank you. Can you tell me what a recovery number is for a Google account?
When setting up a Google account, Google wants a phone number that can be utilized to recover the account in the event of a forgotten password or a security breach, so that they can validate the identity validation that the end user is who they say they are, have the ability to then get back into the account in the event of its lock or password forgotten scenarios.
So you would be able to reset a password for a Google account through a recovery phone number?
Yes, or offer it as a means of two-factor authentication.
So you mentioned that there was a recovery number linked to the Todd Mullis 76 Google account. Whose number was that?
It was a number associated with Ms. Mullis's phone.
Briefly on the Mullis RN Google account, did you review the search history from this Google account?
I reviewed the search history both on the device and as a part of the subpoena reply from Google.
Did you notice that the Google account included searches about cabins?
I did.
Over the course of your analysis and the forensic digital evidence of this case, did you review Mrs. Mullis's US cellular phone records?
I did.
I would like to show the witness what has been previously marked as Exhibit 374. Mr. Castle, what is this?
This is a representative of some cellular communications and the telephone number associated with Ms. Mullis's phone.
And is this what you received from the state's discovery?
Yes.
I would like to admit Exhibit 374.
Any objection to 374?
No objection. Just, however, if we can clarify for the record that it's being received from the state through Mr. Mullis's counsel, but otherwise no objection.
374 is admitted with that clarification.
Mr. Castle, did you analyze Tristan Mullis's phone?
I did.
What type of phone was this?
It was also a smartphone with a larger screen or display and had internet capability and connectivity.
Were the last four digits of the phone number 1864?
I believe that to be correct, yes.
Were there internet searches on this phone?
There were multiple internet searches on the device.
And what types of searches were these?
There were searches for PC games, mobile device games, several multimedia searches, and searches for very specifically military sniper style games.
And what other types of searches were there?
There was some, under the multimedia category, there were some searches for some adult related content.
And what type of online games did you find?
World of Warships and other similar combat style online games.
And when you say adult content, what is it that you mean?
Specifically pornography.
And were there searches for snipers?
Yes, it was one of the games that was searched for.
Did you create extraction reports of Amy and Todd's text messages?
Yes, I created an extraction report both from Todd's phone and from Ms. Mullis's phone as pertaining to the communications between those two parties.
I would like to show the witness what has been marked as Exhibit 307. Mr. Castle, what is this?
This is an extraction report of specifically SMS communications between Todd and I believe it Ms. Mullis's phone, or Ms. Mullis's messages.
And did you do this extraction report?
I believe so. The cover page is missing. That would give more detail, but from my recollection, yes, this is a report that I generated of the data extracted from the phones.
And besides the missing cover page, is this a fair and accurate representation of the data you extracted?
Yes.
I would like to admit Exhibit 307 into evidence.
Any objection?
Yes, Your Honor. I think more foundation needs to be laid about how this exhibit was created. It's been portrayed as communications and text messages between the two, but after, I believe, page 20 on my version of the exhibit I was given, there's pictures, Facebook posts, all sorts of different things that I don't think were mentioned by the witness.
I think I heard the witness say they were SMS communications, so maybe we could have some further explanation, Ms. Steenson.
While you were analyzing Amy Mullis's phone, you had mentioned that she had Facebook on her phone. Did you analyze her Facebook account?
I did. And the reports that I generated of those devices may have contained more information than just the SMS or communications between the parties. It may have included other artifact evidence that was contained within the device for review by defense counsel.
Do you see these, yeah, can you talk, what page is this? Starting on page 19, can you tell us what these are?
These appear to be social media posts or the pages represented on their social media containing images and communications or posts on those media accounts.
And is this from Amy Mullis's Facebook account?
If you just slow so I can validate the, yes, this would be from the Facebook account for Ms. Mullis.
Is Exhibit 307 a fair and accurate representation of the SMS extraction you did and also the Facebook post from Amy Mullis's Facebook page?
Yes, this would be an extraction report of her device containing those items.
Your Honor, I would like to renew my request to admit Exhibit 307.
Any objection at this time?
Yes, Your Honor. May I briefly, while you're the witness?
You may.
Thank you. Good morning, Mr. Castle.
Good morning, sir.
Up on your screen, do you have the Facebook messages there? Can you look at the bottom of one of those pages in the bottom right? Can you tell me what you see there?
Counsel, I think you probably have to identify a specific page, and then we'll have to have.
I'm looking at page 19. In the bottom right corner, it shows a page number. Do you see that? Once she gets there.
Yes.
And what does it say?
It has a page number of a total number of pages noted there at the bottom.
And I believe it states page 877 of 1,453. Is that what you see?
That is correct.
And this total document appears to be 46 pages, including the SMS messages. Is that accurate?
Yes.
So there is not 1,453 pages from Facebook in this document?
In this document, it would appear to be an excerpt or a extraction of specific pages within that more comprehensive report, yes.
And then if you can scroll just to, can you see the top of that page, the very top line on that, on page 19?
Which line specifically are you wanting me to look at?
So right by the e-filing stamp, is the top of that consistent with something that would be printed off Facebook, or is that something that would be consistent with coming from a Celebrite or similar type of extraction?
Can you scroll down just a little bit so I see the bottom of the page? This would appear to be part of a print of a Facebook page. This specific page, not part of the Celebrite extraction report.
Thank you. Your Honor, I would object on foundation, completeness, and relevance. These two mesh of documents are unrelated. I don't understand this exhibit.
Yeah, I guess, counsel, do you want to respond to that? Certainly the way that the exhibit is labeled, and I guess my understanding of what the witness did, it would appear that the first 18 pages make sense. I understand how those were obtained and where they came from. The remaining portion of the exhibit does seem to be cherry-picked pages from Facebook. Can you clarify that, please?
Just one moment, Your Honor.
Sure.
So, Mr. Castle, you mentioned that you did an analysis on Mrs. Mullis's phone that included that she had a Facebook account. Is that right?
Correct.
And is it possible to download information from Facebook?
It is.
And how would that work?
There are multiple ways to acquire that data, primarily for purposes of integrity. Facebook offers a process of a Facebook download in which they pull all the data from their multiple servers that contain account information, posts, messages, those types of things, and combine it within a single zip file that has a report of all that data the user may have posted or communicated via their social media. Secondarily, there are ways to scrape or pull individual posts and pages from Facebook from the computer. This is a couple of different processes that could have been utilized to acquire the information.
Is a portion of your report these Facebook extracts? Starting at page 19.
Objection, Your Honor. The witness has already testified that this is not extraction. These are prints from Facebook. And I'm going to add an objection under 403 that the exhibit in its current form is misleading because the page numbers continually jump around.
This exhibit does contain a portion of the Silver report that I created.
Okay,
So
I apologize, sir. Yeah. I heard the witness say that these appeared to be pages that were printed from Facebook. It certainly does appear to be incomplete if we look at the page numbers at the bottom. So we're really dancing around that issue. So the objection sustained for now.
Your Honor, I would like to offer pages 1 through 18 of what has been marked as Exhibit 307 into evidence, which represents the extraction of the SMS phone records.
Any objection to that portion of 307?
Yes, Your Honor, only because this gets back to my original objection with the exhibit, that I believe additional foundation for how because I believe the witness said this is coming from two different phones, so I believe additional foundation of how the messages were combined would be beneficial.
Ms. Steenson, would you like to lay some additional foundation specifically with regard to the, combining of the information from the two phones for purposes of creating the summary on the first 18 pages of 307?
Yes, of course, Your Honor. Thank you. Mr. Castle, can you explain how you created this extraction report?
If I'm allowed to look at the previous 18 pages, I can validate. Okay, this Cellbrite extraction report here specifically is from Ms. Mullis's phone, and is not a compilation of multiple devices. The first 18 pages are just the extraction report of Ms. Mullis's phone and the communications between her and Todd.
I would like to renew my request to admit Exhibit 307, pages 1 through 18.
Mr. Bakke?
No objection on that portion. Thank you.
The first 18 pages of 307 are admitted.
Mr. Castle, did you create an extraction report of Mrs. Mullis and Jerry Frazier's emails?
I created a report of the communications between those two parties, yes.
I would like to show the witness what has been marked as Exhibit 308. What is this, Mr. Castle?
It is an extraction report representing emails between the two accounts noted in the second column, Amy Lynn 510@gmail.com and Jerry Frasher 70@gmail.com.
What time period do these cover?
It appears to be November of 2018. Is there multiple pages to this document, just a single page?
Can you, Mr. Castle, can you tell us how you created this extraction?
So for this report, I chose the email communications category within the Cellbrite application. I extracted that data specifically into this NACER document.
And is this a fair and accurate representation of the report that you created of the emails between Mrs. Mullis and Jerry Fraser?
As they existed on the device, specifically, yes.
I would like to request to admit Exhibit 308.
Yes, Your Honor, this is also raised in our preliminary objections. Many of these email communications, example beginning at page 3, states that the item was truncated due to length. I don't believe foundation has been laid as to that truncation of the emails. Additionally, it states that it contains body files. Those are hyperlinks that don't go to anything. So the messages appear to be incomplete.
Ms. Steedson, would you like to address those concerns, please?
Yes, thank you. Mr. Castle, can you go to page 3 of this report, please? Can you tell me what it means to have this what truncate means?
When generating the report, due to the volume of the data contained within that specific communications, it leaves the final portion of that communication off as a function of generating this report. The source data that the information was derived from is complete and in totality. This report just simply pulls the rest of the data out of it. This is more representation of that communications between these two parties happened, and this is a overview or summary of the initial communication between the two parties.
Your Honor, I would like to renew my request to admit Exhibit 308.
Counsel?
Thank you, Your Honor. I do object, and I'm going to object on 403 that in its current form, the emails, the truncated version of the emails are misleading, especially with the full content not being available for consideration. Thank you.
May I be heard, Your Honor?
You may.
The state has all of this data. This is just for, this goes to the weight, not the admissibility. We are asking for, this is just an example of it reflects what was sent between, but the state has all the underlying data. And if they want to cross Mr. Castle on this, they are willing to.
Counsel, do you agree that you have all of the underlying data that was used to create this report?
Yes, Your Honor, it's likely in the terabyte of information or approximately terabyte of information that I've received. I don't believe it's a discovery issue. It's that the fact finder here is only getting partial. So I think if there's any specific email that needs to be referenced, it would be more appropriate for that full email to be admitted, not truncated partial summaries.
Certainly. I do think it goes to the weight to be given this particular exhibit, if any. 308 will be admitted.
Mr. Castle, can you tell me what UTC is?
It's Coordinated Universal Time Code. It is a universally accepted standard for establishing a uniform way of maintaining a timestamp globally.
Is this standard in digital forensics?
It is standard in network communications as well as digital forensics, a way of establishing a baseline timekeeping methodology.
What time zone is Iowa?
Iowa is in the Central Standard Time Zone, or CDT, Central Daylight Savings Time Zone, depending upon the time of year that it is.
What is UTC time in Central Standard Time?
It is -6 hours from the UTC time code.
And does UTC time change with daylight savings?
UTC remains unchanged. However, the offset for Central Standard Time is adjusted by the hour.
When it is midnight in UTC, what time is it in Iowa?
Non-daylight savings time, it would be 6 p.m.
Is it typical for extractions to be in UTC time?
That's how the data contained within a mobile device is represented, is in UTC time code stamping. It is an option within the software titles to make that calculation or adjustment for Central Time or Daylight Savings Time accordingly.
So there has to be a conversion from whatever uniform standard time is used?
Correct.
And the reviewer would have to convert to Central Standard Time or Iowa time or the relevant time zone?
The machine will automatically adjust those time code stamps accordingly. making it less prone to mistake or calculation by the end user or the analyst.
Did you review Mr. Hemeseth's testimony regarding UTC?
I did.
Was he correct that UTC is military time?
No.
Was he correct that UTC is Central Standard Time?
Central Standard Time is a time zone based on an offset of UTC. So no, that would not appear to be correct.
So the times and dates that Mr. Hemeseth testified to would be wrong?
Unless the offset was checked against the time code within the report, it would appear to be incorrect.
Mr. Castle, did you review the Dish Network DVR system?
I did.
And did you do extraction of this electronic device?
I did.
And this is the system from the Mullis home?
It is. The satellite TV set-top box was the device I retrieved and created a disk image of to do analysis on. I extracted specifically some log files from that device to do analysis on.
Based on your extraction, could you determine what programs were watched and stored on the system?
There are 2 log files specifically that will help an analyst understand both the listings that were available to be watched on the device and also the shows or movies that were recorded and or watched by the end users. Yeah, there were a number of Arnold Schwarzenegger titles that were viewed, recorded and watched by the end users, and a number of History Channel shows to include Ancient Aliens, some presidential history documentaries, and a number of military-style historical documentaries.
Can you provide an example of some of the shows?
Counsel, would you like to narrow your question?
Yes, Your Honor. Was there evidence of Sniper Into the Kill Zone show from the Discovery Channel on the DVR system?
Objection leading.
Sustained.
Can you give an example of a Discovery Channel show that you saw on the DVR system?
Objection, relevance, and foundation.
Overruled.
I believe that there were a couple of log files extracted from the device that would represent the shows that were watched and recorded on the device. And if I could reference those log files, I would be able to better assist you in knowing all of those shows.
I would like to show the witness what has been previously marked as Exhibit 369. Can you tell me what this is?
This is a catalog.back file from the satellite set-top box, which is a file that could be used to determine what shows the user watched, recorded, or viewed on the device. It is a list of those shows and programming.
And can you go to page 15, please? And can you tell me what this is?
The daily schedule log is a log file that represents the guide. When you hit the guide button on the remote, this would show you the shows that are available to be watched or recorded on the device.
And how is it that you recognize these files?
They're documented on the Dish Network website as to gaining an understanding of what those files represent.
Is this an accurate representation of the information you extracted from the Dish DVR device?
It is.
And just for the record, to be clear, this would be a portion of the extraction you did on the DVR system?
Yes, it is very specifically 2 files contained within the hard drive of that device.
So if there is a show or something listed on the log file, what does that represent? What does that tell us?
It was a show that was available to be viewed on the device as far as programming that was available at that time. And a good way to correlate it would be to compare it to another document that would be representative of the shows available to be watched, such as a TV guide or a newspaper listing of TV shows available.
And I would like to request to admit Exhibit 369 into evidence.
Any objection?
Yes, Your Honor, I'm going to object on relevance and foundation. The witness has already testified that this is only a portion of the extraction. Additionally, this file is comprised of, I'll say computer language instead of gobbledygook. So I don't see the relevance or how this will aid the court.
Your Honor, may I be heard?
You may.
Your Honor, the state has underlying data for this extraction. This is just a portion of the extraction is quite large, and it goes to weight and not admissibility. This will go into explaining later on the the digital, correlating with the digital evidence that was presented at Mr. Mullis's criminal trial.
Do I understand correctly that this is just a listing of shows that were available through Dish to be watched? I mean, not necessarily shows that were watched, correct?
There's two files here, and one of them is, as you say, it's a list of files that could be watched. The first portion of this report were the shows that were actually watched or recorded by the device.
And how do I tell that by looking at this exhibit?
So at the top of the page of this particular exhibit that we have open, where it says daily log, that is the file, the shows that could be watched, like the guide part of it. The first part of this file, which was the .back file, which comprises of pages 1 through the catalog .back up at the top right there that you see indicates the shows that were recorded or watched, and that comprises of pages 1 through
Your Honor, while he's looking, I'm going to add an objection on calls for speculation because I don't see anything in this that indicates when or if these were actually watched.
Well, I mean, that's my next question is the date. I don't remember that there was a specific date provided.
there's the end of the back file right there. So everything preceding that daily log file portion of this report, those shows that were watched or recorded. To correlate the date of the actual viewing of those shows, the TV guide listing for the time period of these shows in question would represent those timestamps.
Okay, well, the next problem we have is I'm looking at what is page 14 of this exhibit of the document that was uploaded, which does not appear to be the same page 14 of what I'm seeing maybe on the screen. So let's go ahead and take our morning break at this time and see if we can try to sort this out. We'll plan on coming back at about 10:25. Thank you.
Would you have done this?
Multiple data sources to gain an understanding.
Apparently everybody's anything can be used against them in court now. And I missed that because I had a phone call. I have a doctor's appointment on a Karen Reed hearing day, and there was no way I could get it on any other day. It's at 1:45 in the afternoon. Hopefully the hearing will be over by then,
Thank you. Please
but I
proceed.
doubt it.
Go ahead and have a seat. All right, Mr. Castle, I just remind you that you remain under oath. And Ms. Dietzen, I think we'll pick.
All I heard was like History Channel stuff. How do you use History Channel against somebody? Was there other stuff like crime documentaries or something? I'm gonna have to go back and watch this part because I missed it.
Pick up maybe with some foundation questions with regard to Exhibit 369.
Yes, thank you, Your Honor.
All right, you may proceed when you're ready.
Mr. Castle, in pages 1 through 14 of this document, you mentioned that this is the catalog.back files. Can you, are these is it your testimony today that these are the shows that were recorded and watched on the DVR system?
Objection meeting.
Or roll.
This file represents content that was viewed, recorded, or watched even in part by the users on this device.
Are you able to determine the timing that these shows were recorded and or watched?
With this document alone, and no.
How can you determine that?
Using correlation and aligning it with the TV guide schedule at the time.
And is this something that you typically do in your line of work?
Yes, using multiple data sources to gain an understanding of context and timeframes is important to understanding the scope of the whole thing. Yes.
Mr. Castle, do you know what dates your extraction data covered?
Based on this document, it does not show the specific date range. I happen to know from TV guide stuff what it may have covered, but this document does not show that.
When you extracted from this DVR, did you extract all the data from the DVR system?
Yes, it was a comprehensive collection of all the data represented on the hard drive, and these log files represent that.
Do you recall what date you collected this data?
Without referencing the forensic image I created of the hard drive, the forensic image of the hard drive I created, I would have a hard time recalling that.
What year would you have done this?
2022.
And so the data included on the DVR system would be from whenever the service plan would have started to when you extracted the data?
I do not know what the log file start date is. I just know when I collected the data. I don't know when the family chose to decommission or stop using this particular set-top box.
We'll come back to this issue. Did the state do an extraction on the dish DVR system?
I don't believe so. I believe they only received what the forensic image of the hard drive contained and the data from me and reciprocal discovery.
One moment, Your Honor. Mr. Castle, during your analysis of the dish DVR system, did you look for History Channel TV guides?
Your Honor, I'm going to object at this time as relevance in 403 that this is a waste of time because, for example, this document from the DVR says the Andy Griffith Show. If this witness is truly going to say that he can identify which specific iteration of the Andy Griffith Show was watched or recorded or whatever show it is, that there was no reruns at any point other than what could conveniently line up with their theory of the case, this is speculative and this isn't worth the court's time in the state's opinion.
Well, counsel, did you wish to respond?
Yes, Your Honor. This is providing contextual information about what was going on in the Mullis home and also provides corroborating evidence regarding the Google searches that were presented at Mr. Mullis's trial. The state at trial presented these searches without any corroborating forensic digital evidence, and we are now able to do so, which relates to the ineffective assistance of counsel claims in this instant PCR.
I mean, as it stands, I don't have any information about the dates that would correlate to this information. So I'm having a really hard time connecting it to anything that could be considered relevant, at least without that information. So, you know, again, if there's some further foundation that you can lay to tie that in some way, you certainly may do so.
One moment, Your Honor. Your Honor, I will just move on for the moment.
Go ahead.
You can. Mr. Castle, based on your knowledge and experience, have you done examination in internet browser-based searches?
Yes.
What is the difference between a browser and a search engine?
A search engine is a program that is built by a content provider that will index and catalog web pages and the data contained on those web pages on the internet. A web browser is a program that is used to view the web pages on the internet specifically.
What would be an example of a search engine?
Google, Yahoo, Bing, web crawler, Excite are all web-based search engines.
What is the example of a browser?
A browser would be Google Chrome, Chromium, Mozilla Firefox, Apple's Safari, or formerly Microsoft's Internet Explorer.
Let's talk specifically about Google. If you were signed into a Google account on a certain browser, does Google track your searches?
It is an option that the user can elect for Google to maintain a comprehensive list of the searches that were conducted in that browser session, and is not necessarily device specific.
And is this typical?
It is.
Can you explain the difference between a device and an account?
A device is a physical piece of compute hardware, such as a tablet or phone or laptop. An account would be the user profile of the individual signing into that device. There can be multiple devices, there can be multiple accounts tied to devices, and synchronization options chosen therein.
What happens if a Google account is logged in on multiple devices?
There will be evidence artifacts of searches across multiple devices represented in the data that Google catalogs. And in the subpoena reply from Google, it will reflect multiple searches conducted on those devices.
Could two people be searching on two different devices on the same Google account?
Yes.
Would this all be saved in the search history for the account?
Yes.
So Google search history is not device specific?
It can be device specific, but it also can be tied to the user account tied to the device as well. So.
And the objection's overruled, the answer will remain in the record.
So if I understand you correctly, just because it is on a Google search history doesn't mean a certain device searched it?
I'm asking you to be a little bit more specific.
So if I had this phone signed into my Google account, and Tara's iPad was signed into my Google account, and I searched on my phone, could this search appear on Tara's iPad?
Yes, based on user synchronization options, absolutely.
Can you explain the difference between a search and web history?
A search is an end user typing a query of word or phrase into the search engine, asking for results. A web history artifact or evidence would be the visiting of a web page or the following of a link from those search results.
Did you review Mr. Hemisath's testimony regarding Todd Mullis 76 Google account?
I did.
Do you recall him saying that there was no evidence of Todd Mullis 76 Google account on Mrs. Mullis's cell phone?
I recall that.
Was that accurate?
No.
Were there indicators that Todd Mullis 76 Google account was tied to or connected to multiple devices?
Yes.
And which devices were those?
The iPad and Ms. Mullis's phone.
Did you review the Google searches obtained from Todd Mullis 76 Google account that were obtained by the state in the underlying trial?
I did.
Mr. Castle, are you aware that Todd's children took a hunter safety course?
I am.
Overruled, the answer will remain in the record.
I would like to show the witness what has been previously marked as Exhibit 306. And just for ease of reference, this has been made into a demonstrative exhibit M that has been provided to the state. This is, sorry. Mr. Castle, what is this?
It is a media document containing information regarding hunter safety.
did you review this over the course of your investigation into the Google searches?
It was one of the documents used as correlation to understand the searches that were conducted across multiple devices.
And are you familiar with this handbook and how it relates to the Google searches found on Todd Mullis' 76 Google account?
I'm going to object that on relevance, foundation, and speculation. There's been no foundation that this document specifically was used or read by anyone or when, and where this line of questioning is going is the exact same as the DVR.
Would you like to respond, counsel?
Yes, Your Honor. This document will show that the Google searches are exactly verbatim for what this hunter safety course purports in there and with the internet searches. And the trial counsel could have found this document and should have known that Todd's children had taken the hunter safety course and would have had access to this information.
Okay, and maybe that's true, but again, as far as foundation for how this witness would know how anything about this would correlate with what he did is maybe unclear at this point. So if you'd like to lay some additional foundation, you can certainly do that.
Mr. Castle, did you review Exhibit 306?
This document.
This document, yes.
I did. During the course of the investigation into the Google searches that were conducted across multiple devices, I noted a pattern that was curious in regards to, they all seem to be related to outdoor shooting activities and firearm safety. Upon further research, I discovered that there was the pattern lined up with maybe an open book test or some type of exam as it regards to the hunter safety course.
And did you review the trial testimony of Mr. Hemisath regarding this series of searches?
There seemed to be some question as to the specificity of the searches being of a violent nature. And to get a better understanding of the pattern there, I wanted to see what came about. It revealed itself to be a series of searches regarding firearm safety and very specifically.
I'm going to object, Your Honor. This is speculation and foundation. Once again, this witness has not established that any particular person in the Mullis family or anywhere else has actually reviewed this document, and it's speculative.
Well, I guess I'm not sure how the witness got this information or what his investigation revealed or where he got this particular guide from. The witness can continue his answer.
Your Honor, in the course of the investigation, when I noticed that the searches conducted on multiple devices, the laptop, phone, and tablet, reflected a pattern of firearm safety specifically and hunting, there was a timeline that emerged that demonstrated an evening of study in regards to firearm safety and hunter safety.
Your Honor, I would like to also note for the record that the state previously indicated that they would not be objecting to foundation or authentication or identification of this particular document.
And while that is true in our preliminary objections, the court did subsequently grant good cause to the state to be excused from the foundational requirements pre-trial. And however that may be, we don't object to the foundation in that we don't need someone to come in and authenticate this document comes from whatever magazine it's from. That doesn't mean this witness has not laid the foundation for how he is aware of this exhibit or how it pertains to this case.
May I ask the witness a few follow-up questions?
You certainly may. I think he had finished his previous answer.
Thank you, Your Honor. Is this document the official study guide for the Iowa DNR hunter safety course?
Objection, foundation, leading, speculation.
It's sustained.
Your Honor, I would like to enter Exhibit 306 into evidence.
Mr. Bakke?
Again, we do not object to the foundation that this is, in fact, a magazine. I would object on relevance to this case as no relevance has been laid.
And again, on relevance point, I still don't have any information necessarily about specific timeframes. Where this came from, I agree. I'm not seeing the relevance yet. It just hasn't been demonstrated by the evidence. If you'd like to continue to lay some foundation, you certainly can. It will not be admitted at this time.
Just one moment, Your Honor. Your Honor, the court may not have reviewed this yet, and I completely understand there's a lot of documents, but there is in the record for this PCR case, in the deposition of TPEM, it does indicate that hunter safety courses were taken and completed. It includes certificates that proves that TPEM and Tristan took these courses and were certified. Additionally, this is the hunter safety course. It is not a magazine. It is this study guide for this hunter safety course that the DNR utilizes. And TPEM's deposition has been admitted into evidence.
And I understand that, and I have reviewed that, and I am aware of that, and I don't think that that's the basis of Mr. Baki's objection. I think his point is that that information hasn't been tied to this witness. I mean, is that fair, Mr. Baki?
Yes, Your Honor.
Okay.
We certainly do not dispute that some hunter safety something was completed at some point, but it's the connection between the two.
Your Honor, may I be heard briefly?
Sure.
Mr. Hemstad's testimony at trial has specific searches, a series of searches that indicate this, that are related to the hunter safety course, and they have a specific date tied to them as they are from the Google subpoena, and so they have the actual date of the search. The certificates that also are in evidence that of the hunter safety course shows just a little bit later. There's also additional Google searches that correspond with the field day searches, which includes the follow-up to the online tests that TPEM was taking on the day of the Google searches. And this is provided in her testimony, but Mr. Castle had access to the Google searches. He had access to Mr. Hemstad's testimony regarding the Google searches and his own experience on using correlative data to understand the evidence and what trial counsel should have done at trial, with Todd indicating that his children had taken these.
So I think Mr. Baki's point, Ms. Steenson, is essentially that all of the factual assertions that you just made in your argument just need to be asked in the form of a question to the witness so that we can get that into the record. If I'm understanding his objection correctly?
Yes, Your Honor.
Okay.
And I would additionally note, it just was pointed out to me that this document is also copyrighted in 2022, which, if I understand correctly, is after this trial.
Well, that's
So are you
not good.
objecting to,
It just plays into the relevance objection, Your Honor.
well, and so maybe this document being used as a demonstrative rather than an exhibit, and I guess I'm a little bit confused about how you're intending it to be used. You referred to it both as Exhibit 306 and also Demonstrative M. So we'll maybe need to clarify that at some point too, but I guess maybe you want to address that as well, Ms. Steen. So,
Oh, are they trying to pull a fast one?
Just to clarify the record for the point that you had just asked, this is, the hunter safety course is what has been previously marked as Exhibit 306. The demonstrative has certain pages from the guide included with the Google searches just for ease of reference. So it is not, we're not jumping from exhibit to exhibit. So it is just to make that exam hopefully a little bit more streamlined, Your Honor.
okay, I understand. Those are two different things.
Yes, Your Honor.
Okay. All right, back then to the issue maybe of some additional foundation for this exhibit. Did you wish to follow up on that?
Yes, I would. Your Honor.
Okay, go ahead.
Mr. Castle, did you review Mr. Hemes's testimony regarding the Google searches on Todd Mullis 76 Google account?
Not only did I review his testimony and transcript, but I also had opportunity to review the subpoena reply from Google regarding the searches conducted across multiple devices.
Did you review, based on Mr. Hemes's testimony, the searches that were testified to in August of 2018?
I did.
And did those searches stand out to you?
Yes, the subject matter contained within those searches was interesting and curious in the means that it was discussing firearm safety, and that some of the searches conducted also referenced the Hunter Safety Guide, specifically the taking of an online test.
Have you personally taken a hunter safety course?
Objection, relevance.
Overruled.
In the state of Nebraska, I did complete and take the Hunter Safety Guide, the coursework, took the test so I could become a hunter in my state. That's what gave me the understanding that some of these searches were relevant to that particular topic.
Your Honor, I'm going to lay an additional objection at this time that I'm unclear of what the scope of this expert is at this point. I believe he testified that he's a digital forensic expert, a network security consultant, and I believe he was only certified for those purposes. And now it appears that he's trying to be certified as a hunter safety expert and some sort of sociologist on what the inner workings of the Mullis family, what they're watching on TV, what they're Googling, and why. And it far exceeds the scope of this expert's background in digital forensics.
Your Honor, may I be heard for
You may.
Mr. Castle has demonstrated that in addition to being a digital forensic examiner with extracting data and analyzing the evidence, he also uses other evidence to examine such evidence for interpretation and investigation, and in showing how correlates and causes, how you can interpret the data. The data used at trial was solely these searches, and was very misleading without this other information surrounding these searches. And that is what Mr. Castle does as his occupation, and he is very well qualified to provide information about what these searches mean with the corroborating evidence.
And briefly, the state likewise believes this testimony is very misleading in that this digital forensic expert is attempting to connect dots far beyond the scope of the foundation that has been laid and beyond the scope of his expertise.
Certainly the court does not consider Mr. Castle to be an expert in hunter safety. Even if he was, that is not an issue that is relevant in any way to this trial. I think we are getting off track and making this issue way more complicated than it needs to be. Certainly the witness can testify about the commonly accepted practices within his area of expertise used to verify data that he extracts from devices or to interpret the data that he extracts from devices. That's where our focus needs to be, I think. And the court's not going to consider him an expert for anything beyond the areas that he is in fact an expert. So Ms. Steenson, if you would like to ask another question, you may go ahead and do so.
Yes, Your Honor. I would like to show the witness what has been previously admitted as Exhibit 270, and I would like to show page 3. Do you see this exhibit?
I'm just waiting for the signal to come up on the screen. It's still not being displayed yet.
Okay.
I'm not sure. Did you switch devices or?
Erica, can you turn on the TV? It's been, well, just so we can see what the connectivity issue is potentially.
And Your Honor, we just discussed, since this is admitted, we're fine with this being to help us all see.
Okay, 270, sure.
I also have a paper copy I can just bring up to the witness if that's all right.
That's fine if you'd like, sure. I'm not sure why it's not popping up on the screen. Did you switch devices or?
Yeah.
Okay.
Mr. Castle, can you flip to page 3 of this exhibit?
Okay.
Do you see a series of searches that are dated August 7th of 2018 UTC?
At the bottom of the page, yes.
And then this continues up to searches that begin on August 9th, 2018 UTC?
Yes.
And just for the clarity of the record, do the searches go sequentially from the bottom of the page to the top of the page?
Yes.
The search dated August 9th of 2018 at 17:38 UTC. Can you tell me what that search is?
What fraction of firearm incidents occur in the home?
And based on your knowledge and understanding of UTC time, and your knowledge of, what time would this search actually have been conducted in Iowa time?
So it's in the time denoted in UTC is in military time or 24-hour time period. So it's not denoted in 12-hour time period. So it's 17:38:25 seconds. So if you subtract at this time, in August would have been daylight savings time, so 5-hour offset. So it would have been 12:38:25 seconds. Would have been the time UTC according to that entry in this document.
And what would that be in Iowa time?
I'm sorry, in 12-hour, I just gave it to you. The minus 5 hours is 12:38:25.
Thank you.
And that's UTC time codes. Yeah. The adjusted for 12-hour period would have been. It doesn't. Sorry. 1,700 hours minus 5, 12 hours, 38 Central Standard Time, daylight savings time adjusted.
Is there a search just a few moments later?
Which one specifically are you asking for?
The one just right above.
Search for examples of elbow carry of a firearm.
And what is the next search that occurs?
The search for checking for obstruction in your firearm.
And what time is that search done?
17:43.
And now I believe that the exhibit is on the screen. Do these searches continue through August 9th, 2018 at 20:21:42 UTC?
They do. And as you can see from the not only just searched but visited web pages, there are references, multiple references to different states' hunter safety guides.
What indicated specifically in these searches to you that they were connected?
The time frame in which the sites were searched and the subject matter visited subsequently. So there would be a search for a topic surrounding firearms or hunter safety, and then there would be a web page visited pertaining specifically to hunter's education.
Can you look at the Google history, same page, August 9th, 2018
at 174416 UTC. Can you tell me what that website that was visited is?
You said 17 what?
174416 UTC.
Visit it. Quizlet.com, Hunter Safety Quiz, flashcards.
And the visited site right above that, can you tell me what that is?
huntersed.com/Washington/study guide, loading and unloading steps of a firearm.
And a few searches up at 174852, can you tell me what that Google history is?
I'm going to object that this exhibit speaks for itself. This was admitted, I believe, as Exhibit 105A at the underlying trial, according to the sticker on the front page. The court can certainly read every search and visited site if it so chooses. The jury would have had this to the Google searches to review for themselves. I just believe under 403, this is a waste of time in the state's opinion.
Your Honor, may be heard briefly.
I'll allow the applicant to make whatever record they think is necessary. If you want to continue, Ms. Steenson, you may, so the objection is overruled.
And do these searches based on your, and this Google history based on your knowledge, experience, and education indicate that they are for a hunter safety course, people searching for answers to potential questions?
Objections beyond the experts go. The exhibit speaks for itself.
Overruled.
Yes. The searches and subsequent visits to websites would reflect, as far as pertains to digital forensics artifacts and evidence, the viewing and searching for subject matter pertaining to hunter's education and a test therein.
So just for the record, do you find this correlative nature of the searches, starting with the first search we mentioned on August 9th, 2018 at 1738 UTC, what fraction of firearm incidents occurred in the home, that is related to the search of elbow carry of firearm?
Overruled.
The searches as reflected in this document show a pattern of a given subject surrounding firearm safety, then a visit to a web page very specifically having to do with hunter's education and firearm safety.
Can you look at the search dated and timestamps August 9th, 2018, 1751-53 UTC, and can you tell me what that one says?
It was a search for actions to take if one falls into cold water.
And can you tell me what the next search history is for that search?
It very specifically reference the search of what actions to take when one falls into cold water. There was a visited website directly after that search on boat education, what to do in falling into cold water treatments as a result of that search.
So your expert opinion, is it your expert opinion that the searches from August 9th, 1738, 25 UTC through August 9th, 2018, 20, 21, 49 are all searches that relate to hunter safety course?
Objection. The foundation hasn't been laid for how these all connect in relevance.
Overruled.
Chronologically, in time, they show a pattern very plainly of a search for a topic, and the topic then visited of a web page that directly correlate to firearm safety, hunter's education, and survival of outdoors. The web history and searches reflect that pattern. The correlation of that data seems fairly straightforward with the evidence of these searches and web history visits.
I would like to talk about Mrs. Mullis' cell phone for a moment. Based on your review of digital forensic evidence, do you know that Mrs. Mullis created her Amy Mullis 5810 account on July 19th, 2018?
There appeared to be a new account created on Ms. Mullis's phone, as reflected by the web history and as well as some unique dialer codes reflected in her call log.
And is it your understanding that she used this email address to solely communicate with Jerry Frazier?
Objection, foundation, irrelevance, speculation.
I would like to show the witness what has been previously admitted as exhibit, I believe 308.
Did she rule on that objection?
Withdraw the question or respond to the objection first?
I would like to lay some foundation if that's
Okay, go ahead.
Can you pull up exhibit 308? And can you scroll to the last page? Does this exhibit show the communication between Amy Mullis and Jerry Frazier?
The document shows a number of email threads as communicated by the amylin5810@gmail.com and an email account of Jerry Frazier70@gmail.com. 70@gmail.com. And again, as prosecution counsel mentioned, these items are
I
truncated.
don't believe this is responsive to a pending question.
Let's have a new question, please.
Yes, Your Honor. Based on your extraction and an analysis of Mrs. Mullis's phone and her email records, did Mrs. Mullis email anyone else using the Amy Lynn 5810 Google account?
Objection, there's not foundation laid that this is every email ever sent. This is an extraction of a device, I believe, not an extraction of the Gmail account itself, unless I misunderstood.
I guess I understood it maybe the same way. Do you want to clarify that, please, counsel?
Yes, Your Honor. Mr. Counsel, did you analyze Mrs. Mullis's cell phone?
I did.
Did you analyze her email address, Amy Lynn 5810 Google account?
As the artifacts or evidence was represented on her phone, yes.
Did you receive a subpoena response from the state's discovery on the underlying criminal trial of the Amy Mullis email account?
I did.
Based on your analysis of all the evidence and all the data related to the Amy Lynn 5810 Gmail account and the phone records of Amy Mullis, were you able to determine that Amy Mullis only emailed Jerry Frazier through this email address?
I'm going to object on speculation, although I understand that that's all the data he saw. I think it's too far to say that conclusively is all the data that exists.
Your Honor, may I be heard briefly?
Objections overruled. The witness can answer if he is able.
Based on my recollection, yes, this Gmail account created by Ms. Mullis on her device was the primary modes of communication between herself and the account of jerryfasher70@gmail.com.
Do you recall a search regarding checking the content of text messages on the phone?
I do recall that search.
I would like to publish what has been already admitted exhibit 270 on page 7, which is the Google searches.
You may. The witness has just asked for some water. Maybe if someone, counsel perhaps would like to grab that. Thank you.
Thank you so much.
I've never watched one of these before. It's a post-conviction relief trial or hearing, whatever it's called. Is it my imagination, or is the judge being like really lenient because the state's making really good objections? Like, how does this guy know about the hunting classes and I mean, like, he's delving into a lot of information that I've never heard brought up in a trial before. Like, you guys were talking about the things that they watch or recorded on their DVR or whatever. Like, and the judge is like, overruled, overruled, overruled. Like, is it normal in this kind of a thing? Like, first of all, he lost his appeal, and then he gets this. What is the criteria that allows him to get this hearing or trial or whatever it is in front of the judge? And now she's being like super lenient. And I mean, she's sustained stuff too, but it just seems like she's bending over backwards to let the defense counsel get all this garbage in. But at the same time, the Googles were about guns, and she wasn't killed with a gun. I'm so frustrated. That makes sense. That makes sense. Because like she said about the evidence that was being presented without being asked to be put into evidence, and the judge was like, well, there's no jury, so I don't care about that. Maybe that's why. I don't know. Now I really, really want to watch the original trial. Maybe we can do that as like a members only thing, like every Saturday until we get it knocked out. Like 4 or 5 hours every Saturday. Sound good? I don't know. I was also thinking about maybe doing like a catch up on Karen Reed for the ones that didn't watch the first trial. I don't know. I'll do a post about it. We'll figure it out. But now I really want to watch the original trial. If you guys want to watch it, if we decide not to do it, but it's on Court TV's website under the Legendary Trials tab. So it is available to watch. And now I have probably done a very bad thing because you know how StreamYard hates it when I mess with anything. Oh, look, it did what I told it to do.
Are you able to see the exhibit?
I am now.
Okay, so for the record, this is exhibit 270, page 5. Is there a search on July 21st, 2018 at 1:43:39 UTC?
Yes, I see that entry. That entry reflects a search for checking content of text messages on a phone.
And was this search conducted in UTC time?
That is what the document reflects.
And what would that be in Iowa time?
Eight. Sorry. 1:43:39 is the one wanted, so it'd be 8. 8 a.m., I would believe.
And this would, so this was on July, this would have been on July 20th, 2018 at 8:43 PM.
Sorry. No, I believe it'd be 8 a.m. If all this is in 24-hour time period stamps, then that would reflect a 1 p.m. UTC time code stamp or minus 5 hours, 8:43 a.m. time period stamp. If these are all reflected in 24-hour time clock designation.
So this is 1:43 a.m. UTC, so minus 6 hours would be 8:43 p.m., is that right?
Yes, I apologize for that mistake. That would be correct.
And this would have been done on the preceding day of July 20th, 2018, instead of July 21st, 2018?
And to correct my mistake, the 24-hour time period designation would have been 1,300 hours for a 1 p.m. time frame, so I apologize for that mistake. Yes, that is correct.
Was there any information in the phone records you examined that corroborated this, correlated with this search?
I'm gonna object on foundation on that. This appears to be speculative.
I'm sorry, what appears to be speculative specifically?
I guess I'll withdraw the objection and see where it goes.
Okay. Do you remember the question, sir?
She was asking me if this search correlated with an evidence artifact on the phone records for this device as well.
And you may answer that question.
Yes, it did correlate to an interesting record on the as an entry on the phone record. Specifically, as a very short phone number that was an incoming artifact.
Just one moment, Your Honor. Mr. Castle, did you review other Google searches connected to other Google accounts such as Mullis RN Google account?
In my review of all this data, I had opportunity to review the subpoena returns for multiple Gmail accounts. And it was all taken into consideration in building my conclusions and understanding of these events, yes.
And were there similar searches on this Mullis RN at Gmail account to the search presented in Exhibit 270?
Yes.
I'm going to object as vague and overly broad. This is 270 is 12 pages of, I don't want to characterize a number on it, but it's a lot of searches.
Can you ask a more specific question, please, counsel?
Yes. Based on the search we just mentioned about checking the content of text messages on the phone, were there similar searches on the Mullis RN Google account that you saw during your analysis and examination of the forensic digital evidence in this case?
As previously stated, there were multiple accounts tied to Ms. Mullis's phone. the Mullis RN account and the Amy Mullins 5810 account being tied to the device. There were parallel searches that were conducted with these accounts tied to the device. So yes, there was overlap of the searches as conducted on this device.
Your Honor,
Yes.
this is, as you can tell from the people sitting at this table, we're having a little bit of a technical problem pulling the exhibits that we need for this witness. And that is obviously the fault of the attorneys, but we're having a little bit of a technical problem doing that. And I don't want to waste the court's time, and I don't want to waste the witness's time. And I'm wondering if it'd be possible for us to possibly take an earlier lunch so that we can get these exhibits pulled, so that we can move through this, so that we can move expeditiously, which I think is our goal, Your Honor.
Certainly, if you think that's the best way to use our time, we can do that. It is about 11:30 now. Are you thinking you'd want to break until 1, or should we come back a little earlier?
I think one would make sense, Your Honor.
Okay, let's take our lunch break. We'll plan on resuming at 1 p.m. Thank you. Sit down, Mr. Kessler.
Lunch is over.
You're fine. Okay, we'll go back on the record. Mr. Kessler, you can return to the stand. I would just remind you that you remain under oath. Oh, sorry. Okay.
I just mentioned this to Mr. Mullis' attorneys, but my understanding is there are 2 witnesses who have arrived in the courthouse who are here under subpoena, both from the Des Moines area. I just want to make sure that we accommodate them if possible.
Okay. I guess, counsel, what are your thoughts about then how we spend our afternoon?
We feel the same, Your Honor. Our goal is to finish this witness expeditiously and move on.
All right, we'll plan on that. Ms. Steenson, you may pick up with your questions whenever you're ready.
Thank you, Your Honor. Mr. Castle, we were talking before break about the creation of Amy Lynn 5810 Google account. This was the Amy Mullis Google account that was only on her phone and not on the family iPad.
That's correct.
Beef stroganoff.
And from your testimony earlier this morning, this was the later created of the 2 Google accounts that you associated with Mrs. Mullis.
Her device, yes.
Do you know when that Amy Lynn 5810 Google account was created?
Without referencing the exhibit that contained that artifact, I don't recall off the top of my head.
With looking at the metadata TXT file from the extraction of Amy Mullis's cell phone, refresh your memory. Can you just show that? Do those guys need it? Yeah, I'll show it. I'll show counsel what we are putting up, what we're putting on. I would like you to just read this to yourself.
Thank you.
Okay, you can move it. Did that refresh your memory about the creation of Amy Mullis's Gmail account?
Yes.
And what was the date of that?
July of 2018.
And what was do you have the exact date?
19th.
Thank you. So July 19th of 2018?
That's correct.
Now I want beef stroganoff and I don't have the stuff to make it.
Did you review or extract data from a phone connected to Mrs. Mullis's phone with the last 4 digits 5678?
Yes.
And 5675. I apologize. I misstated that. The last 4 digits 5675.
I believe that was the number associated with that other device, yes.
And do you recall when the data on the phone started?
No, because the state just couldn't stop objecting and objecting and objecting. Although the judge kept overruling the objections. Were you here when they started talking about the hunting classes? After they did the TV viewing history, then they started talking about they were taking like an open book test on hunting safety. So a lot of the Google searches were about gun safety, but it was because they'd taken a hunting class. But I don't know why they would use Google searches about guns. Because she wasn't killed with a gun. So how did they hold that against him? We're going to have to watch the original trial. That's just, I don't know when we're going to have time, but we're just going to have to at some point. So they were having trouble with their tech. So they took an early lunch. I think that's pretty much all you missed was the part about the hunting class and a lot of objections because the defense attorneys were not good at laying foundation about why this guy knew about the hunting class stuff. That's basically, I think, the only thing that happened while you were gone.
I don't.
Would it refresh your memory to look at a copy of the extraction
Yes.
data? Just one moment. I will have to bring this up to him.
Interesting. I didn't know that. I live in Florida.
Okay.
Did that refresh your memory?
Yes.
You don't even
Mr.
have to
Castle, when was
register a
the
gun in
first,
Florida.
Earliest call on this phone.
July.
What was the date?
I believe it was the 14th, if I remember looking at that. Was it July 14th, 2018?
Can I
Sorry.
approach the witness again to refresh?
Certainly.
I apologize. It was July 22nd.
Does that mean that there was no data on her phone prior to that date in 2018?
No, there was data on the phone.
But no, what data would be available on the phone then?
The artifacts represent the activation of the device and the new call log beginning.
So the call from, was there, what data then was missing before July 22nd, 2018?
Sorry, I'm having a hard time following your question. You're asking me, first of all, when this number started being used as it was tied to which device specifically?
The cell phone that you extracted.
Okay. And
Let me re-ask the question. Based on the cell phone that you extracted for Amy Mullis, and your testimony today was that the earliest call on the phone was from July 22nd, what does this indicate to you?
the possibility of a factory reset.
Did you receive and review Google search history from a subpoena to Google showing Google searches associated with the Mullis RN Google account?
I did.
And did any of those searches search for the term related to the recovery of a phone?
It did.
And what does it mean to recover a phone?
The end user chooses to possibly reset the phone back to its default configuration due to troubleshooting steps or obfuscation of data contained on the device.
Is that sometimes? Can you tell me what you mean by that?
So troubleshooting, meaning that the end user was possibly experiencing some problems or issues with the device. At the instruction of the carrier, they may have reset the device to solve those problems because a factory reset will put the software in a default configuration, which will eliminate a lot of problems. Or secondly, the obfuscation of data, meaning that they reset their phone to hide something.
The search you saw from the Mullis RN Google account relating to the recovery of an LG phone, do you remember when that search was from?
I believe it was in the July timeframe.
Do you know the specific date?
I thought it was around a couple days previous to the reset.
Would it refresh your memory to review the metadata files from the search of the extraction data of the Mullis RN account?
Yes.
Okay, I will show opposing counsel. May I approach?
May.
If you could review this for me, Mr. Counsel, starting right there.
So this entry here, the entry right above it. So on,
Okay, just review it.
okay.
Do you have an independent recollection based on your review of that?
Yes, there was a search on the 20th of July, and then again earlier that day on the 22nd.
I would like to publish what has been previously admitted as Exhibit 374, page 55, which is Amy Mullis's U.S. cellular phone records. Do you see this?
Yes, I can see the phone records.
Approximately what dates does this specific page cover?
From the 19th through the 26th of July,
In what year?
2018.
And this is, just for clarity of the record, this is page 55. Does,
Sorry, page 55, the exhibit.
well, I'll just represent to the court that this is page 55 of the document of Exhibit 374. Does this phone record on this page show SMS activities associated with Ms. Mullis's phone?
Yes, it shows both SMS and MMS messages.
And can you tell me what that means?
SMS is signal messaging service for plain text messages received or sent from the device, and MMS is multimedia messages sent or received from the device.
Looking at this particular page, there is an SMS number that is shorter in length. Can you like that? Can you tell me the date and time of that entry?
Yes, it's 3:04 p.m. on 7/22/2018.
And can you tell me what a short SMS code?
Judy, I think they're trying to say that the state entered evidence of his Google searches and that they were used to make him look guilty because of the things he Googled. But I don't understand how Googling things about a gun and what was the other one about cold water? Like survival type stuff while you're hunting. I don't see what any of that has to do because she didn't die that way. And that's why I asked about why is the judge being so lenient about overruling the state's objections? Because it doesn't seem relevant. A lot of this doesn't seem relevant. Unless she thinks that the defense is making sense. But I think what we're missing is that we didn't watch the first trial. Because maybe we would understand a little bit more about why these are relevant if we'd watched the first trial. Because I don't see how Googling things about guns matters in a case where someone was impaled in the back with a corn rake. Unless, was there something in the first trial about him previously attempting to do something to her? That's what we don't know. Then those Google searches could be relevant. But we're missing that because we didn't watch the original trial. I think that's why we're confused.
It is.
It's typically used by carriers or subscribers to do a couple of things. One, either an advertising blast that would be received via SMS, or possibly a two-factor authentication code sent to a device for authentication purposes.
So this potential re-authentication or of a Google account was at the same day as the search on the Google, the Mullis RN Google account about recovering a phone?
Yes.
Did you review Mr. Castle, do you have experience with obtaining and interpreting cell tower location data?
I do.
Can you tell me a little bit about that experience?
Yes, in multiple cases that I have either offered affidavit or testified in, I have received subscriber intelligence data as it pertains to call data records, per call measurement data, and other similar type signals information that allows me to triangulate and locate the handset of a given subscriber.
Can you explain in general terms what cell tower location data is?
Yes. There are several spreadsheets that are created as a result of the subpoena to the carrier of Verizon or AT&T that are given to the government in response. That data contains multiple items that are used to build triangulation and mapping of the handset. Those are the geolocations of the cell towers themselves and the pointed direction of the antenna on that cell tower. They are in a 120-degree grids, which would make a 360-degree grid array combined. And then with the call data records as applied to the communications coming off the device, whether they be SMS calls or MMS, those signals are used to triangulate the location of the handset in relation to the cell tower at the time of that communication. That's as it pertains to call data records. Now, protocol measurement data, which is a specific carrier term, is a measurement that is taken. Radio frequency travels at the speed of light, which is a determinate variable, and can be used to triangulate handsets. It is a more accurate measure of where a handset may be than call data records, as it is a radio frequency transmission communication between the handset and the tower itself. This information is more accurate simply because that measurement is taken periodically as the handset moves. As a general rule, mobile cellular talks to the tower that has the best signal strength. So that has to be determined. That's determined by this measurement of the radio frequency and its signal strength in relation to the handset and the tower itself.
So just to put it in a little more simpler terms, can the cell tower location data help an expert determine the location a cell phone was at the time it was in use?
Yes.
Did you review phone records of Jerry Frazier?
I did.
And where did you get this information?
I received it as part of the data I got from the government.
And what did you receive originally?
Originally, I received only a few pages or excerpts from these documents that would typically be turned over by the carrier.
I would like to show what has been previously marked as Exhibit 298. Mr. Castle, what is this?
This is a part of those batch of documents that I referred to that will be received from the carrier. This specifically talks about the geolocation of the cell tower and the direction that the gridded array would be facing. Correct.
And this provides.
Yes.
You can take that down. I would like to show what has been previously marked as Exhibit 299. Can you tell me what this is?
Again, this is an excerpt of what would have been a total data dump from the carrier containing data as it pertains to, as I stated earlier, the call data records of the CDR and SMS communications coming off of a handset.
And this is what, this also was previously, this was originally provided to you in 2022?
Yes.
Based on your analysis done with these two documents that I just showed you, what did you find?
My conclusions were incomplete because these documents are incomplete. I did not have all of the data necessary to do a proper triangulation or mapping of the handset in question.
Was there any data on November 10th of 2018?
No.
Did you ever review any other documents regarding Jerry Frazier?
At a later date, I was ultimately provided with all of the call data records and necessary information to build a more comprehensive mapping of the data, but this was after I had authored my original report.
Would these documents, these that you were presented later, potentially change your opinion about whether it was possible to determine the location of Jerry Frazier's cell phone on November 10th, 2018?
if the data was not reflected for that date in particular, no, it would have not aided me in producing a location of the handset for that particular day. It did aid me in understanding where the handset may have been on all days previous to that.
I would like to publish what has been already admitted as Exhibit 271, page 11. Can you highlight that there just like here at the date of July 2nd, 2018, what is primarily being searched here?
The subject matter surrounding Ohana tattoos.
And were you aware of any communication regarding Ohana tattoos in the digital evidence that you reviewed?
Yes, there was a conversation in the communications between Ms. Mullis and another party surrounding her getting one of these Ohana tattoos.
I would like to publish
What the
has
hell?
been previously admitted as Exhibit 262. Page 1. And looking at the top of, can you tell us what this document is, purports to be?
It appears to be the communications between Ms. Mullis and another party.
And at the, and can we scroll to page 7? Can you tell us what the date of this text message is?
This document would seem to reflect that the communications happened on July 2nd. It doesn't state a year in that time date stamp.
You can take it down. I would like to show the witness what has already been admitted as Exhibit 271 on page 57. Mr. Castle, you previously mentioned that you knew the iPad was activated on August of 2017. Why was this significant in your analysis?
It appeared that there were Google searches that were conducted previous to its activation.
And in looking at Exhibit 271 on page 57, can you tell us the date of the first search?
The first search that Google has record of for this account happened in March of 2017.
Mr. Castle, did you review the Galaxy DVR security cameras from the Mullis family farm?
I did.
And did you perform data extraction on the security camera system?
I conducted my own independent collection or extraction of the data, and then I also conducted an analysis of the data contained within that hard drive image.
Can you tell me what your analysis and conclusions were?
After the proper procedures followed for the collection of that device, I took the opportunity to extract specifically the system's log file of that DVR, which reflected the communications of the cameras with the DVR unit itself. The cameras were a wireless connection to the DVR and reflected a number of disconnections over a period of time.
I want to break this down just a little bit. Did the system record any footage from October 29th?
Ohana means family. Family means no one gets left behind or forgotten. I thought she said henna at first too. And then I heard Ohana. And I was like, what the hell? That's why I said, what the hell? Is that supposed to prove that their marriage wasn't on the rocks? Because someone was Googling Ohana tattoos?
'18 to November 11th, 2018?
I did not appear to have made a record of any recordings for that time period.
Could you determine whether any video footage was deleted during that time frame?
Yes, I was able to determine by doing analysis on the file system that there were no video files written for that time period, so there would not been any files deleted for that time period.
And can you remind me what program you used for this extraction and analysis?
I used FTK Imager to create the hard drive image, and I used DME's DVR Forensics, the same title the government used.
So this was the same program that was used by the state?
Yes.
Was there any activity on the camera at all between October 29th, 2018 and November 11th, 2018?
The log files reflect that there were a disconnect of the cameras from the unit itself.
Why would a security system stop recording?
Objection calls for speculation and foundation.
Overruled.
The log files represent a connect and disconnect of the cameras, which again were a wireless connection to the base unit. And this connection and disconnection of the cameras to the base unit would be an explanation as to why there was no footage recorded at the time.
Did you learn through your review of the materials where the camera DVR system was located?
I learned from materials, and also in September 2022, when I visited the Mullis family farm to retrieve a number of these devices I had opportunity to extraction on, I did a site survey to determine what building and office the base DVR unit was located in relation to the cameras that were on the hog barns independently.
And what was significant about having this knowledge?
It gave me a physical awareness of where the cameras were at in relation to the base unit itself.
So how did this impact your analysis and conclusions?
It was a further correlation that demonstrated the accuracy of the log files and their reflection that the cameras had disconnected from the base unit.
Did you review Mr. Hemseth's testimony regarding the camera system footage?
I did.
Did he testify that he could not tell whether the camera did or did not record?
Objection transfer to
Overruled.
Yes, I do recall that. He may have not had opportunity to look at the log files that I did.
Was his statements true?
Objection, this is improper opinion testimony.
Overruled.
It would appear that they did not have all the data necessary to make that conclusion.
Is your conclusion based on the data that you extracted?
It is.
And this is also the same data extracted by the state?
They had access to the data. I don't know whether or not they extracted or did analysis on that data.
But they had access to the system log to come to the conclusion that there was no data on the phones, on the cameras between October 29th and November 11th?
Objection leading.
Overruled. The answer will remain in the record.
Can I have a moment?
You may.
If you were called to testify at Mr. Mullis's trial in 2019, could you have offered this opinion? All these opinions?
I've been retained by counsel for the purposes of analysis in these matters. My findings would be as they are.
Thank you. No further questions at this time.
Cross-examination.
Thank you, Your Honor. I'm going to pick up where we left off. Your testimony was that your findings would be as they are, right?
With the exception of the satellite, with the exception of the call data records and the mapping of the handset, yes.
So that means you used the existing software versions that were available at the time of the trial in 2018, and you didn't use any new versions of software, is that right?
I did have a couple newer versions of software, but it did not reveal any additional data that I used as part of my findings.
So let's break that down a little bit. So you stated that you use several different types of software. So for example, you use Celebrite, I believe Magnet Axios, and FTK, among
Yes.
others. So we'll use Celebrite as an example. Celebrite comes out with new versions of software as time goes on, right?
Often on a quarterly basis, yes.
And
on a quarterly basis, oftentimes, yes.
Thank you for clarifying that. So in those software updates, Celebrite would change how it extracts information from devices, right?
Sometimes, yes.
So for example, it might change what encryptions it can break or new versions of iOS or Android that it can extract data from.
Yes.
And that would be the same for the other types of softwares that you used?
There are often enhancements contained within updates, yes.
And as part of those updates, they're able to extract more information as, for example, Android software gets older, they can find new exploits to look at that information, right?
Yes, that's true.
And if you use a newer version of Celebrite software, just as an example, you might get new or different information than what was available in 2018 based on old versions of Celebrite. Isn't that fair?
I think that is fair.
I guess continuing to work our way backwards through your testimony, you finished, towards the end, you finished off by talking about the Galaxy security camera system. So essentially, you're relying on the logs to indicate that the cameras were never connected. Is that your testimony?
The cameras are disconnected for a period of time over the life of that DVR, and specifically in time frame I was questioned about.
And you don't know why they weren't connected, right?
As established between the main unit and the cameras, represented a disconnect.
So you don't know what caused that disconnect beyond that? Is that fair?
Until the physical inspection of the site, that would be correct.
So for example, if I guess I'll just say this, you don't know specifically what caused any disruption or disconnection of the cameras.
That's fair.
Thank you. In your report, you discuss the Galaxy camera software and the extraction done by the law enforcement officers. Is that right?
Yes.
And I'm turning to that section of your report, and do you have this report in front of you?
I do not. I don't
Okay.
know that it was admitted.
Just to move this along, I'll read from it and just make sure that we're on the same page. So on page 11 of your report, you state, and just tell me if this sounds wrong at the end here, according to a DCI examination synopsis report, Deputy Hemiseth attempted to access the security camera system without the proper software or extraction tools. Does that sound familiar from your report?
It does.
Do you now know that testimony or that portion of your report to be false?
Objection.
I asked if he knows.
What's the objection?
It assumes what it assumes what it is saying.
Overruled. You may answer if you can.
I'm unaware from trial transcripts or the report from DCI that former Deputy Hemiseth had opportunity to review the log files as reported that I did.
In preparation for your testimony today, I believe you indicated that you reviewed Ward Crowley's report and his testimony. Is that true?
In part, yes.
In what part is it untrue?
I recall reading it. I don't recall the totality of it at the moment.
Were you aware that Ward Crowley specifically testified, which is in evidence here, that this is not what occurred?
In what aspect?
Were you aware that it was DCI Special Agent Ward Crowley who conducted this attempt of the extraction of the security camera system at the Sheriff's Office and not Sheriff, then Deputy Hemiseth?
I do recall that aspect, yes.
Okay, and then your report continues on to say that I'll just read it since you don't have it in front of you. You say, DCI Agent Ward Crowley attempted to assist Deputy Hemiseth remotely while Hemiseth tried to conduct an on-site examination of this device at the Sheriff's Office. Does that sound familiar?
Yes, it does.
And you now know that that's not true based on the testimony and evidence here, right?
Hey, I'm sorry, which aspect of the testimony?
Well, you say in your report that Ward Crowley assisted remotely, but he testified in this proceeding that he was there in person, right?
Okay. That part of the testimony I must have overlooked. I apologize.
I'm sorry, you just testified that you reviewed his testimony, right?
In part, in that I don't recall every aspect of his testimony.
That misstates his testimony. You're referencing a report here, and testimony is different than report.
Yes, you've admitted the report and evidence.
That's not necessarily what he's reviewed. And that's not his testimony today, that he's reviewed the report.
Your Honor, I think I can clear this up briefly. I'm referencing the deposition of Ward Crowley, which is admitted into evidence here. Ward Crowley specifically explained how this extraction occurred. If they want to point me to something that contradicts that, I would be happy to revise my question.
Okay, and again, I think her point was that this witness maybe wasn't present at that deposition or wouldn't have that clarification necessarily. Let's just have a new question, please.
Thank you, Your Honor. If I understood your testimony earlier, and I just want to get clarity on this, your testimony on direct examination was that you reviewed the report and testimony, which would only be the deposition from this PCR of Ward Crowley. Is that correct?
an opportunity to read that deposition. I do not recall the part where he was on site to do the analysis of the log files that were extracted specifically. My report in spirit reflects the fact that the log files about the connections between the main unit and the cameras were disconnected.
And maybe I can help clarify here. Do you recall any testimony from Ward Crowley in your review where he discussed attaching the physical right blocker device to the system?
I do recall that.
Okay, so would you agree that if he was attaching a physical device to the system, he would have to be there in person?
That would make logical sense, yes.
And there was some discussion in his testimony, without getting too granular, where he referenced using a trial version of the software. Do you recall that?
I do. I also recall during the course of that interaction that there was a phone call between the two of them regarding his analysis as well. And that may be what I was referencing when I was talking to the remote assistants.
Thank you for clarifying that. So you completed a report in this case, right? This is the general report of your findings that we've been discussing?
Yes.
Have you completed a supplemental or updated report correcting any of these discrepancies since this report?
No, I've not been asked to do so.
I briefly want to talk about your background. At the beginning of your testimony, you talked about your background into digital forensics and network security consultant. Is that right?
Yes.
And you referenced dealerships as part of your background. That specifically is car dealerships, right?
Yes, in the automotive industry.
Okay, so your CV, where it indicates that you worked for example, Sid Dillon, Chevrolet, Buick, GMC, Cadillac, Mazda, Nissan, Hyundai. That's the example of your background working at dealerships?
That's one of them, yes.
Okay, and then you worked for other car dealerships?
Yes.
You don't dispute that the Google searches that all of the Todd Mullis Gmail searches that were in evidence had to have come from some device connected to a Todd Mullis Gmail account, right?
Can you rephrase?
Yes, it's poorly phrased, I'll admit that. Just for clarity, we have the Google subpoena results, right?
Correct.
You're not disputing that all of those searches came from something connected to that account, right?
Correct.
And you have no way to know who specifically is on the other side of those Google searches?
Yes, that would be correct. Attribution in its truest form and understanding the patterns of usage and searches conducted. Unless there was someone that could visually witness the searches being enacted, it would be difficult to tell who was responsible for them.
Fair enough. You had some testimony about the correct meaning of UTC time, right?
Yes.
And although you referenced Deputy Hemeset getting that wrong in his testimony, you also had difficulty converting UTC time today, right?
I did.
Just so we're clear on the issue of the dish DVR, you can't specifically say what show is watched on what day in this case, right?
By the correlation of the TV guide and the unit itself, it's still some difficulty producing the exact date in which some of those videos were watched. You are correct.
And would it be fair to say that shows can be re-aired?
Absolutely.
You had a reference to, or I'm sorry, one follow-up on that. You also don't know who was watching the show that would be on, right?
Correct.
Thank you. If you can just clarify something for me, you referenced based on user synchronization options, the searches can show up on other devices. Can you just explain what that meant?
Yes. When you sign into, as an example, the Google Chromium or Google Chrome web browser with a Google account, you are presented with options. Those options would be to synchronize those searches and history on that account with that browser. So there is a way to opt in or opt out of that synchronization happening across those multiple platforms and devices and browsers.
And are you aware if the user synchronization options were enabled or disabled on the various devices here?
No.
You testified on direct examination that the correlation of Google searches seems pretty straightforward and obvious, or something to that effect. Does that sound right?
The correlation of the Google searches to other data points available to me as part of the investigation does outline a pattern.
So if it's straightforward and obvious, we wouldn't necessarily need an expert to tell us that part?
I would agree with that.
You spoke about Ms. Mullis's phone possibly being reset, but you don't have any firsthand knowledge of why the phone was reset, right? In other words, you weren't personally there to know why?
Correct.
And because I believe you testified that it could have been for a variety of different reasons, right?
Correct.
So you can't say definitively why it was reset without speculating, fair?
The analysis of the web history and searches happening up until the point of that reset would offer some insights into the possibilities.
You also testified about your experience working with cell phone records, extractions, location data, that type of thing, right?
Yes, I did.
And you described for us what SMS and MMS messaging is.
Yes.
Would it be correct in saying that SMS actually means short message service?
It's another acronym that's synonymous with the messaging style, yes.
Looking at the VOLTE records for Mr. Thrasher, would it be fair to say that there would be a tower code in the column of those documents?
Without looking at it again, I'd have to refresh my recollection.
I can try to do that. Give me one moment. I guess I'll speak generally without getting specific. Would it be generally true that documents would, or excuse me, that CDR records might have a column that indicate what tower was being connected to?
Oh, absolutely.
And based on that tower code, would you agree that anyone, if they know what website to go to, could figure out where that tower is with some effort?
As far as like just putting the latitude and longitude coordinates into a browser to determine its location?
Going the other direction, is it possible to take that, say for example, just hypothetical here, that we know someone connected to a US cellular tower and we have a tower identifier. Is that something someone can take and figure out where that tower is?
It depends on the public records release of the carrier for those locations.
Is it possible?
In this random number generator of a universe we live in, anything's possible, sir.
Fair enough. I want to direct your attentions. You discussed doing, in addition to your general report, you did reports of various extractions of devices, right?
I did create reports of specific communications or data points out of some of the devices I did extractions on, yes.
And one of those reports that you did, I believe you titled New Conversation or New Convo Report. Does that sound familiar?
It does.
And would that be in reference to Mr. Mullis' cell phone?
Without referencing the document itself, I'm not recalling specifically which communications those are referencing.
And I can attempt to plug this in here so you can take a look at it, and this will be just for the witness, Your Honor. Yeah, it's the instruction. Let me know when you can see my screen here.
I see a source extraction data in regards to a phone.
And this is your name up at the top here, is that right?
Yes.
Okay, I'm going to scroll through this briefly. I just want to make sure we're talking about the same document here. What would you need to see to identify what device this was from?
So it mentions the selected device name underneath the device name and manufacturer. And it also, oops, I'm sorry, the documents, sorry. So it gives a general idea of the device name there and the brand. Is there another page that gives more specifically the IMEI or some other unique identifier for the device itself?
I'm sorry, I was being asked just a clarification question from counsel. Can you just state that again? I just want to make sure we're on the same page.
Okay, so it shows a device name and it shows brand. It doesn't show the specific serial number or unique identifier for the device itself that I can see here.
Okay, I'm going to scroll down to the content, see if that helps us get on the same page.
Okay, I'm sorry, I still don't see anything that uniquely identifies the device that this came from.
Okay, let's look at, but you agree this is a report you generated in your investigation, in your analysis?
It was an extraction report, yes.
Okay, I'm going to scroll down just so we can move on. So what we're seeing now are various messages that have been created as part of your report. Is that fair?
Yes.
Your Honor, I'm sorry, we're just trying to find the document that council's referencing. I just need a minute to make sure that we have it.
Certainly, and I can help with that. This is the report that resulted in the state's Exhibit E, proposed Exhibit E. I think it's identified with more specificity in the exhibit list. If you need a minute to find it,
Just give us 1 minute, Your Honor.
Sure. Just let us know when you're ready, please.
We're pulling the data, Your Honor.
Your Honor, I'm just going to share the file with them just so they don't have to dig through the data. So if we can have just a moment, just I want to make sure they're seeing what I'm looking at too. And if you can unshare me so I can look through my files. Thank you. I didn't have the luxury of an extra laptop, unfortunately.
Just give us 1 minute, Tom.
And just for clarity of the record, this was produced to us in discovery, but I agree it's from a large amount of data.
Certainly. Ms. Steenson, are you ready to pick back up? Okay, and Mr. Beck, are you ready to have your screen shared again?
Yes, Your Honor, thank you. Can you see that in front of you again? Or let me know when you can see it.
I can see it now.
All right, so we were looking at this. I'm going to scroll down to page 2, and beginning at the bottom of there, there's messages. So this would be extracted from a device and then is output in this report. Is that fair?
Yes.
So I'm going to draw your attention specifically to the bottom of page 5, which I'm going to scroll you there. So in, I think it's conversation or line number 11, do you see that? And I can zoom in.
I do, I see it.
So if the first column says phone, what does that mean?
The device type.
Okay, and that next column, it says Todd, and it has a number ending in 1114. Is that the number you testified earlier that was Mr. Mullis's?
Your Honor, I truly apologize. I'm not sure what page number we're on.
Oh, I said 5.
I just want to show you our next one. Sorry, it's like a very large document.
Page 5, line 11 is where we are. Yes.
Did you locate where we're at, Ms. Thompson, Ms. Steenson? Okay,
Thank you, Your Honor.
okay, Mr. Bakke?
I apologize, I don't recall if you answered, so I'm just going to ask it again. That 1114 number, I believe you testified earlier, that was Mr. Mullis's phone number, is that right?
That was the phone associated, the telephone number associated with his account and the device that he had, yes.
And I'm going to scroll up for just a second so we see what that column is called. And at the top of that page, I can scroll there.
Objection, Your Honor, this was not an exhibit that was presented before trial. In the state's exhibit list, they just had an extraction from an unidentified phone extraction. And so this was not disclosed to us which extraction was being used. And also it was not disclosed, this entire report was not disclosed that they were going to use this as an exhibit.
Your Honor, if I may respond.
Go ahead.
This is a report from their expert who they called as a witness from a message from their client. And we filed the actual message as an exhibit, and they objected to authentication and foundation for that exhibit. So that is why I'm having the witness go the long way through the actual report to confirm it was in his full report before we work with the actual exhibit. And I believe in reference to our exhibit list, we confirmed that it was in a report sent to us from Sean Castle's digital extraction on the physical drive produced by applicant during discovery. And if there had been any question as to what report or where in that data it was, we would have been happy to provide that, but no such clarification was requested.
May I please speak for a moment? I can probably clarify this. They gave us a one-page document. May I please?
Go ahead.
They gave us a one-page document. First of all, it doesn't have the same information as what we provided to them. We have no idea who did that actual extraction. And even more concerning is it doesn't have the same information that's on the report that we gave them. So I think maybe if we confer for a second, we can maybe figure it out or approach, but we've never seen what they're reading before.
Your Honor, I think I can simply have the witness lay foundation of how reports are generated in Celebrite from a Celebrite reader file, and he can explain to counsel how those are generated and printed, or we can substitute it with the full report if they want the entire thing that they produced and gave to us.
I can give you a couple of minutes to visit if you think that will put an end to the objections. Certainly, it would seem to me that the full report could come in if it's something that this witness generated. Now, I don't want dozens more pages of information that maybe isn't relevant or, you know, shouldn't need to be reviewed. If we can whittle it down to one, that would be great. But so again, I don't know what's different on the proposed one page from the full report. I haven't had a chance to compare those. If you think a couple of minutes to confer would be useful, I would suggest that we do that. Why don't I go off the record for a few minutes? Let me know when you're ready. The court will recess while you do that. Give everybody a chance to stretch their legs. Mr. Castle, you may step down.
Your Honor, may. So this is not complete. The state's, first of all, can you hear me? We'd like to read in just the full content of that message that the state just read into the record, or the full message in response to it, so if I may do that. Or we'd like to offer again the text message between Todd and Mullis that give the full content of that message, because this is just a snippet of the extraction, not the full extraction. So we would provide the full context of what that message is about, not.
Your Honor, I apologize, but I'm confused. I believe the exhibit I read from is already in evidence. Is counsel intending to read from a different portion that's already in evidence? I'm unclear.
I guess I'm not sure. Are you planning on reading from 307?
Let's see.
307.
And I guess for just clarity of the record, briefly, I wasn't intending to testify when I read that message in. It was only because it was obstructed from an exhibit number, and the e-filing stamp was the only reason I read it that way.
Well, and is the reading attached to a question for this witness or not? Sure. I mean, is it being read because there's a question that goes with the reading, or?
I think our argument is that we just want to have the real completeness, that the whole text conversation is considered as a whole instead of just that one isolated text message. And so,
well, okay. And so that's my job in reading the exhibit, which I will do. You know, we've put this witness through a lot of hours of testimony. And so I think right now we need to focus on what questions we have for this witness. And so he doesn't need to read that whole exhibit unless there is a question for him.
Yes, Your Honor.
Okay.
May I resume?
Yes.
Based on your review of the digital forensic data, were you able to determine that multiple devices were logged into Todd Mullis 76 Google account?
Yes.
And so would this indicate that the Google search history presented at trial could be from multiple devices?
Yes.
One moment, Your Honor, sorry. You can take down the exhibit. Your Honor, I just wanted to clarify for the record, we will at a later time renew our motion about the DVR records, extraction records. However, we will not use Mr. Castle's time any longer. So no further questions on behalf of the applicant.
All right. Any recross?
Nothing additional, thank you.
Okay. Thank you, Mr. Castle. You may step down.
Thank you.
Further evidence on behalf of the applicant?
Yes, Your Honor, we will call Mr. Meyer.
Sure. Good afternoon, Mr. Firehelm. Good afternoon. You've been called as a witness. Do you swear the testimony you're about to give will be true and correct?
I do.
Go ahead. Take your time. Have a seat there. Feel free to adjust the chair and the microphone so you can sit comfortably. Ms. Nichols-Cook, whenever you're ready.
Good afternoon.
Good afternoon.
Could you please state your name for the record and spell your last name for the court reporter?
It's Gerald Burton Firehelm, Feuerhelm.
And do you also go by Jake?
Yes, prefer that.
Have you previously been deposed regarding your representation of Todd Mullis?
Yes,
And did you previously sign an affidavit regarding this case?
yes,
Are you an attorney?
I am.
Have you always practiced in Iowa?
Yes.
What area of law do you generally practice in?
Almost exclusively criminal defense.
In general, how many years have you been practicing?
46, 45 and a half.
Has the type of evidence in a criminal case changed in any way between the time you started practicing in criminal law till today?
Yes, lots of technology.
And are you employed by a firm or do you have your own firm? Where do you work?
I'm a PC, but I'm the solo attorney.
Okay. Have you ever had a legal assistant or support staff person work with you?
Yes.
When you represented Todd Mullis in 2018 and 2019, did you have an assistant?
Yes.
What was her name?
Christy Klein, Klyn.
What types of things would Christy do for you?
Everything from answering the phone, scheduling appointments, accumulating and organizing discovery materials. Pretty broad section of what she did.
Over your decades of experience in the criminal law area, have you represented individuals charged with Class A felonies?
Yes.
Do you know approximately how many of them went to trial?
8 or 10.
In your experience, have you ever consulted with an expert witness for the purposes of representation of a person charged with a Class A felony?
Yes.
Have you consulted with an expert about determining cause of death?
Yes.
Have you consulted with an expert regarding digital forensic evidence such as cell phone extractions or cell tower data?
Both.
How often have you used an investigator on a Class A felony?
I would say about half of the cases.
Do you belong to any bar associations?
Iowa State Bar Association, Iowa Association for Justice, and the National Association of Criminal Defense Lawyers.
And are you aware of the American Bar Association?
Yes.
Are you aware that the American Bar Association has issued a defense function standard?
Yeah. Yes.
Would you agree with me that the prevailing standards for defense attorneys recommend that you continue to reevaluate your need for investigation or experts?
That sounds correct, yes.
I want to turn now to your involvement with Mr. Mullis.
Okay.
How did you come to meet Todd Mullis?
An attorney in Dubuque, I believe, his name is Joey Hoover, who practiced in Polk County, and I knew him from there. I don't know how he knew Mr. Mullis or was connected to him, but as I understand it, Joey had contacted a friend of mine, Roger Owens, who I've tried Class A's with on several occasions, and wanted to know if Roger would be interested in getting involved in Mr. Mullis's case. Roger contacted me and said he didn't want to take a case so far out of Des Moines. Thank you. And encouraged me to call Joey about it, and that's how it came to be.
Thank you. At the time that you learned about Mr. Mullis's criminal case, do you recall if he had been arrested or not?
I believe he had.
Did you meet with Mr. Mullis and enter into an engagement letter or anything like that?
I think the first thing I did is I made arrangements with his sister and brother to go out to the farm and have them show me the location of the incident. And I talked to Lynn about whether or not they wanted to retain me. I had not yet met with Todd.
Do you know Lynn's last name?
I'm not sure.
If I told you it was Lynn White,
Yeah.
would you?
That was going to be my guess.
Okay. Was there another attorney that you worked with on Mr. Mullis's criminal case?
Bob Sabers from Dubuque.
Had you ever worked on a case with Mr. Sabers before?
I never met him.
Never even met him.
No.
How did you communicate with Mr. Sabers as co-counsel?
Probably equally phones and emails.
Do you know how often you talked to Todd Mullis while his criminal case was pending?
I really couldn't even guess.
Do you know if Mr. Mullis would call you from jail?
I believe he did.
And was your office set up to accept those types of calls?
Yes.
Do you know if Mr. Mullis sent you letters or wrote notes to you?
Letters mostly.
And I think you mentioned earlier that one reason you'd gotten the referral was because it wasn't that close to where your office was, or it wasn't that close to Des Moines.
Well, Roger Owens didn't want to get involved because this location he didn't want to travel that far to represent somebody, and I was willing to do that.
Do you recall what county Mr. Mullis was being held in?
Independence, I believe. I think that's Buchanan, maybe.
Did you have a regular practice or policy of how you communicated with your clients that were incarcerated?
I prefer meeting them in person, and the jail over in Independence accommodated that, and those phone calls.
Did you speak to Mr. Mullis once a week or once every 2 weeks? Did you have any sort of regular schedule?
I don't think we had really a schedule. I think it would be like if something came up on my end, I would set up a phone call, or if he sent me a letter that had some request or a question in it, I'd respond to that either by a visit or a phone call.
Do you recall ever writing Mr. Mullis letters and sending them to the jail?
I don't think so.
Was it your practice in this case to take internal notes about visits or phone calls with your client?
I'm sure I did, on maybe not every time, but yes, I did.
And did you provide your file to subsequent counsel?
Yes, I did. I just gave everything I had to Aaron Hamrock and Tim McCarthy.
I think you have seen some of these letters in your deposition, but just so that we're all on the same page, I'm going to ask that we display Exhibit 233. Are they showing?
No.
Okay. And we can scroll for you when you're ready. I think that one has several pages. I don't want to rush you, but do those documents appear to be letters from Todd Mullis to you?
I believe they are, yes.
Do you recall reviewing these letters during your representation of Mr. Mullis before his trial?
Yes.
And am I understanding correctly that your response to any questions Mr. Mullis had would have only been relayed to him in person during a visit or a phone call?
I believe so.
I want to just look at the very bottom of page 1 of 233, the last paragraph. That should be the bottom of page 1. Do you see a paragraph at the bottom of page 1?
Is there any expert? It starts out.
Yes.
Yes.
Do you recall Mr. Mullis asking you about an expert to be used in his defense?
Well, that is posed as a question there.
Okay.
Yes.
And at this time, what was Mr. Mullis's position as to how his wife had died.
He believed it was an accident.
And could this paragraph in this letter be him asking you to get an expert to show it was an accident?
Your Honor, I'm going to object on a couple things. This is one of the exhibits specifically that we had objected to: authenticity, accuracy, identity, or foundation. The letter's undated. It specifically has no identifying information as to the date, time, or otherwise. And also it's hearsay because Mr. Mullis' statements are not statements of a party opponent and therefore being offered directly to in violation of Rule 5, 802, and 3.
If there are objections to the exhibit, it should probably be admitted before it's specifically referred to. Would you like to respond to the objections?
Sure. Thank you, Your Honor. We've laid some foundation that Mr. Firehelm received letters from Mr. Mullis from jail. He identified these as being letters that he remembers receiving. I could ask Mr. Firehelm the dates of his representation. I do think the record reflects when Mr. Mullis was arrested and when he went to trial. And I guess I don't see how 802 and 803 would prevent a request from a client to his attorney when that is the claim on post-conviction of ineffective assistance to counsel that we have the burden to show. And I have to elicit evidence about what Mr. Firehelm did or didn't do.
I assume these are being offered to show the effect or lack of effect, perhaps, on the reader or recipient. 233 is admitted.
Thank you, Your Honor. Mr. Firehelm, did you understand Mr. Mullis to be asking you to hire or retain an expert to determine if you could put on evidence that Ms. Mullis died in an accident?
I don't know if excuse me, I don't know if I'd characterize it as a request. It reminds me, that paragraph, of a number of times when, to me, it was like Todd was kind of like shotgunning or spitballing ideas of what about this, what about that, and so forth. So I don't know if I would say that that was a specific request, more of a what about this, or how would this be something to think about or talk about?
Did you contact any experts regarding the manner of Amy Mullis's death?
No.
Did you review any literature or do any investigation into an accidental manner of death?
I reviewed discovery material, which included the manner of death, to allow me to assess whether or not it was an accident or homicide.
And outside of the discovery materials provided to you by the Attorney General's office, did you do anything else?
No other materials or individuals, no.
We can scroll to page 2. In the middle of the page, there's a sentence that refers to looking at the clothing.
Yes.
Is this a request for you or a question for you about examining Amy's clothing that she was wearing when she was injured?
I guess my answer would be similar. I don't know if it's a request or just an idea.
Okay. Did you ever go look at the physical items of clothing that Amy was wearing on November 10th?
I did not. I don't know if Bob did or not.
Okay. I would never ask you to tell me what Bob said.
Okay.
What did you understand that there were 3 items of clothing that the state medical examiner had looked at during her autopsy?
I think that's right.
If you go down a little farther on the bottom of page 2, there's a reference about iPads and Amy using the iPad. Do you see that?
Yeah. Yes.
Where, I'm sorry?
It's kind of around the highlight and the very it's not a paragraph, but towards the very end of the letter. Amy used that iPad.
Is this page 5 of the exhibit? Got it. Thank you.
Do you see the portion I'm referencing, Mr. Firehome?
Yes.
I apologize. I am definitely fighting off a cold. Mr. Firehome, was the iPad a piece of evidence at Mr. Mullis's trial, or the data from the iPad?
I think the data was.
And what did you do when your client brought up the issue of the iPad and who used it to investigate that?
Well, here where he was mentioning multiple people using the iPad. I believe that's something that Bob and I either talked about or traded emails about. I think I saw one where Christy maybe responded to one of Bob's questions about that.
Did you interview any witnesses about who had access to the Mullis family iPad?
Just Mr. Mullis, I think. Maybe Lynn and I may have talked about that too.
Did you take any steps to learn about the password to the iPad?
I don't recall.
Just one moment here. I think I'm done with 233 and we can take it down. Mr. Firehome, you mentioned you spoke with Todd's sister, Lynn. Do you remember how you communicated with her during your representation of Todd?
I'd say a vast majority was by phone, and there were some emails.
Was she also in communication with Todd while he was incarcerated?
I think she was, yes.
Do you recall her reaching out to you with requests to meet with Todd?
Lynn was good about reaching out to me after she talked to Todd about either him wanting to talk to me or see me, or maybe even a specific thing he wanted looked into or checked on.
I'm going to represent to you that Todd was arrested at the end of February 2019. Do you know what your first task was after you were retained and began representing Mr. Mullis?
I think my trip to the farm to meet with Mike and Lynn was the first thing.
Okay. And then did you file any motions or take any action in court?
From the get-go, there was a lot of effort put into trying to get Todd out of jail with bond review. I spoke with bail bond company in Des Moines that I was familiar with and had worked with. Talked to Todd, Lynn about resources to acquire a bond.
And would that work have been separate from investigating the charges against Mr. Mullis?
Yes.
Do you recall a time where you requested discovery from the state of Iowa?
I don't know the time, but that probably would have been one of the first things that I did.
When discovery came into your office, what was your process?
I would review it, at least scan it. I don't mean scan it like to copy it, but to look at it. And then talk to Christy. And then Christy was great at organizing, setting up tabs, indexing things, that kind of thing. And then I'd go back and go through it after she had that organization completed.
Are you a paper guy? Do you like hard copies?
She called me the tree killer. Yes, I prefer
I'm
paper.
sure she meant that with all the love.
No, I preferred paper.
So did Christy handle compiling discovery that was tendered to you in an electronic format and making it into paper for you?
Yes.
At the time that you went to trial in September of 2019, did you know if the state had withheld any discovery, or did you identify anything that was missing?
I did not identify anything. And I was assuming the state had produced what they were supposed to.
If we can put up exhibits 201, I believe you saw these in your deposition. I'm going to show you 201 and 202. Do you recognize that document?
I believe Angela showed this to me in my deposition, and I don't think I do.
And do you remember testifying in your deposition that you'd never seen it before Todd's criminal trial?
I think that's correct.
And we can scroll through it if you like. It's only 2 pages, but does this purport to be case log notes from the state medical examiner's office?
Yeah, it looks like that.
I believe 201 and 22 are already admitted. Did you learn that the state medical examiner had made comments to DCI that Amy Mullis's manner of death could have been accidental or a fall?
Counsel, I guess, would you like to rephrase your question, or do you take the position that that's an accurate summary of the statement that was made?
I can withdraw the question and ask another one if you like, Your Honor.
Thank you.
Let me just find the spot here. Okay. If we look at the bottom of page 1, there is a paragraph under November 14th, 2018. Do you see that paragraph?
Right now, the witness has page 2 in front of him, so.
Oh, page 1, please.
What date did you say?
It's towards the bottom of the page, November 14th, 2018.
Oh, yeah, I see it.
So if we go down towards the bottom, there's a sentence that begins, Agent Turbot stated.
Yes, I see it.
If you read that, is that new information to you about what DCI was telling the medical examiner?
I think it is, yes.
And is that type of information that you would have wanted to know for your cross-examination of the state medical examiner?
Sure.
Could it have explained where she was getting her information?
Yes, but in other homicide cases that I've been involved in, I've seen this type of exchange between medical examiners and like a lead investigator. But I just don't think I saw this one.
Okay. We can go to 202. And Exhibit 202 has also been admitted. And if you could review that, I'll just ask that we scroll slowly. Mr. Firehelm, do these also appear to be notes about conversations with the state medical examiner?
That's what it looks like.
Okay, and does this, and we can scroll for you if you like that, contain information obtained from the autopsy about injuries?
It appears so.
Does it indicate how long Ms. Mullis would have survived after her injury?
I don't see anything like that on page 2.
It might be page 1 at the very bottom.
Yeah, it says, so hard to tell how long she was alive, at least minutes she was alive, not immediately fatal.
Would you have wanted to have these notes available to you at trial to cross-examine the DCI agent, Mr. Turbot, who provided this information or made these notes?
Yes.
Does it also discuss whether Amy Mullis's injuries could have been from a fall, or if so, why not?
There's indications in there about whether it was accident or intentional.
And Mr. Firehelm, the first time you saw these documents was during your deposition in 2023?
I believe so.
Okay, we can take that one down. Do you remember the name Deputy Keith Rowley?
I don't recognize that.
Have you learned, I'm sorry, let me start over. Do you recall the state filing a motion in limine pretrial to limit the use of a deputy's name who'd had a prior affair with Amy Mullis?
I'm pretty sure I remember that, yes.
Did you ever learn who that deputy was?
I think we knew the name, yes.
Did you ever receive any documents or information that Deputy Rowley was cleared as a suspect from being involved in Amy Mullis's death?
I don't ever remember seeing any documentation.
Do you remember hearing anything in depositions about clearing Deputy Rowley?
There might have been, the only thing I remember specifically about depositions in that issue was how the case was assigned within the sheriff's office for investigation.
Do you recall seeing any patrol logs for any of the sheriff's deputies from Delaware County on the day that Amy died?
I do not.
Do you recall seeing them during your deposition?
The one of my deposition?
Yes.
I don't recall.
Just a moment, I'm going to pull those up for you. I lost the number, so I apologize for the delay. Okay, should be exhibit 323. Okay, 209. I'm sorry. Let me know when you have it. Mr. Firehelm, if you could scroll through 209 a little bit, it's 12 pages. And when you're ready, let me know what you see.
It looks like a log that a deputy would maintain about activities on their shift.
And at trial, I'm sorry, in preparation for trial, would it have been helpful for you to know whether other people were near the Mullis farm November 10th?
It's helpful to have as much information as you can, and that was something that we talked about.
Okay, we can take that one down. Did you hire an investigator to help you investigate or to represent Todd Mullis?
Did not hire one.
Do you remember who Jerry Frazier is?
Yes.
Before trial, did you know or investigate where he was on November 10th, 2018?
Yes.
How did you know that?
From discovery material and his deposition.
Okay, I want to show you Exhibit 212. It should be Frazier cell phone record. Oh, I'm sorry, we don't have 212 for that. 213 and 214. Let me know when you've had a chance to look at 213.
Report.
Have you had a chance to review that?
I don't recall seeing that document.
Okay. Do you recall being asked about cell phone tower records or cell phone records for Jerry Frazier in your 2023 deposition?
I think Angela asked about that.
Do you recall saying that you were surprised to hear testimony about Frazier's location by cell phone tower?
If that's what I said.
Would you like to review your deposition?
Sure, I don't remember that question and answer.
If we could flip 323 and scroll to the bottom of 42.
I'm sorry, that was my cat. I don't know what she did. I guess she decided I didn't need to be on the computer anymore. I don't know. I have to beg her to play with me, let me pet her, all that kind of stuff. But no, when I'm doing something, she has to jump up here and make it stop. It was going so well. And I have no idea where we were.
I really couldn't even guess.
Do you know if Mr. Mullis would call you from jail?
I believe he did.
All right, StreamYard. Turn my camera off again. Are you going to show up on the screen? We're almost done. They just finished for the day like 2 minutes ago. We're almost caught up to the live. And then tomorrow we'll be back caught up. I don't know why StreamYard isn't putting it on the screen. Stupid StreamYard. I also don't know where we're
And was your office set up to accept those types of calls?
Yes.
Do you know if Mr. Mullis sent you letters or wrote notes to you?
Letters mostly.
And I think you mentioned earlier that one reason you'd gotten the referral was because it wasn't that close to where your office was, or wasn't that close to Des Moines.
Well, Roger Owens didn't want to get involved because this location was, he didn't want to travel that far to represent somebody, and I was willing to do that.
Do you recall what county Mr. Mullis was being held in?
Independence, I believe. I think that's Buchanan, maybe.
Is this good? Is this about where we were? I don't remember. I know they were asking about her affairs, but I don't know if we're too far.
Yes, lots of technology.
Oh, wait, we were way past that.
And Exhibit 202 has also been admitted, and it is 2 pages. If you could review that, I'll just ask that we scroll slowly.
It looks like a log that a deputy would maintain about activities on their shift.
And at trial, in preparation for trial, would it have been helpful for you to know whether other people were near the Mullis farm November 10th? Explained where she was getting her information?
Yeah.
Did you take any steps to learn about the password to the iPad?
I don't recall.
I don't know where we were going.
Just one moment here.
Okay. 10 minutes faster.
indicate how long Ms. Mullis would have survived after her injury?
I don't see anything like that on page 2.
I think it might be page 1 at the very bottom.
Yeah, it says, so hard to tell how long she was alive, at least minutes she was alive, not immediately fatal.
Would you have wanted to have these notes available to you at trial to cross-examine the DCI agent, Mr. Turbot, who provided this information or made these notes?
Yes.
Does it also discuss whether Amy Mullis's injuries could have been from a fall, or if so, why not?
There's indications in there about whether it was accident or intentional.
And Mr. Farahome, the first time you saw these documents was during your deposition in 2023?
I believe so.
Okay, we can take that one down. Do you remember the name Deputy Keith Rowley?
I don't recognize that.
Have you learned, I'm sorry, let me start over. Do you recall the state filing a motion in limine pre-trial to limit the use of a deputy's name who'd had a prior affair with Amy Mullis?
I'm pretty sure I remember that, yes.
Did you ever learn who that deputy was?
I think we knew the name, yes.
Did you ever receive any documents or information that Deputy Rowley was cleared as a suspect from being involved in Amy Mullis's death?
I don't ever remember seeing any documentation.
Do you remember hearing anything in depositions about clearing Deputy Rowley?
There might have been, the only thing I remember specifically about depositions in that issue was how the case was assigned within the sheriff's office for investigation.
Do you recall seeing any patrol logs for any of the sheriff's deputies from Delaware County on the day that Amy died?
I do not.
Do you recall seeing them during your deposition?
The one of my deposition?
Yes.
I don't recall.
Just a moment, I'm going to pull those up for you. I lost the number, so I apologize for the delay. Okay, it should be exhibit 323. Starting came in as a demo exhibit. Okay, 209, I'm sorry. Let me know when you have a chance to look at that, Mr. Faraham. Mr. Faraham, if you could scroll through 209 a little bit, it's 12 pages. And when you're ready, let me know what you see.
It looks like a log that a deputy would maintain about activities on their shift.
And at trial, in preparation for trial, would it have been helpful for you to know whether other people were near the Mullis farm November 10th?
It's helpful to have as much information as you can, and that was something that we talked about.
Okay, we can take that one down. Did you hire an investigator to help you investigate or to represent Todd Mullis?
Did not hire one.
Do you remember who Jerry Frazier is?
Yes.
Before trial, did you know or investigate where he was on November 10th, 2018?
Yes.
How did you know that?
From discovery material and his deposition.
I want to show you Exhibit 212. It should be Frazier cell phone record. Okay, this one's oh, I'm sorry, we don't have 212 for that one, just 213 and 214. Let me know when you've had a chance to look at 213.
Yeah, that's the cover page of report.
Have you had a chance to review that?
I don't recall seeing that document.
Okay. Do you recall being asked about cell phone tower records or cell phone records for Jerry Frazier in your 2023 deposition?
I think Angela asked about that.
Do you recall saying that you were surprised to hear testimony about Frazier's location by cell phone tower?
If that's what I said.
Would you like to review your deposition?
Sure, I don't remember that question and answer.
If we could pull up 323 and scroll to the bottom of 42. And if you could review page 42 and 43.
Okay, I do kind of remember this now, yes.
Okay. Do you recall at Mr. Mullis's criminal trial making arguments that Amy could have been killed by Jerry Frazier because of their affair?
I don't remember that specifically, but I could have.
Do you recall your closing argument at the criminal trial?
Not any details, no.
Do you recall whether you argued to the jury that Jerry Frazier was the perpetrator, not Todd?
If that's what the transcript says, I wouldn't obviously deny it.
Okay, let me ask a different question. In your trial, Jerry a suspect.
I would say yes.
And if you look at 42, page 42, line 22, the question asked of you is, okay, but would it be fair to say you were surprised to hear a state witness say they had conducted cell tower analysis and verified Jerry Frazier's location by cell tower analysis? And then at the top of 43, your answer is, I would have to say that would have been a surprise, yeah. Do you recall giving that testimony?
Yes.
Okay. If you had had information that Jerry Frazier was not on the Mullis farm November 10th or near it because of cell phone tower data, would you have still argued that he could have killed Amy?
I think you could because of the relationship that they had.
Did you consider that the state had evidence giving Jerry Frazier an alibi for the time that Amy was hurt?
I don't know.
I want to move on for Mr. Frazier. Do you recall deposing Dr. Kelly Cruz from the state medical examiner's office?
Yes.
Do you recall being asked about reviewing that autopsy report in your 2023 deposition?
I think so.
And what actions did you take after you reviewed that autopsy report to investigate it or to verify the opinions within it?
I don't believe I consulted anybody other than talking to Bob about it that I recall.
Okay. Do you remember testifying in your deposition that it was your personal opinion that you agreed with Dr. Cruz?
I think it did, yes.
And you don't have any forensic pathologist training, is that fair?
No.
Okay. Okay, I want to talk a little bit about the Google searches that were offered at Mr. Mullis's trial. Do you recall that evidence?
Yes.
Do you recall who testified about the Google searches?
I can't remember which state witness did.
If I told you it was law enforcement, would you accept that?
I think I would, yes.
Okay. Did you do any investigation or take any steps to determine if those officers were qualified to testify regarding cell phone data extractions?
They may have mentioned it in their depositions, but I don't recall specifically.
And did you contact your own digital forensic expert to review the data?
No.
Do you remember testifying in your deposition that the Google searches were harmful to Todd?
Yes.
And do you recall if the Google searches were how the state was using those in their case in chief?
Well, I think they were trying to show that some of the searches were rather specific about harming someone, cheating spouses, that kind of thing.
Would you characterize that as motive evidence?
Sure.
If you had evidence that Todd did not conduct those searches, would you have used that at trial?
Yes.
Do you recall Todd writing letters and having discussions with you about those Google searches?
It came up in letters, it came up in meetings at the jail, phone calls. Yes.
Did you present any evidence in Todd's defense that he did not make those searches?
I recall during cross-examination of some state's witness, it would have been law enforcement, that there were some obvious searches that, like looking for a dress or something like that, or jewelry, that kind of thing. So I felt that the point was made that not all those searches were done by Todd.
Did you do any work to determine where Todd was on the day of the most offensive searches? The ones that you referenced earlier about unfaithful women?
I don't think so, no.
Do you recall researching or drafting a motion to limit the admission of those Google searches because they were not close in time to Amy's death?
I don't think so.
Did you consider that if searches were being done in May, where Todd would have been at that time?
I didn't try to make that connection, no.
Did you know that your client, Todd Mullis, was a crop farmer?
Yes.
And as a lifelong Iowan, do you know when planting season usually is?
Yep.
When is that?
Depending on the spring, sometimes it's April into May.
Do you recall discussions with your client about his kids taking a hunter safety course?
Yes.
Did you take any actions to determine what that entailed?
I didn't research. I relied on what Todd told me about it.
If we can show the witness 306, but not published. Mr. File, can you identify the document? Tell me what the name of it is.
It's titled Today's Hunter, Hunter. And down below it says a guide to hunting responsibly and safely.
Do you know what topics a person needs to learn about to get a hunter safety certificate?
No, I don't. I grew up hunting, but I never took a course.
If you had reviewed this guide before trial and it included information about hypothermia and organs of the body or things like that, could you have used that to explain the Google searches the state presented as motive for Todd to kill Amy?
I think that's reasonable, yeah.
And did you understand that Todd was charged with first-degree murder, which included premeditation or planning, right?
Sure.
If I could show you 223. Do you remember discussing with Mr. Sabers about whether you should hire a computer expert? And I'm showing you an email from May of 2019. If you could tell us when you've reviewed it and identify it for me.
It's going kind of fast, but yeah, it looks like an exchange between myself and Bob and Lynn White.
And did you ever consult with a computer expert or digital forensic expert?
I don't think so, no.
Okay. We can take that one down. Do you remember evidence being tendered to you that included text messages between Ms. Mullis and friends of hers?
Yeah, I think so.
Did you interview any of those friends about those messages?
No interviews, no.
Do you recall deposing some of them?
I think we did, yeah.
Did you seek to issue any subpoenas for cell phone records as part of your defense investigation or preparation?
I don't recall doing that, no.
Do you recall filing a motion in limine before trial asking to prohibit witnesses from testifying to hearsay, especially relevant to the friends of Amy and what Amy had told them about Todd?
I think there was a motion, yes.
Do you recall getting a ruling on that before trial?
Yes.
What was that ruling, if you remember?
Not favorable to our request to limit the evidence.
Do you recall discussing this with Bob Sabers?
Yes.
Oh, I'm sorry. Can we show the witness exhibit 219, an email with Mr. Sabers? Do you recall this email exchange?
Not specifically, but I'm not saying I didn't get it.
If the docket reflects that the judge did not issue a ruling on your motion in limine and reserved it for trial, would you disagree?
Without certainty, no, I wouldn't disagree.
Are you familiar with making hearsay objections during a criminal trial?
Yes,
If you made objections, would those be reflected in the trial transcripts?
sure.
Do you remember a statement by a friend of Ms. Mullis's, Terry Stainer, to the effect of, "Look for me in the timber if I go missing"?
I remember that specifically.
Was that one of the statements that you intended to address with your motion in limine?
That and others like it.
Why that statement and others like it?
Well, it indicated Amy's state of mind and her fear that Todd would harm her.
Did you consider those types of hearsay statements to connote a guilty inference that you would have wanted to keep out of the trial?
Yes.
Do you recall if you and Mr. Sabers discussed what your roles were going to be at the trial?
I don't recall a specific discussion, but I think throughout it, I was the lead counsel and he was taking notes and making suggestions and talking to Todd, and that kind of thing.
Do you recall if he passed you notes during the trial?
He did.
I apologize. Excuse me. Do you recall if you read them?
That's difficult to do during a trial. Glance at them, talk about them during the break, that kind of thing.
Did Mr. Sabers handle any witnesses at this trial?
I don't think he did, no.
Do you recall any discussions about who was going to do the opening statement?
I don't think we ever discussed it.
Did you draft an opening statement to review with your client before trial began?
I normally have, I don't know if you call it an outline or notes, but not really a draft word for word. And I don't recall sharing with Todd about the content of the opening statement before we went to trial.
Do you remember what the premise of your opening statement was?
That Amy was murdered, but not by Todd.
What evidence did you plan to present to show that?
The focus was on Tristan and his testimony about the events of that morning, of who was where.
Did you have any other witnesses or evidence that you planned to present?
I think we called a couple witnesses that had contact with Tristan after, that took him home from the hospital after this had occurred.
Did you have an alternate suspect or another person in mind that you were going to suggest was responsible for Amy's death?
No, I think I talked about that with Todd and Bob, that it wasn't our job to find out who did it. It just cast doubt about Todd being responsible.
Did your client, Mr. Mullis, ever agree to your decision to make that statement in your opening statement?
I never asked him if I could, and he never told me I couldn't. I think going clear back to early on in the case, I made it clear that I did not believe this was an accident and that she was murdered.
And that was based on your own personal opinion or evaluation of the autopsy report?
Autopsy report, police reports, life experiences.
And you don't recall writing any letters to Todd explaining that or asking him if he was in agreement?
I'm sure there weren't any letters. Again, we just generally talked about our theme of the trial.
Do you recall that Tristan testified via closed circuit television at this criminal trial?
He did.
Do you recall how old he would have been?
14, I think.
And I think you testified a little bit earlier that part of your plan was to focus on Tristan, right?
Yes, significantly.
Did you consider Tristan to be Todd's alibi?
Yes.
Do you recall there being an issue between Tristan's pretrial deposition and his trial testimony?
Yes.
Did you do any investigation or take any steps to learn more about the slight change in Tristan's testimony?
If I'm recalling the events accurately, Tristan testified in a deposition, and he gave testimony about the amount of time he would have been absent from the location in the hog barn where he could see Todd. And he gave a time frame that was relatively short. And then Afterwards, he met with his attorney, and that attorney came back and said that Tristan said he had made a mistake.
And I guess my question is, did you take any action to look into?
Indicated in an email is that I contacted Todd about this development with Tristan and suggested that we needed more time to do that. But Todd was adamant that he did not want to continue the trial. So other than that, Lynn had provided me with some drone photographs of the hog barn and the shed where Amy was found and that kind of thing. So we used those to show the significant distance between the barns. And if Todd did leave Tristan's eye shot, even for the longer time that Tristan said, I think it was 30 seconds, I don't know what, it would have been impossible to leave the far end of the hog barn, go to the shed, do whatever happened there, and then get back before Tristan missed him.
So that covers everything that you did do
Yes.
to corroborate or to investigate Tristan's testimony.
Yes.
Do you recall why you called Mr. Mullis to testify at his trial?
One reason is that so many times when I've talked to jurors after trials, my conclusion was they expect to and want the defendant to testify that they didn't do it, even though you tell them that in voir dire and so forth that they don't have to. And as late as the night before the beginning of the trial, when we met in the Dubuque County Jail, I'm not sure we had decided for sure if Todd was going to testify, but I left that meeting that night with the understanding that we both agreed that he would.
How did you prepare Mr. Mullis to testify?
In those meetings,
Did you ask him questions so he could practice his response?
I don't know if it was questions or answers. We just talked about topics that he would expect to be asked about.
Did you practice any potential cross questions that the prosecutor might ask him?
I don't think so.
Do you remember discussing with Todd that he needed to testify to rebut the Google searches?
I think that is one of the things we talked about, yes.
And was that in part because you didn't have an expert or anybody else to testify about whether Todd made those Google searches?
I don't think that was the reason, no.
Did you cross any other state witnesses about whether Todd Mullis could have done those searches?
There was cross-examination about some of the searches that seemed obvious that Todd would not have done. I can't remember what state witness that would have been.
Did you consider Todd's credibility to the jury after your opening statement?
I take that into account throughout.
Were you concerned that you had told the jury that Todd was wrong when he told investigators Amy died in an accident?
Would you repeat that, please?
Were you concerned about Todd's credibility in front of the jury
Dude, just
when you had
answer
told the
the
jury in opening
questions.
that Todd was wrong when he told investigators Amy fell on the corn rake and it was an accident?
I don't think that comment was undermined his credibility. I think Todd honestly thought that when he said that thing. I just said, as we researched or prepared for trial, that was wrong.
Do you remember the 911 call in this case?
Yes.
Do you remember it stipulating to the foundation or the admission of it at trial?
I think so, yes.
He's aggravating me.
Did you ever take the 911 call to the jail so Todd could listen to it before trial?
I think we had a transcript of it, but I don't ever recall playing the audio for him in jail.
If you have been tendered a transcript, would that have been in the discovery?
Yeah, I think so.
I'm just clarifying, you didn't have a transcript made.
No, I don't think so.
Do you remember the prosecutor playing the 911 call during her cross-examination of Todd Mullis?
Yes.
Do you remember 2 comments towards the end of the call that the prosecutor emphasized?
I do.
Had you ever heard those before?
No.
Were those undisclosed statements made by a criminal defendant?
Objection calls for speculation and a conclusion that's well beyond the actual terms of what he can testify to. The evidence speaks for itself.
Overruled, the witness can answer if he's able.
Could you repeat?
Yeah, I'll rephrase. Are you familiar with rules of evidence that require the disclosure of statements made by a defendant?
Yes.
Before the cross-examination where the prosecutor played that call, had those statements ever been disclosed to you before? Purported statements. So sorry.
Well, the whole 911 call was, we always had that, the whole thing. But the contention that he said certain words, no.
And weren't those phrases highly inflammatory?
Yes,
Did you think Todd made those statements on that call?
I did not.
And you don't recall seeing them in any discovery or anybody telling you about them in a deposition?
No.
Have you made a motion for a mistrial before in a trial?
Yes.
Did you do so in this case?
No.
Just one moment. Do you recall the prosecutor telling you off the record that she was going to ask him about these specific statements?
I'm certain that she did not.
Do you recall taking any investigative steps to determine who would have been present at the time of those alleged or purported statements by Todd?
Why is he acting like this is personal? Like he's stopping and thinking way too long before he answers these questions. Like, dude, this is just a guy trying to get out of prison. You don't have to take it so personally. It's not, it's a last ditch effort to get out of jail. Dude, you did your job. Just answer the damn question.
If I'm remembering correctly, the 911 call ended there on the gravel road when law enforcement first it was law enforcement people showed up. And that's about when supposedly he made these statements that the prosecutor brought up.
If you had notice of these purported statements, could you have investigated or attempted to discredit that cross-examination question?
Yes, I actually took the 911 call after the trial was over and had it enhanced to try to
Good
see if
point.
I heard what supposedly was said.
Did you ever learn how the state came to make that argument?
I was told by the prosecutor.
Did you get your own transcript of the call for post-trial motions or anything?
Because of the change in representation, I wasn't involved in the post-trial motions.
When did your representation end? I should have asked you that.
Between verdict and sentencing.
Between verdict and
So you did not get a transcript of the call before your representation ended, am I right?
doesn't it last?
I think you're right. I'm not sure we ever had a transcript of it.
Your Honor, can I have just a moment to confirm?
And don't they stay on until they get like an appellate attorney to take care of the appeal? Why did he even stay on through sentencing? That's strange. I don't know, maybe it's not. I'm just used to them staying on at least through sentencing.
Nicole, can you you find 294 to show Mr. Firehome? And I'll move on for a moment and come back while you're doing that. I don't think I warned her I was going to do that. Mr. Firehome, during your 2023 deposition, do you remember being asked about a Greeley EMT who had filed a report about her response to the 911 call for Amy's injuries?
Yeah, I kind of recall something about that, yes.
Did you do any investigation or take any steps to determine whether the first responders' actions and or CPR could have caused some of Amy Mullis's injuries?
I vaguely recall whether it was the ER doctor at the hospital or possibly during the medical examiners, but I'm not sure of that. I'm sorry.
Did you talk to any of the Greeley EMS first responders before trial?
No.
Do you recall the Mullis family telling you that Greeley EMS was there and that you could contact them?
I don't recall them telling us that. It was pretty obvious from the reports. They might have.
But did you ever do any follow-up to get the Greeley EMS reports before trial?
Not unless they were in the general discovery.
Did you ever learn that law enforcement was suspicious about how Amy sustained her injuries at the hospital on November 10th?
I honestly can't say when the suspicion began.
Do you recall doing any investigation or interviews with people about that?
Again, and I might be wrong about this, about whether or not that hospital doctor talking to law enforcement, that it may have started then, the actual
But
day.
did you take any steps to learn about potential conflicts of interest or bias in the investigation?
No.
And were you aware that Amy Mullis had worked at the same hospital where she was taken when she was injured?
Yes, I think we did know that.
And were you aware that some of the witnesses the state called to elicit those hearsay statements worked at that hospital as well?
I think we were aware of that, yes.
Are you ready, Nicole? Okay. 294. The record to reflect that we're showing the witness exhibit 294. And if you could take a look at the first page and tell me what it is, and then we are happy to scroll through it for you.
It's still dark.
Still loading. It knows that it's 4 o'clock.
Yeah, I'm not sure when it's connected. I'm not sure if you need to try again.
Can you identify the document for me, Mr. Farrell?
And he still doesn't have it yet.
Oh, I'm sorry.
Sure.
Sure.
And Mr. Baki's computer?
Yes.
All right, let's try that one.
Do you see a transcript of 911 call?
Yes.
What date?
The date of the call,
Yes.
November 10th, 2018.
And does it identify who made the call?
911 call by Todd Mullis.
And if we can start scrolling. Page 15 of the PDF. Could you review that for me, Mr. Farrell?
Yes.
I want to direct you to line 5. Can you read that for me?
Deputy Luke, here, comma, Todd, let me.
Do you know who Deputy Luke is?
No, not specifically.
If I told you that was Delaware County Sheriff Deputy Luke Thompson, who testified at trial, would you disagree?
No.
Objection, we're reading from evidence. We're reading from a transcript, not an evidence that the state would object to its admission and consideration in the first place.
If I could ask 2 more questions and then I'll move to admitting her.
Well, again, if there's an objection to it, we should probably admit it before we get too far in the weeds. I mean, do you think you can get it in through this witness?
Just a moment. Your Honor, it's a certified transcript by a court reporter. I'm not sure what other foundation the state would like to have. Page 17, I think, is where Kimberly Blink does her certificate.
I mean, counsel, any response in that respect?
While we agree that this is a certified transcript of a 911 call that, according to that same certification, is done merely to the best of the court reporter's ability based upon heavy breathing and inaudibility, this is not a transcript from a court proceeding. It constitutes hearsay. This witness hasn't seen it before. And while it's certified, that may go to its authenticity and to its identification, but it certainly doesn't go to its admissibility outright. So the state objects on lack of foundation, objects also on hearsay as it falls under the rule and doesn't meet any criteria or exception. And 403(2)B as prejudicial more than probative, given that the Court of Appeals have already addressed this, and a footnote finding that the jury could listen for themselves and believe or disbelieve the arguments of the prosecutor as presented at trial.
Well, I think that certainly Ms. Nichols-Cook, you can ask your questions about the timing and the presence of the deputy in relation to when these statements were made or not made without the use of the transcript. We can address the possibility of this coming in maybe at a later time. I don't think this is the right witness necessarily to do it if it is going to come in, but why don't you proceed? We do need to end at 4:30 today, and I suspect we're not in a position to do that, so go ahead.
Okay. Thank you, Your Honor. Mr. Fireholm, if you could just read through page 15 and 16 for me.
You could just tell me when to scroll.
Page or line?
Page 15 and page 16.
Oh, okay. It's kind of covered up, but I think this is 15. Line 2. Oh, excuse me.
Just tell me when you want me to scroll since I'll do the technical.
Could you let me see the top?
Sure.
Okay, that's good. Line 2 starts out, she's cold.
And right now, you're just reading to yourself, sir.
Oh, I'm sorry.
He's a lawyer. He should know that he has to read it to himself.
Scroll, please.
I think you might be right.
Have you been able to review page 15 and
Yes,
16?
because
Yes.
Okay. In your review of this transcript of the 911 call, do you see the two Mr. Mullis about on his cross-examination?
I do not see those words.
Thank you. We can take it down. Mr. Firehelm, are you aware that the state misrepresented the source of the Google searches at the criminal trial?
Objection to the categorization of the state's statement and also under Rule 543. Also vague.
Sustained.
Mr. Firehelm, I'll ask a different question. Are you aware that evidence exists that would have rebutted the evidence presented at trial, that Todd Mullis alone made the Google searches that the state presented?
I'm not aware of any technical research or document.
Are you aware of digital forensic experts that could examine the iPad and determine information that could potentially contradict the evidence presented at trial?
Well, that's pretty broad. Yeah, I assume an expert could examine it and give an opinion to that. Whether or not it would confirm it or not, I don't know.
If there was evidence that contradicted the state's presentation about the electronic evidence, would you have used that at trial?
If there was evidence?
Yes.
Yes.
If you were aware of evidence that contradicted the state medical examiner's determination that the manner of death was homicide, would you have presented that at trial?
Yes.
Okay, I think I have one last exhibit to show you. It'll be 245. Mr. Fireholm, do you recognize the document on your screen?
No.
If we can scroll a little bit and let me know if you do recognize the handwriting or content.
I don't know.
Okay. We can take that one down. Do you recall taking any steps to investigate Amy Mullis's medical condition at the time that she was injured on November 10th?
We were aware that she had had a medical procedure a few days prior.
Did you obtain medical records about Ms. Mullis's procedure or medications that she was on?
If it was in the discovery, yes, I don't recall specifically.
Did you do any investigation into whether Ms. Mullis would have been dizzy on November 10th due to her medications?
No research, no, other than what Todd and Tristan said.
And did you issue any subpoenas to get medical records?
I don't believe so.
Did you have any medical records that you did receive in discovery reviewed by an expert?
No.
Do you recall the letter from Mr. Mullis asking you to, or stating that he wanted to get a 3D demonstration of the injury to show that it was a fall?
No, I don't recall that specifically, no.
If we can pull up 233. And we're going to go to page 11. 233. 233. Is it in front of you, Mr. Farrell?
Yes.
Can you read page 11, 12? Do you see any drawings or diagrams in this letter?
It's not very clear, but I can tell that there's something there.
Look at page.
That one, yes.
We can scroll to page 13.
Your Honor, I'm going to object to this exhibit isn't in evidence. It's hearsay. It hasn't been adequately authenticated. I do believe 213 was admitted into evidence and, oh, I'm sorry, 233 was admitted in full at this time. I apologize. I withdraw my objection, Your Honor.
Thank you.
Mr. Farham, have you had a chance to look at page 13?
Yes. Excuse me.
And we can scroll to 14 as well. Do you see additional drawings regarding Amy's injuries in this letter from Mr. Mullis?
I do.
Did you take any steps to investigate the information that Mr. Mullis provided to you?
I don't know what the date of this is.
Do you recall taking any steps at any time to investigate the
No,
information in this letter?
no forensic experts or witnesses or anything, no.
Your Honor, I think this is a good place for me to stop. Unfortunately, I think I still have a few more questions for Mr. Farahone. I don't know if the state would be agreeable to, I think we have potentially an expert in the morning, and Mr. Farahone might not be able to get back up here until tomorrow afternoon.
And maybe we can have some off the record discussion about scheduling briefly. Okay, we'll do that before everybody takes off, but we'll plan on recessing until 9 o'clock in the morning. I have been informed by the clerk of court that they're bringing a crane in tomorrow to move something. So whatever the parking situation was this morning, it's going to be even worse tomorrow, to the extent people want to know that. They may need a couple extra minutes to get here. See you tomorrow at 9. Have a nice night.
Thank you, Your Honor.
Okay, guys, we did it. We caught up. We're caught up to the live. So tomorrow, 10 o'clock for this. And if you're watching the full Spectre trial with me, that will be tomorrow around 8-ish, whenever Court Vibes gets done with OJ. So around 8-ish for that. And I will thank you guys for sticking with me. I know we went late today because I was so focused on getting caught up. So tomorrow we'll be all caught up and we probably won't be this late. So, but thank you so much for sticking with me. And I will see you guys later. Bye. Love y'all. Have a good evening.